The Lord Speaker.
My Lords, the hybrid sitting of the House will now resume. Second reading of the United Kingdom Internal Market Bill. Lord Callanan.
I beg to move that the bill be now read a second time. My Lords, the United Kingdom's internal market has been the bedrock of our shared prosperity for centuries. Since the Act of Union, the UK internal market has been the source of unhindered and open trade across the entire United Kingdom. It has enabled businesses and individuals to thrive and been the source of unhindered and open trade across our country. And it has helped to demonstrate that, as a union, our country is greater than the sum of all our parts. Around 60% of Scottish and Welsh exports are to the rest of the UK, which is around 3 times as much as exports to the whole of the rest of the European Union. About 50% of Northern Ireland's sales are to Great Britain. When we leave the transition period at the end of the year, an unprecedented number of powers will flow from the EU to the devolved nations and to the UK government. As this happens, and as we recover from COVID, we must ensure that our economy is stronger than ever. This bill will guarantee the continued functioning of our internal market to ensure that trade remains unhindered in the UK and that businesses can continue to operate with certainty. Without this bill, a Welsh lamb producer, for whom almost 60% of the market is the rest of the EU, could end up unable to sell their lamb as easily as before. Scotch whisky producers could lose access to supply from English barley farmers, unnecessarily putting at risk Scotland's own whisky industry. This package guarantees a continuation of our centuries-old position that there should be no economic barriers to trading within the United Kingdom. To achieve this, the bill will do the following. Firstly, it will introduce a market access commitment for goods, services and professional qualifications, respectively. This will ensure that the UK can continue to operate as a coherent internal market and maintain the deep integration and strong economic ties that bind the UK together. Secondly, it provides a statutory underpinning for a new Office of the Internal Market within the Competition and Markets Authority. This office will independently monitor the health of the UK internal market and provide technical advice on issues that may impact it, reporting to the devolved legislatures and to this Parliament itself. Thirdly, it introduces provisions to ensure that there is a safety net in domestic law to prevent new checks and controls on goods going from Northern Ireland to Great Britain, in line with the Government's commitment to unfettered access for qualifying Northern Ireland goods. Fourthly, it enables strategic investment in all 4 corners of the United Kingdom, giving the UK Government a power to provide financial assistance for the purposes of economic development, culture, sporting activities and infrastructure, as well as both international and domestic educational and training activities and exchanges. Finally, it reserves to the UK Parliament the exclusive ability to legislate for a UK subsidy control regime once this country ceases to follow EU state aid rules at the end of the transition period. This is to ensure that subsidies don't unduly distort competition within the UK's internal market. Let there be no doubt, this bill is crucial in providing certainty to businesses, and we must give them that certainty. My department and I, along with colleagues across government, spoke to hundreds of businesses and business representative organisations from across the UK to gather views and feedback on our original white paper proposals. Over 270 businesses and organisations responded to a public consultation on the proposals, and overwhelmingly businesses supported our approach. And let me record my thanks for the engagement that we have had from all aspects of business on this. This bill will put in law a market access commitment by enshrining mutual recognition and non-discrimination. Mutual recognition to ensure that goods and services from one part of the UK will be recognised across the country, and non-discrimination to guarantee that there is equal opportunity for companies trading in the UK regardless of where in the country that business is based. The same principles of mutual recognition and non-discrimination will also be applied to services, and will introduce a process for the recognition of professional qualifications across the whole UK internal market. This will allow professionals such as doctors and nurses qualified in one of the UK nations to work in any other part, as members, I'm sure, would expect. Furthermore, the Government is inviting views on the regulatory framework for professional qualifications to ensure that our approach remains world-leading. We have, of course, listened to those in the devolved administrations and business and made some exemptions to respect the divergence that exists between the legal professions in England, Scotland and Wales, for example. The bill will also ensure that Northern Ireland qualifying goods benefit from the market access commitment and receive mutual recognition in the rest of the UK, guaranteeing a continuation of our centuries-old position that there should be no economic barriers to trading within the United Kingdom. My Lords, we consulted on how to ensure that an independent monitoring and advice function should be enabled to uphold the UK internal market. In response, and to oversee the functioning of that internal market, this bill will set up an office for the internal market within the CMA. This office will monitor and report on that internal market to the UK Government, to devolved administrations, to the legislatures and external stakeholders, ensuring the continued smooth operation of that internal market that businesses so desperately desire. My Lords, subsidy control has never been devolved. It is crucial to continue to have a UK-wide approach to protect our internal market and to prevent harmful and distortive practices arising. The purpose of this bill is to ensure that we continue to have fair and open competition across the UK, and so it is right that we have a UK-wide approach to subsidy control. As we take back control of this policy from the EU, the UK will have its own domestic subsidy control regime. From the 1st of January, the Government will follow the World Trade Organization rules for subsidy control and any related commitments the Government has agreed in free trade agreements. We will consult on whether to go further than those existing commitments, including whether legislation is necessary to achieve a system that promotes a competitive and dynamic economy throughout the United Kingdom. We appreciate that our longer-term approach will have implications for business and all public authorities that grant subsidies with taxpayers' money, including the devolved administrations. So we will take the time to listen closely to those voices and design a system that promotes a competitive and dynamic economy throughout the whole of the United Kingdom. However, we will not return to the 1970s approach of bailing out unsustainable companies, be they in Scotland, England, Wales or Northern Ireland. As we leave the EU and take back control of our money, we will require new powers to continue to invest across the United Kingdom. Therefore, this bill will confer a power to make sure that the UK Government can invest UK taxpayers' money nationwide, including on UK Government priorities, supporting people and businesses across the UK, and to deliver on our commitment to level up all parts of our country. Currently, unelected EU bodies spend billions of pounds that we provided as a net contributor on our behalf. They spend our money with very little say from elected politicians in the UK. This will rightly change as we leave the transition period. The UK Government intends to take a much more collaborative approach in delivering programmes that replace EU funds. This includes engaging heavily with local authorities as well as wider public and private sector organisations. And of course, it means working closely with the devolved administrations to make sure that investments complement their existing and continuing powers used to support citizens in Scotland, Wales and Northern Ireland. This power to provide financial assistance will cover infrastructure, economic development, culture and sport, and will also support educational and training activities and exchanges both within the UK and internationally, much of which, of course, was previously done at EU level. These powers are not designed to take powers from the devolved administrations, but to add powers to direct investment in a similar fashion to the EU Commission, whilst reforming programmes and empowering MPs from Wales, Scotland, Northern Ireland and England to design and to scrutinise those funds in a way that was never possible within the EU. This will also allow the UK Government to meet its commitments to replicating and matching EU structural funds within the Shared Prosperity Fund. This is in line with the Government's manifesto commitments to strengthening the Union and to level up the country. This power to provide financial assistance is one of the mechanisms by which the Government hopes to achieve these ambitions. We will also be introducing limited and reasonable steps to provide a safety net to ensure that peace can always be preserved in Northern Ireland. In the event that we do not reach an agreement with the EU on how to implement the Northern Ireland Protocol, we must be able to deliver on promises in our manifesto and in the command paper. This is a legal safety net, which clarifies our position on the Northern Ireland Protocol, protecting our union and ensuring that businesses based in Northern Ireland have true, unfettered access to the rest of the United Kingdom without paperwork. This bill will also provide certainty on state aid, ensuring that there is no legal confusion and that whilst Northern Ireland will remain subject to the EU's state aid regime for the duration of the protocol, Great Britain will not be subject to EU rules in this area. This bill and our wider approach to protecting our internal market is designed for cooperation between the four parts of the United Kingdom. It will protect our common causes, such as the setting of high standards in our economy, and will work in concert with the Common Frameworks Programme and with the IGR, which is due to conclude shortly. After all, the UK has some of the highest standards in the world. And it's worth reminding, noble lords, that we go beyond EU rules in many areas, including health and safety in the workplace, in workers' rights, food, health and animal welfare, consumer protections, household goods, net zero and the environment. And we will maintain that commitment to high standards, including as we negotiate trade agreements that will provide jobs and growth in the UK. We have been driving this forward through our Common Frameworks Programme, to drive collaboration and a coherent approach to policy across the UK now that we have left the European Union. I therefore want to reiterate the Government's invitation for all devolved administrations to work together with us on this bill, with the Common Frameworks process and with the internal market as a whole. My Lords, this bill is crucial to ensuring that we continue to work together as one United Kingdom, support jobs and livelihoods across our entire country. As we rebuild and recover from COVID-19 and look ahead to the opportunities following the end of the transition period, this bill will provide the certainty that businesses need to invest and to create jobs. And it will accompany one of the biggest transfers of power in the history of devolution, with hundreds of powers flowing from the EU to the devolved administrations at the end of the transition period. This bill will do all this and preserve the internal market that has been an engine of growth and prosperity since the Acts of Union. That is why we need this bill, and, my Lords, I beg to move.
The question is that this bill be now read a second time. Amendment, Lord Judge.
My Lords, I beg to move the amendment in my name on the order paper. If I were somebody who believed in compulsion, in particular executive compulsion, I would make an order that every member of the Cabinet should read the report from the Constitution Committee and the report from the Delegated Legislation and Regulatory Reform Committee and understand what it means. What I read in those reports is something we've read time and time again in those reports, and so far, at any rate, nobody's paid much close attention to them. I can sit down, can't I, really? No, perhaps not. My Lords, I don't want to grandstand, but the rule of law is a bulwark against authoritarian incursion. and even the smallest incursion threatens it. And, my lords, when those responsible for making the law, that is us, Parliament, we, the lawmakers, who expect people to obey the laws that we make, knowingly grant power to the executive to break the law, that incursion is not small. The rule of law is not merely undermined, it is subverted. And there's one consequence, and the damage is to our standing in the world. We have no real power now except soft power, the English language, and an understanding that we in this country have a traditional belief in the rule of law, and we respect it. We hope that one day all those countries in the world that do not have respect for the rule of law will have it. And yet here we are, about to tear it into tatters. My lord, our contribution to happier days round the world is going to be diminished. I want to make it clear that I passionately believe in the sovereignty of Parliament. I extol it, I discuss it abroad, I explain the advantages of it over a written constitution, and that includes the flexibility that we now have. And I also accept that Parliament can make any law that it likes. It can criminalise anything that it likes. Let me give you a silly example, but not that far removed from what's been going on through COVID. I happen to support Leicester City Football Club. Parliament could make it an offence to be a supporter of Leicester City Football Club. They could make it an offence for 10 Leicester City Football Club supporters to gather together to support Leicester City Football Club. It can, obviously won't do that, but in theory it can do exactly what it likes. But the rule of law requires properly enacted laws. I accept that. Rule by properly enacted laws is one of the ingredients, but, my lords, it is not definitive. And when the sovereignty of Parliament is tossed against us, fair enough, and it's important, it's crucial, it's our constitution. But can we just remember this? Every country in the world has a law-making body. Think of one that hasn't. And it will produce the laws by which that country is ruled. Of course it will. But some laws, constitutionally properly enacted laws, are the antithesis of the rule of law. My lords, there are so many examples, but here's one that leaps to mind. Apartheid South Africa, where everything about you as a human being and the way you were treated by the law depended on the accident of birth. What was the colour of your skin? And depending on the colour of your skin, your rights were more or less, certainly different. We tend to forget, and we should not forget, that apartheid South Africa's laws, abhorrent laws, were the result of a perfectly clearly understood constitutional enactment. In law, they were utterly justified in making any law they like, just as we are. But somebody tell me that apartheid South Africa, with its properly enacted laws, was a place where the rule of law could be found. It was miles away, the furthest constellation in the stars that you can imagine. So we need to be careful to distinguish between the rule of law and the rule by laws. It's the rule of law that gives us the protection that we need from the abuse or misuse of the constitutional power which is enjoyed by Parliament. My lords, it is our safest shield against authoritarianism. It is a phrase that was conjured up by the Commons for the first time in 1610 to tell an overweening king that he was exercising or seeking to exercise overmuch power. It's a phrase we should use to remind an overweening executive that it is going too far. So, my lords, I know that I am not alone in finding it offensive that we are being asked by a minister in Parliament to seek Parliament's authorisation to allow him to break the law deliberately and knowingly. My lords, saying it's only going to be done in a very specific and limited way is a total obfuscation. A thief who steals only a tin of tuna is still a thief. Over the years, Parliament has heard many strange words. It's heard some very surprising words. It's heard some very inspirational words. It's part of the history of our country. But I have never yet found an occasion, I've tried, and if the Minister can find one, no doubt he'll tell me, where Parliament was invited to agree that a minister should be entitled to break the law. My Lords, we must look on the impact of Part 5 as a totality. It's not just Clause 47 that is pernicious. Can we just go back? We became party to a new agreement with the EU. The agreement provided sensible get-out clauses on both sides, which either side could use. We enacted the Withdrawal Act this year, just before COVID hit us, and the Northern Ireland Protocol was integral to it with its own get-out clauses. And I recognise, if I may say so, the distaste and hostility which some people in Northern Ireland regard what happened then. I would suggest to them this debate is not about the protocol, it's about the rule of law. The Act gave legal effect to the withdrawal agreement and to the protocol, and thus it became domestic legislation implementing an international agreement. Of course, I accept international agreements, treaties occupy a separate star in the firmament, but breaking international law is not different in principle from breaking domestic law. The rule of law is no less an ingredient of the legal relationship between nations as it is domestically. Let us get ourselves rid of the myth, the spin, that when the rule of law internationally is damaged, well, the rule of law domestically is nevertheless quite unscathed. It's absurd. The rule of law is indivisible. And let's disabuse ourselves of a further myth or spin, that actions already taken have not diminished virtually to extinction the assertion by the Minister in the other place that we are a beacon around the world for the rule of law and international law. My Lords, the light given by that beacon is being extinguished. And finally, we must not be beguiled by the recent argument that the legislation would only be used if necessary in an emergency. My Lords, it doesn't cure the fault, does it? My Lords, what is not a myth is that not a shred of evidence has been produced which would justify the use of the get-out clauses. Hence, this proposed legislation. Part 5 provides that a Minister of the Crown shall be vested with power to use secondary legislation, in effect to repeal an Act of Parliament which Parliament has only just enacted, indeed almost before the ink on it was dry, and that is not the way the sovereign Parliament should be treated by the executive. We do not have executive sovereignty. But this is worse than the standard Henry VIII clause. My Lords, to talk about a standard Henry VIII clause is itself a shameful thing to have to do, but we are faced with them in every piece of legislation we have, like the blossom in the spring when the wind blows. And despite the recent arguments by the Lord Chancellor, Part 5 as a whole was obviously intended to prevent any legal challenge to ministerial decree. And the Lord Chancellor himself accepts that such rights will be reduced. My Lords, this is not an attempt to limit the Court's jurisdiction over primary legislation. It is now being extended to secondary legislation. You've heard me before on the subject of the inadequacy of parliamentary control of secondary legislation. But, my Lords, if Parliament will not exercise control, and the courts cannot do it, where then are the controls of the executive? They're vanishing into the air. So now we're being asked to give a Minister of the Crown, on behalf of the executive, the lawful authority, knowingly and deliberately, to repeal recent domestic legislation, to break international treaties, all through secondary legislation over which parliamentary control has crumbled through disuse, and the normal level of scrutiny of secondary legislation by the courts is reduced to a whimper. My Lords, I have nearly done. The rule of law has served us well. It has not made a perfect society, nor could it. But we all know that without it, our society would have been and would still be catastrophically worse. We must defend that bulwark, and I shall, I hope, be supported, because I intend to take this particular issue to a division for the House to give its own opinion about this dangerous legislation. Not in my name.
My Lords, the original question was that the bill be now read a second time, since when an amendment has been moved by Lord Judge at the end to insert the words printed on the order paper. The question I now have to put is that this amendment be agreed to. I call the next speaker, Baroness Hayter of Kentish Town.
My Lords, while thanking the Noble Lord the Minister for opening the debate, we concur totally with the regret expressed by the noble and learned Lord Judge, that I'm going to leave it to my noble and learned friend, Lord Faulkner, to set out our case on this, having allocated some of my speaking time to him. And my noble friend, Lord Stevenson, will cover the state aid and competition parts of the bill, as well as the governance, independence and powers of the OIM. Today, my Lords, will be a notable one for your Lordship's House, given the expertise we will hear, and we look forward to the maiden speeches of my noble friend, Baroness Hayman of Alloch, and of the noble Lord Shaftesbury, as well as those of my noble friend, Baroness Andrews, Chair of the Common Frameworks Committee, of my noble friend, Baroness Taylor, and the noble Earl Kinnoul, who chairs respectively of our Constitution and EU committees, who reports the noble Lord Judge has already referred to, and of course to the Most Reverend Primate, the Archbishop of Canterbury, who, together with the church leaders across the four nations, writes in today's FT of the grave responsibility of peers because the bill will profoundly affect the future of our countries and the relationships between them. It's hard to understand how a bill, long expected as a result of our exit from the EU, that the government in it has got so much wrong. Perhaps it's symptomatic of its genetic inability to work with those whose interests are affected by legislation. Hence, it undermined the protocol without a word to Irish politicians, its willingness to break international law and renounce the treatment, with ne'er a word to the judiciary or to the co-signatories, which led the EU to take legal action via a letter of formal notice for breaching the good faith terms of the withdrawal agreement. And despite claims to strengthen the integrity of the Union whilst upholding the devolution settlements, the bill actually risks destabilising an integral part of the UK's constitutional significance, in the words of our Constitutional Committee. Jeremy Miles, the relevant Welsh Minister, in a letter to the Lord Speaker, describes the bill as an unprecedented attack on the devolution settlement, undermining the Senate's right to regulate in devolved areas of competence and explicitly amending the Government of Wales Act. Unsurprisingly, the Senate's legislative consent memorandum concludes that unless the bill is substantially amended, the Welsh Government would not be able to recommend consent. A similar reaction led the Scottish Parliament to vote by 90 to 28 against granting legislative consent, its government stating that we could never recommend consent because it threatens devolution and breaches international law. And it looks as if that response has led to a third of Scottish voters being more likely to back independence. Now, there has been a real issue to resolve, because when we entered the EU in 1973, there was no devolution. But we thought we had achieved a solution with the common frameworks in the Withdrawal Act. Within the EU, of course, common standards, mutual recognition, labelling, testing, professional recognition, or whatever, was decided by consensus across the 28, and with MEPs from our 4 nations signing off the various measures. Our exit repatriated powers to the UK, but included in those were powers in some devolved competences. So how did the government react? Did it set up a mechanism akin to EU co-determination, designed along with the devolves? Did it build on the common framework efforts already in play? Oh, no. It took to itself in this bill significant repatriated powers, annulling elements of the devolved settlement, to replace a system that had evolved slowly and by careful negotiations over decades by government edict. It published its plans with statements from Messrs Gove, Sharma and Jack, along with a Scottish businessman and the Scottish Retail Consortium, but no word from the Welsh Secretary of State and no involvement of devolved governments. It sweeps state aid to itself and gives a role to the CMA, which is unrepresentative of the devolved nations. The bill grafts UK ministers powers on mutual recognition without any input from devolved administrations. So if England, for example, imports chlorine-washed chicken, consumers in Aberdeen and Aberystwyth could find it on their supermarket shelves without any say by their elected governments. Similarly, the bill's lack of a public health exclusion from market access principles makes it difficult for all parts of the UK to implement policies to reduce harms from alcohol and tobacco, for example, or to tackle environmental harms. Meanwhile, our Delegated Powers Committee describes the bill as a constitutional power grab, apparently horrified by its, and I quote, extraordinary, unprecedented powers, which allow ministers to amend or repeal parts of this bill, or indeed any act of Parliament or statutory instrument. We do not concur with the government's assertion that the bill is not constitutional but economic. Rather, we agree with the archbishops that the effect on devolved policy making is of constitutional significance. The Delegated Powers Committee calls on us to ensure major decisions are taken by primary, not secondary legislation, noting that many of the bill's reliance on statutory instruments actually have no relation to any issue of urgency. Turning to the CMA, its present structure is inadequate, not simply by failing to represent all 4 nations, but by lacking a clear duty to place consumers at the heart of its work. It's notable that nowhere in the Minister's letters of the 1st of October to your Lordships does the word consumer even appear. You have to get to clause 32 of the bill before you find a welcome mention of the impact on prices, the quality of goods and services, or choice for consumers. But, my lords, consumer competition is not an end in itself, but it is to serve consumers, to prevent rip-offs, and to promote fair trading and growth. Intervention exists to get a market working for consumers, so that objective must be hardwired into the CMA's DNA. The Noble Lord Tyree, as chair, produced an excellent suite of suggestions to make the CMA consumer-focused and fleet of foot. We will seek to write these into this bill, as well as to reflect all 4 nations. My lords, in this bill, the Prime Minister has managed to anger lawyers, devolved authorities, the EU, the churches, its own bank benches, and the majority of your lordships. He's really like a bathroom brawler, is he not, taking on all comers. Is it possible that they are right and that he is wrong? Perhaps it's worth reminding Mr. Johnson of the oft-quoted words of Barack Obama that Barack Obama left in the Oval Office to President Trump. We are just temporary occupants of this office. That makes us guardians of our democratic institutions and traditions like the rule of law. It is up to us to leave those instruments of our democracy at least as strong as we found them. My Lords, something is needed to replace the EU's competition-based open market, such that consumers do not lose out, so that public health, the environment and food standards are protected, and that the Union is strengthened. But it's not this bill. This must be amended to be workable, legal, democratic and respectful of the devolved settlements. For that reason, we share the regret expressed by the noble and learned Lord Judge, and in his motion by the noble Lord Cormac, that this bill undermines the rule of law and reneges on a treaty, reducing our standing on the world stage. Regrettable indeed, and completely avoidable.
Yeah. Lord Newby.
My Lords, this bill is on a number of grounds the most dangerous and baffling piece of legislation to come before your Lordship's House in the 23 years since I became a member. It's dangerous because for the first time in that period, a British government is explicitly legislating to break its word in a treaty recently entered into and in breach of international law. But it's baffling because none of its other provisions are necessary at all to meet its ostensible policy goals. Take the dangerous part first. The provisions in clauses 44, 45 and 47 that the government can override the provisions of the Northern Ireland Protocol which could impede unfettered access to Great Britain markets of Northern Ireland goods. Let's pass over the provision in Article 43.2, which allow a whole raft of new checks, controls and administrative procedures on such trade, which the government now accepts as necessary, and which, in doing so, makes a mockery of the whole concept of unfettered access in the first place. But on the offensive provisions themselves, let's be clear on three questions. First, do they indeed breach international law? Second, in these particular circumstances, is such a breach justified? And third, if not, what should now be done? My Lords, on the first question, the answer is clear. The government itself has accepted that the provisions breach international law in a limited and specific way. And to use a slightly different example from the noble Lord Judge, just as if I go into a shop and steal a specific and limited number of Rolex watches, I've still committed a theft. Government amendments to the bill in the Commons would require Parliament to vote before any provisions could be introduced under the offending clauses. But as the Bingham Centre for the Rule of Law puts it, such a vote, and I quote, does not alter the fact that Parliament is still being asked by the government to legislate in deliberate breach of its treaty obligations. So the provisions, without doubt, break the law. But are they still justified, as the government contends? It's argued that they are on a number of grounds. They produce the lamentable excuse that because it signed the withdrawal agreement in a rush, it didn't realise what it meant. They've resorted to scaremongering, that the EU was planning to impose a blockade, the word they use, on agricultural goods moving across the Irish Sea, a suggestion which the Irish Foreign Minister has described as, and I quote, totally bogus. And they've argued that the UK government has broken international law on numerous occasions in the past in order to justify doing it again. But the briefing to your Lordship's House by the Law Society and the Bar Council knocks that argument on the head when it states, and I quote, "We are unaware of a precedent for such an approach in UK legislation or administrative process." End quote. The truth is that there isn't a shred of justification for breaking international law as is provided for in this bill, and its effect will simply be to diminish our international reputation as an honest partner and an advocate for the universal application of the rule of law. So, my Lords, what should your Lordship's House do? We must ensure that the law-breaking clauses do not enter the statute book. My Lord, personally, I've got considerable sympathy with those who've argued that we should vote against the bill today at second reading, because that's the cleanest way of getting rid of the offending clauses, and because, for reasons which I'll explain, I don't believe the remainder of the bill is necessary at all. But I understand that this isn't the view of others across the House, and so we'll work with them to excise the specific offending clauses when we get to them. My only plea, though, my lords, is that when it comes to ping-pong, the many noble lords who over the next few hours will be expressing their abhorrence of what the bill contains will be willing to gird up their loins for the repeated ping-pong which will surely be necessary if our common views are eventually to prevail. My lords, if the Northern Ireland Protocol clauses are dangerous, the remainder of the bill succeeds in being completely unnecessary, while at the same time undermining some of the basic principles of the devolution settlement. Veterans of the EU withdrawal bill will remember grappling with how to manage the repatriation of measures which underpin the single market, which should be retained at UK level, which should be devolved, and which should be jointly determined. With the help of the noble Lord Mackay of Clashfern, we arrived at a system of common frameworks, which between them would deal with all aspects of the single market, all aspects of the single market. There are some 40 of them, and they have either been fully negotiated or are in the process of being negotiated. When finalised, they'll render the ostensible purpose of the bill to ensure the smooth operation of the UK's internal market completely unnecessary. But the bill doesn't simply provide overarching UK-wide market access provisions. It takes away power from the devolved administrations and reserves it to London at the same time. There are several ways in which it does so. It will undermine the devolved institution's right to regulate in devolved areas of competence. It gives wholly new powers to UK ministers to spend public money on devolved issues in Scotland, Wales and Northern Ireland without necessarily involving them in deciding on the priorities. And it seeks to amend the state aid legislation so that the UK government could impose a new state aid regime without the agreement of the devolved administrations. Over the course of the debates, my lords, my noble friend and other noble lords will set out in detail why this legislation is so very damaging to the devolution settlement. But to seek to undermine devolution in these ways, under the innocuous cloak of maintaining market access for goods and services across the UK, isn't simply disingenuous. It's dangerous because it can only give succour to those who want to break up the United Kingdom as a whole. My lords, amendments will be laid on a cross-party basis at committee stage, supported by the Welsh and Scottish governments, which will seek to reverse the worst aspects of what the government's proposing in respect of the devolution settlement, and I hope that they'll be supported across the House. My lords, as we face the ravages of COVID and the impending costs and disruptions of Brexit, to have to spend, as we now are, weeks of legislative time trying to stop the government breaking international law and undermining the devolution settlement is both depressing and infuriating. But if this House of Lords has any purpose, it's to protect the rule of law and the Constitution, and it's up to us now to rise to that challenge.
The Lord Archbishop of Canterbury.
My Lords, I look forward to hearing here and online the contributions to come, especially the maiden speeches of Baroness Hayman of Alloch and Lord Shaffraz. I also concur totally with the powerful and remarkable speech by the noble and learned Lord Judge. What we are above all called to do in this country, deeply embedded in our Christian culture and history, is to act justly and honestly. We cannot do so if we openly speak of breaking a treaty under international law, reached at properly, on which peace in part of the UK relies. My distinguished former colleague Sentamu, who paid with beatings for his defence of law and justice in Uganda, would have spoken trenchantly. I regret his absence. There are some who claim that I and my colleagues who wrote in the FT this morning are misinformed. But the letter and this intervention follow the lead of those who have spent their lives seeking peace in Ireland. Peace is surely something of which religious leaders should speak. We also listened to the Select Committee on the Constitution, to all 5 living former Prime Ministers, 2 former Conservative leaders, and distinguished judges, including former Presidents of the Supreme Court and a former Lord Chief Justice of England and Wales, to name but a few. This country has different characteristics and needs in its regions and nations. They must be reflected in all our relationships if the Union is to survive. There is no watertight door in relationships between economics and constitutional issues. They overflow from one into the other. The timing of anything that the UK Parliament or government does in Northern Ireland is always especially significant to relationships. It is particularly so at present. The revived Assembly is scarcely a year old. 2021 is the centenary of the establishment of Stormont and the creation of the border. Much progress has been made since the 1990s in building confidence and peace. Yet it is clear from many visits in the last few years, and clear to anyone who listens, that the tensions continue. Peace and reconciliation need continual reinforcement and continual progress. I will therefore be seeking to work with others for amendments which ensure that the process of peace and reconciliation is pursued and that powers exercised under this bill, when it becomes law, involve consultation amidst the immense complexities of Northern Ireland. I hope we may act on a cross-party basis. Politics, if it is to draw out the best of us, must be more than just the exercise of binaries, of raw majority power unleashed. It exists to seek truth, to bring diverse peoples together in healthy relationships. Our reputation as a nation, our profoundly good and powerful influence and example, which I know from experience around the world, will suffer great harm if law-breaking is pursued, greater harm than this bill seeks to prevent. In the Church of England, my lords, we are all too clearly aware of the shame that comes with failing morally. Let us not make the same mistake at national level. This House exists to amend and improve legislation, not to derail it, and that must be our urgent aim now.
My Lords, it's a great pleasure to follow the Most Reverend Primate, and can I also congratulate him and his Most Reverend colleagues on their very welcome letter today, with which I too wholeheartedly agree. The European Union Committee published our report on the Internal Market Bill last Friday. It was the 74th Brexit-related report that we have made since the referendum in 2016. It was unanimous, as all the previous reports have been. And once again, I pay tribute to the outstanding committee staff, working all hours as they do, and to such a very high standard over such a long period. The report is short. It deals only with Part 5 of the bill and its interaction with the government's implementation of the withdrawal agreement. It was designed to fit together with the excellent report of the Constitution Committee and their wider analysis of the rule of law issues. I have said before in this chamber that there is an inherent tension at the heart of the Ireland-Northern Ireland Protocol, essentially in marrying up the aspirations of the recitals with the hard legal text of the articles that follow it. The committee reported in June that there was not enough urgency among the parties in the negotiations, which in a pragmatic way need to seek the compromises to sort this out. So protecting first and most importantly the Belfast Good Friday Agreement, and secondly the two mighty single markets involved, those of the EU and the UK. That report also dwelt on the multi-layered dispute resolution mechanisms contained within the withdrawal agreement. The bill before us supplants those mechanisms without their ever having been tried out. And we've heard already of the Secretary of State's clear and repeated statement that in doing so the bill breaches international law. The result, as we report, strikes at the heart of the withdrawal agreement and hence poses a threat to the maintenance of the Belfast Good Friday Agreement itself. It is corrosive, too, to the future relationship discussions, as trust has become a casualty of the arrival of Part 5 of the bill. We wrote to the Chancellor of the Duchy of Lancaster on the 18th of September with 9 questions on the situation. To date, we have no response to that letter, and the letter is set out as Appendix 2 of our report. I very much hope the Noble Lord the Minister will cover carefully these 9 questions in his response tomorrow. In the absence of convincing answers to these 9 questions, the committee recommends removing Part 5 of the bill. In closing, I note that the amendment proposed by the Noble and Learned Lord Judge is entirely in keeping with our report. I therefore strongly support it, and for once, and after advice, can follow him into the virtual voting lobby when he divides the House.
Lord Howard of Limerick.
My Lords, it's a pleasure to follow the Noble Earl, and I congratulate him on his and his committee's report. Like the Noble Lord Judge, with whose every word I agree, I entirely accept that the Sovereign Parliament of the United Kingdom has the power to legislate in breach of international law. That is not the issue which this bill presents. The question is not whether we can so legislate. The question is whether we should so legislate. I don't often quote the President of the European Commission. But then the President of the European Commission doesn't often quote Margaret Thatcher. And what Mrs. Thatcher said was this: Britain does not break treaties. It would be bad for Britain, bad for relations with the rest of the world, and bad for any future treaty on trade. My Lords, that says it all. I was surprised, nay, astonished, by the fact that my noble friend the Minister, in his opening remarks, did not deal with, or even, unless my hearing has totally failed me, even mention the fact that Part 5 of the bill is in breach of international law.
He's gone off to read it.
The admission by the Secretary of State for Northern Ireland in another place that it would be in breach, that it is in breach, was not, as was suggested by one of my noble friends in the recent debate in Grand Committee, merely a clumsy form of words. Those words were read from a brief. They were prepared. They were premeditated. They were deliberate. They represented the government's clear intention. And as far as I'm aware, the government has not sought to resile from them. It was argued that, suggested that the dispute resolution provisions in the withdrawal agreement would be activated in parallel with the activation of the provisions in the bill. But I draw your Lordship's attention to Article 168 of the withdrawal agreement, a short article. I should read it in full. For any dispute between the Union and the United Kingdom arising under this agreement, the Union and the United Kingdom shall only have recourse to the procedures provided for in this agreement. Now, the government may have second thoughts about that article. They may regret that they signed up to it, but it's too late. They did sign up to it. They are bound by it, and they should honour it. My Lords, together with the majority of those who voted in the 2016 referendum, I voted for Brexit. I do not for one moment regret or resile from that vote. I want the United Kingdom to be an independent sovereign state. But I want it to be an independent sovereign state that holds its head up high in the world, that keeps its word, that upholds the rule of law, that honours its treaty obligations. I want it to be an independent sovereign state that is a beacon unto the nations. I do not want it to be an independent sovereign state that chooses as one of the first assertions of that sovereignty to break its word, to break the law, and to renege on a treaty that it signed barely a year ago. So I shall vote for the amendment in the name of the noble Lord Judge, and if it is put to a vote, the amendment in the name of my noble friend Lord Cormac, and I shall vote against the clauses in Part 5 of the bill, which are in breach of international law, and I urge your lordships to do likewise.
Lord Falconer of Thoroton.
It is a real pleasure to follow the noble Lord Howard of Limp, and it is a real pleasure to have heard the speech of my noble and learned friend, Lord Judge. Two incredibly powerful speeches, and I agree with every single word of them except the bit where Lord Howard of Limp said he'd voted for Brexit, but I didn't. I very much look forward to hearing the maiden speeches of the Baroness Hayman of Ulloch and Lord Chafras, which I know will be incredibly good. My noble friend, the Baroness Hayter, has given me 5 minutes of her speech, and it's been agreed with the usual channels that I may exceed the advisory limit a short bit because I'm speaking from the front bench. My Lords, the Northern Ireland Protocol ensures an open border in Ireland to preserve the Good Friday Agreement. It does this by creating a regime legally binding on the United Kingdom, both as a matter of domestic law and international law, that goods in or entering Northern Ireland will be compliant with single market rules. On that basis, the border remains open and the integrity of the single market is protected. The protocol also provides that Northern Ireland remains within the customs territory of the United Kingdom and there is unfettered access to goods between Great Britain and Northern Ireland. On the 8th of September of this year, this bill, including Part 5, was published, giving the United Kingdom government the express power to break the terms of the protocol. The key foundation of an open border, namely the legally binding commitment freely entered into by the United Kingdom government, was fundamentally undermined when the UK explicitly stated they no longer regarded themselves as bound by all of the protocol. Law is not a protection when those to whom it applies can choose which particular laws to accept. Closing the border is ultimately the only way to protect the single market's integrity if the United Kingdom will not accept its legal obligations. Destroying our reputation as the country that abides by the law, depriving the European Union of confidence the border can remain open. Why? The Prime Minister says the European Union is negotiating, quote, in bad faith. He produces no evidence of bad faith. He says it is to protect the Union and to ensure unfettered access to goods between Great Britain and Northern Ireland. The powers that have been taken in Part 5 give the lie to that defence. There is power in Part 5 to break the protocol in two specific respects only. First, in respect of the requirement the UK signed up to in the protocol that exit declarations have to be submitted to the UK government for goods leaving Northern Ireland. I'm in favour of reducing unnecessary paperwork, but the suggestion a requirement for a short summary of goods leaving Northern Ireland is breaking up the Union is beyond reason. Second, the bill gives the government the power to break the protocol by giving the United Kingdom power to identify which state aids apply to Northern Irish Great British trade in breach of the protocol. This, I was told by Northern Ireland officials, is for clarity. I asked for maybe one actual example where there is a problem. I was not given one. And those are the only areas where the government can break the terms of the protocol under Part 5. There is a third issue not covered by the bill arising out of the protocol, which is what goods are to be regarded as at risk of moving from Great Britain to Northern Ireland and then on to the south. The issue is about trying to avoid some people paying the tariff and then getting a rebate because, in fact, the goods didn't go into the single market. It's an operational issue. I'm in favour of as few people as possible paying a tariff when not due and having to get a rebate. But the stuff of law-breaking, threatening the Union, absolutely not. The power to break the protocol in respect of the at-risk issue is not even included in Part 5. There was a reference in a government statement of the 17th of September to bringing in further law-breaking measures in the finance bill. There isn't going to be a finance bill this year, so that is no longer in play. So there you have it. Our government has signalled its willingness to break the law, walk away from the legally binding agreement that guaranteed an open border and peace, in order to reduce some red tape and resolve two issues half-decent diplomats could resolve in an hour. It makes no rational sense. When they say they are not walking away, ignore that. Which party will trust his counterparties who says, I will pick the terms of the legally binding agreement that I'm bound by? I have no doubt this comes from number 10. It's the product of a Prime Minister clueless about detail, so lacking in grip he can't or won't see beyond looking tough towards the European Union, flailing around trying to deliver on the false promises he made to Northern Ireland business that there wouldn't be any additional checks between Northern Ireland and Great Britain, and to the hardline Brexiteers that he would do something about the Northern Ireland Protocol, with his advisers out of control, looking for political stunts to reinforce the insurgent nature of Brexit, happy to sacrifice the rule of law in the hope of a good culture wars row with the Remainers and some screeching headlines, oblivious to the consequences to the standing of the UK, to its long-term relationship with the EU countries, and to the security and safety of those who live in Ireland. And with the defenders of the rule of law in government forced out or too desperate to hold on to the offices into which they have been over-promoted to speak out as they should. I congratulate Keith Stewart of Her Majesty's Council on his appointment as Advocate General and on the peerage that accompanied it. His predecessor, Lord Keane, resigned on the basis he could not square his obligation to protect the rule of law with the policy of this bill. The bill has got no better since his resignation. This is not about Brexit. That must happen. It's about destroying one of the foundational values of our country. Without a government committed to obeying the law, everything is at risk. The law is the ultimate protector. We will invite this House at the appropriate time to remove Part 5 of the bill, neck and crop. I hope thereafter this House will do everything it legitimately can to ensure it does not return.
Lord Wallace of Tankernes.
My Lords, can I follow on from the noble and learned Lord Faulkner of Thoroton by paying tribute to my successor as Advocate General for Scotland, the noble and learned Lord Keane of Ely. I have known the noble and learned Lord for over 40 years. He is undoubtedly one of the best advocates of our generation. And when a lawyer of his calibre and experience says that he found it difficult to reconcile what he considered to be his obligations as a law officer with the Prime Minister's policy intentions with respect to this bill, then I believe noble lords should sit up and take note. And in an age when resignation on a matter of principle seems to have gone out of fashion, surely we must commend the personal and professional integrity shown by the noble and learned lord. As someone who has seen devolution work in practice from within both Scottish and United Kingdom governments, I want to express real concern about the potential for this bill to do untold damage to the delicately crafted architecture of the devolution settlements. I seriously question whether this bill is necessary. As the White Paper itself acknowledges, the UK internal market is already strong, with overwhelmingly frictionless trade. By contrast, the evidential base for needing legislative requirements for mutual recognition or non-discrimination between the different political units in the UK is wholly underwhelming. Yes, divergences already exist. More than 30 years before devolution, different building standards were adopted in Scotland. But now the White Paper flags up differential building standards as a threat to the internal market. I certainly believe that the United Kingdom governments of the 1960s had a better understanding than the authors of this bill in the White Paper that differences in climate and the built environment between the home counties and Orkney merit different standards. And it is also the case that even within the EU regulatory framework, devolution has led to some divergences to reflect local needs and political priorities. That surely is the essence of devolution. Indeed, the United Kingdom government supported the Scottish government in the European Court of Justice when the Scottish government sought to bring in minimum unit alcohol pricing in Scotland. But this bill does not replicate the limited grounds set out as legitimate aims, which are provided for under Article 36 of the TFEU, when a legislator seeks to diverge from internal market principles. Nor indeed is there any reference in this bill to principles of subsidiarity and proportionality, which also underpin the current EU framework. As a result, the scope of devolution is restricted and unprecedentedly without consent of the legislatures, the devolved legislatures. So in replying, can the Minister explain why are these differences allowed to arise? One further compelling reason to put this bill aside, as referred to by the noble Lady Baroness Hayter, is a curious silence in its provisions on the subject of common frameworks. Heralded as the way forward 3 years ago, and in spite of difficulties, efforts to achieve common frameworks have enjoyed buy-in from all the devolved administrations. On the 15th of September, in another place, Cabinet Office Minister Chloe Smith said that 5 frameworks will be delivered by the end of this year. In seeking to commend the whole of the 17th report of the Constitution Committee, on which I have the privilege to serve to the House, may I particularly refer to our comments on common frameworks and our conclusion at paragraph 57. I quote, "We consider that adhering to the principles agreed for formulating common frameworks would improve the likelihood of reaching agreement on how to progress the bill. We are not convinced that opportunities for managing the UK internal market through the common frameworks process have been exhausted. This contributes to our doubts about the necessity for the bill." I don't underestimate the challenges, but surely if there is a way forward which promotes and facilitates cooperation over the conflict and mistrust which this bill has come to symbolise, it is in the best interests of all parts of our United Kingdom that we vigorously pursue it.
Lord Clerk of Nottingham.
My Lords, I find it difficult to express how strongly, firstly, I am amazed, and secondly, deeply, deeply dismayed that any British government of any complexion should produce before Parliament a bill which contains the provisions of Part 5 of this bill. I never expected in my parliamentary career, which has not been a short one, to find myself reading a bill of this kind presented for parliamentary approval. It's already been said, and will be said many times in this debate, It appears to give the government unfettered power to break, in any way it finds necessary, particular provisions of a treaty upon which the ink is barely dry. I will not attempt, and I don't have the time, to compete with the undoubted eloquence of the noble Lord Judge and my noble friend Lord Howard, who have expressed very much the shock which I think everybody who has any regard for the rule of law in this country undoubtedly feels. So let me just move slightly to my more familiar field, although I'm certainly a long-practiced and experienced lawyer, and just talk about the politics that underlines this, which I also find quite bizarre and completely inept. The origins of the need for this bill are quite extraordinary. Of course, it all arises from the decision taken shortly after the referendum that Brexit would involve leaving the single market and the customs union. Now, I strongly disagreed with that. I think we could have left the European Union and remained. I actually moved a motion in the House of Commons and got within 6 of a majority for staying in the customs union, which is nearer than the then Prime Minister, Theresa May, unfortunately got to achieving for anything. But that is not the issue today. I accept that we are committed to leaving the single market and the customs union. I accept the judgment of Parliament and the population, but it does give rise to all the problems that the government does not know how to solve. Once you leave the customs union and the single market, you need a customs frontier between your own internal market and the rest. I mean, it's wholly in accordance with all the ordinary practices of international trade in modern times, WTO rules and all. And everybody knows that at Dover this could create a very considerable problem, and we're preparing to recruit the people, get the lorry parks, handle the traffic, get people to prepare for the paperwork that is involved. The problem, of course, arose in Ireland, which no one seemed to have thought about very clearly, until they realised to do the same in Ireland would totally undermine that extremely important agreement to the security of the United Kingdom and of the Republic, the Anglo-Irish Agreement. So the solution was determined that Ulster should stay in the customs union and the single market, and Great Britain would leave. And that means we have a customs frontier down the Irish Sea. Now, this wasn't a sudden or ill-considered thought. It was argued about very vigorously. The Democratic Unionist Party, otherwise firm Brexiteers, supported the whole agreement. They opposed the whole agreement on that basis. But the fact remains we have committed ourselves to actually having a frontier. The proper thing to do now is not to go back on our word with no solution. It's quite unclear what the government really proposes by way of essential customs controls that are still compatible with the agreement. We should minimise the necessary delays, as I hope we're doing in the negotiations with the EU. If we insist on changing standards, we should have equivalence of standards. We should have arbitration procedures to settle disputes. We should make sure disruptions to trade, delays at the border, costs are as little as possible. But the idea we solve the problem, as I say, it isn't quite clear what would happen if you just leave a hole so far as controls between Ireland and the GB is concerned. The session is we break the rule of law. I realise I've only got 4 minutes to talk on this matter, which I do think is one of the bizarre arrangements in this chamber I'm getting used to, because no other parliament in the world would think that people can do justice to the contents of this bill 4 minutes at a time in the way we're doing. But I add my voice and I will oppose Part 5 in particular in every way in which my membership of this House permits me.
Lord Panic.
My Lords, what an extraordinary series of speeches so far. The speech of the Noble Lord, the Minister, was itself extraordinary because he ignored the elephant in the chamber. That is the elephant that is trampling through Part 5 on the rule of law. The noble and learned Lord Judge, in his powerful speech, referred to the report of your Lordship's Constitution Committee. I'm a member of that committee. We unanimously concluded that for this bill to set out to break international law is without precedent. We described Part 5 of this bill as, quote, constitutionally dangerous, unquote. We said that this bill is, I quote, fundamentally at odds with the rule of law, unquote. We reached those conclusions not just because ministers want to give themselves this unprecedented power to breach international law, which, as Lord Howard said in his eloquent remarks, this country is looked at by other nations as a beacon of legality, and it's therefore extraordinary that ministers should want such a power. But we reached these conclusions also because ministers are seeking to immunize the regulations that they make from challenge in the courts on any ground, quote, whatsoever, unquote, the word used in clause 47, subclause 8. Now, the Constitution Committee is not a group of lefty lawyers, the Prime Minister's term of abuse in his recent speech to the Conservative Party conference. Nobody, I think, has ever described my esteemed colleague Baroness Fuchs in that way. There are some lawyers on the Constitution Committee, but most of the members are politicians and political observers from across the House with decades of political experience. My Lords, the government should be ashamed to be responsible for producing and pursuing a bill which attracts such condemnation from such a committee of your Lordship's House. Like those unfortunate people who do not feel pain and who are therefore at grave risk of injuring themselves and those around them, this government does not feel shame. It is therefore the responsibility of this House to shout out a warning to the government that Part 5 of this bill will, if enacted, endanger the rule of law. I'm grateful to the noble and learned Lord Judge because his regret motion gives us the means by which that warning can tomorrow be communicated loudly and clearly. Thank you.
Lord Cormack.
My Lords, I cannot forbear from saying to my noble friend the Whip on the front bench that limits in second readings are advisory, and I was very sorry she felt necessary to interrupt my noble and learned friend, Lord Clerk of Nottingham. My Lords, this is a particularly sad day for me, because, like my noble friend, Lord Clerk of Nottingham, and we entered Parliament on the very same day. He's had a much more illustrious career than me, but we entered on the same day. I never thought I would see the day when any British government would produce legislation that would take out a significant part of a treaty entered into by this government following a manifesto commitment, and that was commended to both Houses of Parliament and endorsed by both Houses of Parliament less than a year ago. For anyone who aspires to be a parliamentarian, this is shameful, and there is no other word for it. And I am deeply ashamed that a Conservative government should have embarked on this course. I like to think that it's the result of Barnard Castle, but at the end of the day, the buck stops where the buck stops, and it is the government that has done this. My Lords, I have a regret motion on the order paper, similar in intent, although differently phrased, from that of my noble friend, I'm deliberately calling him that, Lord Judge. I do not intend to exhaust your lordships electronically tomorrow, and as long as Lord Judge does indeed move it, I can't think that he would ever change his mind on a subject like that, I will certainly not move mine. But I put it down on the order paper because I was so saddened and so disturbed. And my feelings have been entirely reinforced by the 3 reports which have been referred to in your Lordship's House this afternoon. That of the Noble Earl Canoole's Committee and our own Constitutional Committee and the Regulatory Reform Committee. I have never seen 3 reports so uniformly damning as those. And we, my lords, in this House have a duty to ensure that this bill does not go on the statute book in anything like the form it is at the moment. Part 5 has got to be removed. And if anybody talks about the Addison-Salisbury Convention, we would actually be upholding the Addison-Salisbury Convention by taking that course of action. That was the convention agreed when the Labour Party had a tiny number of people in your Lordship's House, Conservative overwhelming majority, but it was agreed that any manifesto commitment would not be prevented from having a second reading or getting on the statute books. My Lords, this was, as I said earlier, part of a manifesto commitment, and so we would be upholding and not contradicting that convention. My Lords, as we sit in this chamber, we look up and we see the barons of Runnymede, the barons of Magna Carta, from which the rule of law developed over 800 years ago. And we have a great duty in this House to ensure that the rule of law is maintained. As Lord Judge spoke, and he made a marvellous speech, I thought of Tom Bingham, whom I was privileged to count as a friend. And Tom Bingham wrote the most wonderful little book called The Rule of Law. Every one of your lordships should buy some copies and distribute them at Christmas time, particularly members of the other place. My lords, the Bingham Centre for the Rule of Law has produced a paper which I think we have all received. It is a very well-worded, forcefully argued paper. And we cannot, my lords, allow those chilling words uttered in the other place a few weeks ago to be the final say. Limited and explicit breaking of the law. How can we lecture China? And how can we exhort our fellow citizens to obey the draconian laws we are currently thrusting upon them if we take this line? My lords, we must not, and I hope we will not.
Baroness Hayman of Alloc.
My lords, it is a great pleasure and honour to make my maiden speech today and to follow the noble Lord Cormac. And I would first like to thank the staff for their support and hard work. Black Rod and her team, the Clerk of the Parliaments, doorkeepers, attendants, police officers have been helpful, patient and truly welcoming. I'm also indebted to my supporters, my noble friends, the Lady Jones of Whitchurch and the Lady Smith of Basildon, for introducing me to the House, and to my mentor, the Lady Lister, for her advice and guidance. I was delighted to be able to take the geographic title of Baroness Hayman of Ulloch, a village in West Cumbria where I live on a small holding beside the River Marron with my husband and a collection of animals. It is a beautiful place, nestled between the majestic fells of the Lake District National Park and the mountains of Scotland across the Solway Firth. And I am passionate about nature, and we manage the land to enhance the environment and to encourage biodiversity. So I was very proud when I was elected to the other place as Member of Parliament for Workington, Cumbria's first woman MP, and then given the responsibility of Shadow Secretary of State for the Environment, Food and Rural Affairs, a role I carried out for nearly 3 years. To be able to develop policy, not just on environment, food, farming and rural issues, but also on another of my passions, animal welfare, was a huge privilege. And it really is a privilege to have joined your Lordship's house. I am aware of the many differences between here and the other place, so I ask you please be patient with me if I fall into old habits. But I'm looking forward to getting stuck in, and also to get back to singing with the Parliament Choir. It was a great honour to be chair of the Parliament Choir until last year, and I made many friends, a number of whom sit in this house. And having listened to the speeches today, it is clear that there is a huge amount of knowledge and expertise in your Lordship's house. Although as a long-standing Leicester City supporter, I was somewhat taken aback by the earlier suggestion of the noble and learned Lord Judge. But I'm pleased to be able to participate. So turning to the debate, I've already talked of my passion for the environment, but I am also half Welsh. My mother's family farmed in the South Wales valleys, and the Minister will need to address the concerns that the bill risks destabilising devolution arrangements and hampering environmental legislation. I have no problem with the objective of ensuring that the UK internal market can work smoothly after Brexit transition, but it must protect high environmental standards and encourage improvement. And these matters generally fall under devolved responsibility. The government has said that our existing high standards for the environment will underpin the functioning of the internal market. However, the bill does not give a legislative effect to this commitment. On the contrary, in its current form, it could make it harder for the devolved nations to achieve their ambitions. So it's vital that our devolved administrations can introduce and implement their own environmental laws. So can I ask the Minister to clarify how the government intends to ensure that current environmental standards are not weakened and that this bill will not prevent or deter any part of the UK from introducing or implementing measures that are designed to protect and enhance the environment and mitigate climate change? Climate change hasn't stopped because of the global pandemic, yet it seems to have become the forgotten crisis. We should be increasing our ambitions in the fight against climate change, and every new piece of legislation should consider its potential negative impact on the environment. I hope the Minister can reassure me that this will be the case with the bill that we are debating today, and our environment will continue to be both protected and enhanced. I have chosen to make my maiden speech today because I believe this issue is of such fundamental importance to our future. and I look forward to fully engaging with the work of your Lordship's House.
Lord Liddell.
My Lords, it's an inestimable pleasure to congratulate my noble friend Baroness Haven on her maiden speech. We go back a bit of a way. We were both freshers, if that's the right term, in the Cumbria Labour Group when it was first elected in May 2013. And that's a forum of plain-speaking common sense, which I would recommend to some of our national politicians. And together, as we are now in this place, I hope we will in future speak up for the North, speak up for Cumbria and its very special concerns, alongside, of course, many other peers in this place, including Baroness Hayman's predecessor, but one as MP for Workington, Lord Campbell Savers. Now, Sue made a distinctive mark in the Commons. She led the opposition on environmental and rural affairs, and she thought deeply about the issues. In a Labour Party that was then going through a very difficult patch, to put it mildly, she was a voice of quiet calm and reason. And it's great that my wife will be extremely pleased, for one, that she's going to take up again her involvement in the parliamentary choir. In last December's general election, the so-called Workington man assumed a mythological status as driving a huge breach in what used to be Labour's so-called Red Wall. Now, I see Baroness Hayman as a fine and, I believe, more lasting example of Workington woman with an instinctive feel for progressive values, a deep concern for the underdog, a practical passion to secure reform and change, and what's more, she's a very decent human being. So congratulations and welcome. Now, today, on the issue, I'll speed up, I hope. As we're not supposed to be talking about Brexit, people say Brexit's all over. Well, sort of it is, and of course I accept the result of where we are. But it is because of the Brexit we've chosen, as Lord Clark of Nottingham pointed out, that the government has got itself in this very considerable difficulty. And I believe that although you could say the debate about Brexit is over, the debate about the consequences of Brexit, and not just the economic consequences, which I think are going to be bad, worse than COVID according to most independent assessments, but it's not just the economic consequences. They're going to affect our politics and dominate it perhaps for years to come. This bill is a dramatic blow to Britain's standing in the world. The very act of tabling it has done incalculable damage to our international reputation, and as Lord Judge said, we are now dependent on our soft power for influence. Why has it been done? Well, look, the proposal for a revised Northern Ireland Protocol was put to Brussels by Boris Johnson himself after his walk in the park on Merseyside with Leo Varadkar last autumn. It was the key to having a different withdrawal agreement that he could then get through Parliament. Are we to assume that he never read the provisions of the protocol that he signed, or that Michael Gove didn't read them on his behalf? Now, I actually believe by the time we get to report stage, these provisions may have been dropped. That's what I very much hope. And I think the government will use the excuse of a skinny trade deal to drop them. But my fear is that this won't resolve the problem. Trade across the Irish Sea will muddle on for now, but that's only because our rules and standards are presently fully convergent with the EU's. But for this government, the whole point of Brexit is to diverge from EU rules, and I think that this will cause great difficulty as time goes on. And I think it has dangerous potential to undermine the Good Friday Agreement. And as my noble friend has said, this puts in question the future of the United Kingdom. And also, if I had been a Scottish MSP, I would vote to refuse legislative consent to this measure on the grounds that they are overriding the devolution settlement. It's a profoundly dangerous bill, what we're looking at today, and this House has constitutional responsibilities to reject parts of a measure that contradict the manifesto in which the government was elected and breaches international law. And I hope the Lords will neuter it and then stand their ground.
Lord Carlisle of Berry.
My Lords, may I too congratulate the noble lady Baroness Hayman of Ulloch on her excellent maiden speech. As a former Welsh rural member of Another Place, I welcome her commitment to the integrity of rural life and rural communities, and I look forward to her many further contributions to your Lordship's House. I would say to her that she should not be unduly sensitive about the habits of this place. We all get used to being shouted at when we break order by standing up at the wrong moment or in the wrong gangway, but it's never really meant. It's just one of those things. My Lords, I suggest that the very fact that so many speakers are expressing their concern about Part 5 of this bill, combined with the range of expertise and experience of those speakers, should give ministers serious pause for thought before this bent-barrel blunderbuss is fired into the rule of law. This is legislation by offensive weapon, not legislation by logic. Like many others, I support the regret motion in the name of my noble and learned friend Lord Judge, and moved by him with such clarity. As a former Lord Chief Justice, he speaks with authority, the contradiction of which on this issue at least would in my view amount to brazen and wilful ignorance. For those who are interested in his support for Leicester City, I would remind others who are listening that at the moment, as it were, Leicester City are winning 14-1, a fairly rare experience, and I suspect that it will be a much larger lead by the end of this debate, something that ministers should not overlook. I would urge your lordships and others outside to beware of thinking that this debate is a lawyer's word fest. This is not an issue on which any special knowledge of the law is required at all. It's a matter of surely constitutional instinct, international expectation, and mutual respect between the United Kingdom and the rest of the world. And let me remind your lordships that this government that we have is the first to resort to the rule of law when it suits them. If you look at the way they have made their submissions in cases concerning foreign terrorism fighters seeking to return to the United Kingdom, however unruly in law those applicants' other countries of potential citizenship are, the British government is the first to say, we rely on the rule of law. We may not like those countries, but they're entitled to go back there, so there they shall go. So there's a degree of hypocrisy on the evidence in what is happening today. My lords, my parents escaped from the basest of persecution. My father, a deep-rooted Anglophile, after he got over my decision not to follow him into the medical profession, about which he expressed deep disappointment, but was probably to the benefit of my potential patients, taught me politics and history in an international context. And he told me of his pride at living in a legal system that would make my qualifications respected throughout the world. I and many others in our current professional lives deal with business people in many countries. One of the beacons that attracts them to making contracts with UK-based entities is their belief that once a contract and agreement are reached, nothing will be changed in this country arbitrarily, gratuitously, or for oblique motives. And some of those dealings are with the British government. Well, my lords, I am ashamed that this government is even considering empowering ministers to derogate from the obligations of the United Kingdom under international law. I am dread-dazed that it is contemplated to breach international law that could, in a way that could undermine the extraordinary achievements of courageous people on all sides in Northern Ireland, and appalled by the suggestion that we should be in breach of Article 26 of the Vienna Convention. And I hope that the government will listen to these debates, and particularly today's debate on my noble and learned friend's regret motion, and change its mind.
Lord Lilly.
My Lords, I congratulate the noble Baroness on her excellent maiden speech and look forward to hearing her both spoken and musical words in future. As a non-lawyer, I enter this arena like a Christian facing a pride of angry legal lions, made worse by the fact they've already captured my own Archbishop. I'm armed only with a simple question. What should a state do if it finds that its obligations under one treaty conflict with those under another treaty or its constitutional law? The only reply I've received so far is, you shouldn't have signed the withdrawal treaty. That might work in a student debate, but it fails to address my question. So let me answer it myself, not in my own words, but in those of the European Court of Justice. The Court affirmed in the Caddy case that although the EU seeks to comply with its international legal obligations, and I quote, it would be wrong to conclude that once the community is bound by a rule of international law, the community courts must bow to that rule with complete acquiescence and apply it unconditionally. Likewise, the German Constitutional Court has ruled that if treaties, even the EU treaties, conflict with German constitutional law, the latter prevails. And British governments have, of course, disapplied aspects of international law, most famously the Convention on the Sea 15 days after it came into effect, when the future Lord Diplock ruled that the Crown has a sovereign right which the Court cannot question to do so. And moreover, in Clause 38 of the Withdrawal Act, Parliament explicitly foresaw that it might need to set aside the direct application of the Withdrawal Treaty, as this bill permits. But no one ever suggested, when they disapplied parts of the conflicting laws, that the European Court of Justice, the German Court, or previous UK governments have broken the law, until Brandon Lewis uttered those fatal words, which have been seized upon as a weapon by some and proved a stumbling block for some of my closest friends, but which I believe should be disavowed. Now, this raises the question, are there potential conflicts between obligations under the Withdrawal Treaty and our fundamental constitutional laws? There are certainly many internal contradictions within the Withdrawal Act, but we ratified it because it contains a mechanism, the Joint Committee, in which both sides are committed to resolve outstanding issues in good faith and respecting each other's legal order. Their legal order, Lords. So given good faith and mutual respect, there should be no conflict with our legal order, the pillar of which is the Act of Union between Great Britain and Ireland, which pledges that all prohibitions and bounties, i.e. tariffs, on the export of articles of either country to the other shall cease. And this is buttressed by the Belfast Agreement, which promises no change in that union without the consent of both communities. However, the EU has been showing little evidence of good faith by insisting on applying the entire EU customs code, which would mean that no goods can move from Northern Ireland to Great Britain without an EU export declaration, which my noble friend used to say was one of the disadvantages which is we all face in all our trade once we left the customs union. And that's contrary to both the Act of Union and Article 6 of the protocol, which says nothing in this protocol shall prevent the United Kingdom from ensuring unfettered market access for goods moving from Northern Ireland to other parts of the United Kingdom's internal market. In the other direction, the withdrawal treaty commits both sides to agree before the end of the transition period the definition of goods which are at risk of crossing into the Republic. But the EU has implied that if it declines to agree, the UK will have to levy EU tariffs on all goods going from Great Britain to Northern Ireland. Now, both these results would conflict with the Act of Union and the Belfast Agreement. Happily, because of this bill, the EU seems to be pulling back from both these positions. So I hope that good faith will prevail and will not need to implement the clauses in this bill. But it would be irresponsible to leave this country unprepared by rejecting these clauses.
Baroness Taylor of Bolton.
My Lords, can I start by welcoming my noble friend Baroness Hayman and congratulating her on her speech. I'm absolutely sure that she will make many positive contributions to the work of this House, and it's good to see her here today. My Lords, there's no way that in 4 minutes I can do justice to the report of the Constitution Committee that I have the privilege of chairing, so I will restrict myself to some remarks on some major points. When we first heard about this bill, we were sceptical about the need for legislation and particularly concerned about the impact on relations with the devolved institutions. I'll come later to the rule of law issue, which is now receiving greater attention. But I do want to emphasise the impact in terms of the unity of the United Kingdom. And this bill remains a major concern in respect of this. The committee believes that there is no reason why the principles for the successful operation of the UK internal market cannot be arrived at consensually. There is, after all, broad agreement on the need to avoid erecting new barriers to trade. There are existing mechanisms to achieve this, including, of course, the common framework arrangements, which we are sometimes told are working well. And the government has never explained why these mechanisms are inadequate. Moreover, the devolved administrations are required by law to adhere to international obligations such as trade treaties. And if the government is committed to the Union, then it needs an internal market that all parts of the Union have bought into. Turning to the rule of law issue, the committee took a great deal of evidence on this issue and has said very clearly that the rule of law applies to everyone, from government ministers to the person in the street. We are all bound by and entitled to the benefit of the law. Indeed, it is an essential characteristic of a democratic society and a fundamental principle of our Constitution. And the rule of law also includes compliance with international law. Yet, this bill provides the government with extraordinary delegated powers that the government itself has acknowledged are for the purpose of breaking international law. My Lords, we believe that taking powers in this way to explicitly break international law is without precedent. And for the government to put such powers beyond the reach of judicial oversight is a step that is also fundamentally at odds with the rule of law. For these reasons, I will support the amendment in the name of Lord Judge. My Lords, there are other concerns, that is obvious. There are the implications for the ministerial code, where we raise the question of the need for clarification of ministers' duties to comply with the rule of law. Then there is the question of the scope of delegated powers addressed by the DPRRC, and of course, the Union Committee, European Union Committee, has also outlined issues in relation to the Northern Ireland Protocol, which Lord Kinnoul and Lord Faulkner have spoken about. A cynic might say that the rumpus around this bill aids the government by drawing attention away from the basic ambiguity in the government's original approach. Finally, my Lord, I must reiterate my view about the lack of necessity for this bill. There is general agreement that we need a thriving internal market. No one has argued against it, and there are existing arrangements that can deliver this. On EU relations, I do not know if this bill is part of the government's brinkmanship, but even if that was its purpose, it is no justification for legislation to break the rule of law. But I do know that this legislation is damaging to the UK's international position, and that can be in no one's interest at all. I regret that the government has introduced this bill and ask them to rethink their approach, and particularly to accept amendments to Part 5 of this bill.
Bruce of Benaki.
My Lords, first of all, I would like to join in the congratulations of Baroness Hayman of Alloch, and I've made a maiden speech. And like others, look forward to hearing her contributions, whether it's about Cumbria or the environment, which I think the House will anticipate. But my Lords, I first of all would like to deplore that a government bill should contain Clause 45(2)(a), which trashes the UK's reputation for upholding its treaties and honouring its obligations, and seriously undermines our ability to negotiate effective agreements. I believe it reveals that the government is under the stranglehold of anarchists and disruptors. Indeed, I have no doubt that it suits the dark forces in the government that this part of the bill has diverted attention from the other deeply damaging proposals which cut across the devolution settlements to which I now turn. I was closely involved with the Scottish Constitutional Convention, which laid the basis of the Scotland Act and subsequent further extension of powers. I'm a passionate Home Ruler, but deeply inimical to the breakup of the UK, which I believe will cause fundamental and lasting economic and indeed emotional division and hardship. And in typically British fashion, devolution has evolved differently in each devolved administration, nor is it written into a basic law, but it has become accepted and it works. And one of the reasons for this has been the overarching umbrella of the European Union now being removed. Awareness of the implications of this were addressed by the Joint Ministerial Committee on EU negotiations in October 2017, with a joint communiqué setting out principles behind the common frameworks, which many noble lords referred to. As a member of this House's newly established Common Frameworks Committee, I am now aware that this work has been progressing slowly but constructively. A dispute mechanism is envisaged, but has not yet been required. And it's the view of the devolved administrations that this process is both fit for purpose and practical. As the Constitutional Committee stated, it appears that this bill is anticipating problems that may never arise, but seeking powers that prejudice the effective and consensual working of devolution. By contrast, the devolved administrations can identify how the powers in this bill would allow the UK government to block or disrupt the working of devolution. This could affect building regulations, where, as has been pointed out, in Scotland, we want higher insulation standards, or we might want lower carbon specs. It could affect single-use plastics, where Wales and Scotland want tighter restrictions than England. The mutual recognition and non-discrimination rules could nullify such divergence, which is why devolved administrations argue it could be an England-led race to the bottom. Clause 46 and 47 give the UK government powers to initiate spending in the devolved administration areas without requiring the engagement or consent of the respective governments. The motivation behind this seems blatantly disruptive. No doubt the people of Scotland, Wales and Northern Ireland may welcome extra cash from the Treasury over and above their own sources of revenue. City deals are an example of that. However, for such a measure to be pursued without the participation or consent of the parliaments or governments is the total negation of devolution. And what is more, to be pursuing this only months before crucial elections in Scotland and Wales is a monumental misjudgment by a government that cares nothing for devolution, talks unionism while trampling all over the settlements that are essential to holding it together. The bill is not just unnecessary, it's downright provocative, shows utter contempt for the hard-won measures that are essential to holding the United Kingdom together. Ideally, this bill will not proceed. If it does, it must be with the removal of law breaking and the requirements of consent from the devolved administrations, which currently seems unlikely to be forthcoming or even sought. What is missing from the government's approach is any concern, consideration, or comprehension of the delicate balance of devolution. And this is well summarised in the report published by the Centre on Constitutional Change. When 5 archbishops are motivated to put their anxieties into print, it's time for the government to recognise this hastily concocted and ill-thought-out bill is not fit for purpose, whatever the purpose is meant to be.
Baroness Noakes.
My Lords, I support this bill because it is an essential element of our preparations to be an independent nation again. Before we joined the EU, we did not need special internal market arrangements for trading goods and services within the UK, but devolution has changed that. We need this bill to ensure that the different parts of the UK can continue to trade with each other as at present without incurring costs or negotiating regulatory hurdles. The beating heart of this bill is about protecting the devolved nations. The government's UK Internal Market White Paper last summer showed that Scotland, Northern Ireland and Wales export more to other parts of the United Kingdom than to outside the UK. And there are similar patterns for imports. Keeping the ability to trade within the UK on a barrier-free basis should be at the core of the belief set of each of the devolved nations. I've been surprised that they have not grasped this basic economic fact, but have instead been focused on working up grievances about this bill. Now, the economic imperative is not the same for England, which trades goods and services outside the UK more extensively, but nevertheless, intra-UK trade is important for England too. My Lords, this bill is also strongly pro-business. The plain fact is that most businesses in the UK do not export goods or services outside the UK. And roughly 90% of SMEs trade only within the UK. Keeping this intra-UK trade going without friction is of massive importance to the health of the UK economy and the UK economy overall, and of the devolved nations as well. My Lords, other sensible provisions in this bill include ensuring that any subsidy control regime is UK-wide in order to avoid distortions in intra-UK trade. We simply cannot have an efficient and fair UK internal market unless subsidy control is exercised on behalf of the whole of the UK. And I also welcome the new role for the Competition and Markets Authority. My Lords, I know that most of today's debate will be taken up with the provisions of Part 5 of this bill and the power that it creates to modify the EU Withdrawal Act. The government have been clear that they would use such a power only if it really were necessary to protect the position of Northern Ireland within the UK. They would use it only as a last resort, having exhausted all other routes. And of course, they would not put the issue of peace in the island of Ireland at risk. And I'm also clear that the other place would not let the government do otherwise. My Lords, I hope that it is not necessary to breach international law. But we should remember that such breaches are not without precedent. Sometimes countries and different governments in our own country have concluded that faced with competing evils, the least harm is done by taking that decision. I hope noble lords who have concerns about this part of the bill will see that it has the best interests of the UK at its heart. Lastly, my lords, I regret the highly political intervention today by the Most Reverend Primate, the Archbishop of Canterbury, and his fellow Anglican primates. This establishment is starting to look rather attractive.
Lord Hannay of Chiswick.
My Lords, I regret that the virtual proceedings we have mean one doesn't no longer welcome maiden speeches across the chamber, but have to do so remotely, and I do that now, both to the one already made and those that are coming. I make no apologies for concentrating my remarks in this second reading debate exclusively on the bill's Part 5 and its clauses 44, 45 and 47. Other parts of the bill require, certainly, the customary careful scrutiny and very possibly the amendment we normally give to legislation, but this section is unprecedented, indeed unique, and it requires more drastic treatment. Why so? Because never before in Britain's modern history has a government brought forward a bill giving it the authority to unilaterally break international law and to override our treaty obligations. In this case, obligations entered into less than a year ago and legitimised by legislation passed by this Parliament following last December's election. No doubt about that, because the Secretary of State for Northern Ireland stood at the dispatch box in the other place and told us it was so quite explicitly. Now, does that have implications going far beyond the subject matter covered by this bill? Indeed, it does. This country has prided itself that its word was its deed. In the 20th century, we twice went to war, to world war, in 1914 and 1939, to uphold our treaty obligations. But apparently, we now no longer are going to have our word being our deed if these provisions become law. Moreover, it is the government's view, which I happen to share, frequently put forward at our own dispatch box, that it is in Britain's national interest to sustain and to strengthen the rules-based international order. And that order is currently under severe strain. How much credibility will our advocacy of that order have if we start picking and choosing which bit of it we intend to apply and which ones we intend to ride roughshod over? Very little, I would suggest. And I can just visualize the justifications which the representatives of Presidents Putin and Xi will next put forward next time they wish to break international law and their international obligations. They'll be identical to the arguments being used by the government to defend the measures brought forward to us today. This is not, I would insist, a matter of which side of the Brexit argument you were on. That matter was settled last January when this House endorsed the deal the Prime Minister struck with the EU, and this deal, that very same deal, we are now being invited to override. And it was settled when we left the EU at the end of January. That is demonstrated by the fact that the critics of these measures are drawn from both sides of that Brexit argument. What really is relevant is the risk to the Northern Ireland peace process if the government persists in the course it has set out on. Government's protests, to the contrary, ring to me quite hollow, and the balance of analyses point to a real, genuine, serious risk to that process. So those are the reasons why I believe the principled course of action is to remove those parts from the bill that I have referred to. There is just one word I find that describes them: an aberration. And that is why I will be voting with the motion in the name of my noble and learned friend, Lord Judge.
The Lord Bishop of Leeds.
My Lords, I add my congratulations to Baroness Hayman of Ullach and look forward to her future contributions to this House. I fully endorse the arguments set out by the noble and learned Lord Judge. I concur with the concerns set out in reports cited by other noble lords earlier. I even welcome the commitments articulated by the Minister, but I question how they can be trusted given the underlying ethic of this bill. And it is absolutely right for archbishops to ask questions of such matters. Relations with potential partners usually depend on integrity. trade, security, migration, and so on, all rest on the matter of fundamental trust. Now, trust can't be one-sided, or it's not trust at all. Respecting one's interlocutors is essential, and this is inevitably evidenced in language. The bill before us assumes that our interlocutors cannot be trusted, will behave in bad faith, and that we need to be protected from them. If they don't give us what we demand, we are free to do our own thing, including breaking the law and reneging on agreements we made less than a year ago, which was said to be, at the time, oven-ready, a good arrangement that required, and I quote, no more negotiations, unquote. What it doesn't ask is why our word should be trusted by others. My lords, integrity and morality matter at the level of international relations and agreements, unless, of course, we are now agreeing to reduce all our relations and transactions to some sort of utilitarian pragmatism. Morality also applies to how we both remember history and establish what will shape the national mythologies that future generations will inherit. My lords, what story will be either celebrated or commemorated next year? The centenary of partition on the island of Ireland. One that chose to end violence and respect difference, including different perspectives on identity, justice, and unity, or one of a conscious abrogation of agreements that were built from bloodshed and courageous willingness to stem the wounds of grievance. Ireland, both the province and the Republic, needs some certainty in shaping the future narrative. So what sort of certainty is built on a broken word, the negation of trust, or the arrogance of exceptionalism? Irish church leaders are surely right to be concerned about what this bill implies for relations between the devolved institutions themselves and with the UK government. These leaders are not talking into fresh air. They straddle the border in Ireland, and their deep concerns about a breach of the Good Friday Agreement need to be listened to and not simply dismissed with a wave of boosterish optimism from Westminster. Others will speak about the implications of closing any legal route to challenge the government's implementation of the protocol. But let's be clear, parliamentary sovereignty does not translate easily into executive sovereignty. A decision to prefer short-term pragmatism over long-term ethics will lead to a future in which a question mark will hang over any statement by those whose word and adherence to the rule of law cannot be trusted. More is at stake here than economics.
Hunter Wirral.
I begin by drawing attention to my outside interests as set out in the register. In this important debate, it's vital we don't lose sight of the bigger picture in two important respects. First of all, our society and our economy have been battered this year and continue to be battered by the effects of the global pandemic. All the government's deeply held fiscal aspirations have necessarily and rightly been jettisoned, as the Chancellor has done everything within his power to protect jobs and economic activity, and also protecting the National Health Service. Our society and our economy are one and the same thing. In 2016, the British people voted to leave the European Union, and last December this government won a clear mandate to see that policy through. In so doing, it is inevitably involved in complex negotiations both with the European Union and also in practice with individual member states, each with its own particular interests. Defending our economic interests is and must always be the paramount concern for ministers, and that priority has never been more important. A satisfactory trade deal with the EU was never going to be easy to achieve with so many competing interests at play. Of course, there must be give and take on all sides. I have stated on many occasions that I believe a constructive and comprehensive post-Brexit trade deal between the UK and the EU is not only the best outcome, but an outcome we must all avidly support. I think we all also agree that any repudiation of a treaty or any action that might be seen as a breach of international public law must be avoided if at all possible and used only as a last possible recourse in the most extreme situations. And I do so strongly support the tribute paid by Lord Wallace of Tankeness to my noble friend Lord Keane of Ely. We certainly miss him in this debate. After the damage inflicted by COVID-19, however, we surely cannot afford to allow anyone, internally or externally, to jeopardize the integrity or the efficiency of our own internal market here within the United Kingdom. That, it seems to be, is the actuating principle behind this bill, and of course, in a second reading debate, it is the principle that we are considering. There is a second point, which is the role of this House. I never cease to be impressed by the exceptionally erudite and public-spirited contributions we hear week in, week out from these benches, especially today. The brilliant maiden speech of the noble Baroness, Lady Hayman of Utlock. Nonetheless, we mustn't lose sight of where we stand in the delicate constitutional settlement of this land. It is our obligation fairly to consider propositions sent to us by the House of Commons and, where possible, to improve them. On the assumption that convention is honoured and this bill progresses, there will be bountiful opportunities to return to the details of this legislation. For now, however, with Her Majesty's ministers engaged in highly technical and demanding negotiations, the outcome of which is of the utmost importance to us all, I hope we will find ways of strengthening the hands of those who represent us rather than seeking to tie them.
Lord Whitty.
My Lords, most contributions so far in this debate have related to Part 5 and the government's somewhat ham-fisted attempt to unilaterally disavow an undertaking made only a few months ago. My Lords, I agree with those sentiments, and I agree with the reports of the Constitution Committee and the EU Select Committee, and the contributions here by their chairs, the Earl of Kinnoul and Baroness Taylor. And I will also support Lord Judge's motion at the end of this debate. But, my Lords, this is quite a big bill, and I really want to talk about something else. But before doing so, could I welcome my noble friend Baroness Hayman to this chamber and commend her speech today and the importance that she stressed of environmental standards, which relate to this bill as much as they do with much of the legislation which will be facing us over the coming months. The issue I want to talk about is state aid, which is in this bill, but it's rather superficially dealt with, and it needs to be clearer before this bill finishes its passage through this House. My Lords, Baroness Noakes, in a sense, in her contribution, referred to this. And Baroness Noakes and myself were members of a EU Select Committee which produced a report on state aid about 2 years ago. She and I rarely fully agreed on anything, but we do agree on the importance of this issue. My Lords, at its most acute, the issue of state aid could perhaps be epitomised by the issue in Northern Ireland. As a result of this, the agreement and the way the government are now pursuing the matter, through the Northern Ireland Protocol, Northern Ireland is to be part of the customs union and also, to a large extent, part of the single market. So if the Stormont government gave a subsidy or a preferential procurement, public procurement arrangement to, say, a Northern Ireland textile company whose main exports are actually to the Republic, and the Irish competitors objected, does EU state aid rule prevail, or does the UK internal market rule prevail? My Lords, it is clear we need a UK state aid regime, and it is fairly clear how that will relate to our international obligations under the WTO and under, hopefully, future bilateral free trade agreements. But it is not at all clear how it will operate in relation to the internal market, which is the focus of this bill. If that same Northern Irish company, main export, was to Scotland, what then would be the arrangements? And if it were to be England, would it again be different? Because there would be an equivalent objection from English-based competitors. My lords, the fact is that industrial policy, employment policy, and consumer policy, all of which are relevant to state aid considerations, are differentially devolved between the three devolved administrations and centralised in England, but not in the UK. And of course, even in England, there is also the expected intention to devolve more industrial and employment policy to the English regions. So the question could, at some stage in the future, apply to Greater Manchester, which might have a different industrial and employment support system from that in the West Midlands, say. How does that play out in the new state aid framework? And indeed, the central question here is there yet a draft framework for all of this in relation to state aid, at least between the UK government and the Scottish, Welsh and Northern Irish government? And if not, what does the government think it should look like? And above all, how should it be enforced? Is the Office for Internal Markets, OIM, due to be established within the CMA, wholly a creature of the UK government, or do the devolved administrations have a say in its governance and decision-making? My lords, if the EU regime, during the EU regime, the Commission state aid arm had authority over member states with prohibitions and fines at its disposal.
Speaking limit.
Is that to be the case in relation to the CMA? My lord, before the complete passage of this bill, we need to clarify these issues.
I call the next speaker, Baroness Sutton.
I would also like to add my congratulations to Baroness Hayman on her excellent maiden speech, and I look forward to hearing her speeches in the future. My lords, what is remarkable, perhaps, about the speeches we have heard this afternoon is the overwhelming majority agree on all sides of the House that this bill is both unnecessary and deeply damaging. My lords, as has been pointed out, we only have 4 minutes, and so I will make 3 points. The first is simply to recall, as other noble lords have done, that this is a problem of the government's own making. The fact is that the Prime Minister insisted that it was possible to do 3 incompatible things. As Lord Clark so eloquently explained, the government insisted that the whole of the United Kingdom could leave both the customs union and the single market, while simultaneously avoiding a hard border on the island of Ireland, as well as down the Irish Sea. And so their solution was the Northern Ireland Protocol. Just 10 months ago, the Prime Minister was referring to the withdrawal agreement with the protocol attached as fantastic and historic. The Northern Ireland Protocol, which I believe is far from perfect, is nonetheless a carefully constructed compromise to try to maintain peace and stability on the island of Ireland and to protect the Good Friday Belfast Agreement. My second point is that this bill in reality does very little to address the actual problem about which ministers claim to be concerned. It does nothing about checks on goods crossing from Great Britain to Northern Ireland, and only theoretically providing a power relating to avoiding checks in the other direction. If the UK government is concerned to ensure that everything possible is done within the protocol to facilitate GB/NI trade, it has the legal means at its disposal through the Joint Committee. And my third and final point is this. The people in Northern Ireland from all communities have been let down too often already by this government. It is just less than a year since the executive installment was restored. The progress made in the last 20 years is not something which can or should ever be taken for granted. Repeated polling makes it very clear that a majority of people in Northern Ireland recognise the need for the protocol despite its challenges. They do not want the government to break international law on their behalf. Businesses need economic certainty, and the people of Northern Ireland deserve much better than being used as a political football in the Brexit talks. The solution is clearly to negotiate a better, closer deal between the EU and the UK, and then to use agreed mechanisms to protect trade between Great Britain and Northern Ireland. If this bill was intended to strengthen the mechanisms that hold together the United Kingdom, then it is clearly not succeeding. If this bill was a short-term tactic to strengthen the government's negotiating hand, then it is hard not to conclude that the loss of trust that it has generated will do long-term harm to our international reputation.
I call the next speaker, Lord Howard of Rising.
My Lords, comments of genuine legal concern criticising Part 5 must be respected, however disproportionate. My Lords, most of the adverse comments are frankly sour grapes from Remainers. That Britain would lose its reputation by passing this bill is nonsense. There are endless examples of EU bad behaviour. The French shepherding illegal immigrants into British waters, the EU willfully breaking international law, as in the case of Airbus, etc., etc., etc. The EU ignores the law with complete abandon. To quote the EU Advocate General, it would be wrong to conclude that, once the community is bound by a rule of international law, the community courts must bow to that rule with complete acquiescence and apply it unconditionally. There's a very strong argument that Part 5 would not be in breach of international law. There isn't time to discuss detail, but the EU's behaviour means that various clauses of the Vienna Convention give the EU the freedom to implement, give the UK the freedom to implement Part 5 if required. If anyone is in doubt, let me quote the noble Lord Pannick, one of this country's most distinguished advocates. If, therefore, the UK and EU were unable to reach an agreement on Northern Ireland and Ireland, despite good faith negotiations and despite the arbitration procedures, and if the UK were therefore to be faced, against its will, with a permanent backstop arrangement, the UK would be entitled to terminate the withdrawal agreement under Article 62 of the Vienna Convention on the Law of Treaties. Furthermore, Clause 38 of the Withdrawal Agreement Act, passed by your Lordships, fairly and squarely confirms the supremacy of Parliament. This bill gives the power to act if Parliament so agrees. The bill itself does not initiate anything, so whatever view you take, the passing of the bill is not an illegal act. My Lords, the withdrawal agreement was signed in expectation of reaching a reasonable agreement. For the EU to threaten to withhold third country status or use the Northern Ireland Protocol to try and gain advantage in discussions is not acting in good faith. Monsieur Barnier, saying that not even a pat of butter may go between England and Northern Ireland, demonstrates this attitude. It is an example of the view expounded by Verhofstadt's team that Great Britain will become the EU's first colony. It is how Britain has been treated throughout negotiations. Last Thursday, their council arrogantly restated their opening position was their continuing position. This is not negotiation, but dictation. With no clear argument against Part 5, we must put the interests of our country first and foremost. We must do our best to achieve what the people of Great Britain have consistently voted for and rid ourselves of EU control. Including Part 5 will show the EU that we are not a colony and are not prepared to be treated as one.
Yeah.
I call the next speaker, Baroness Andrews.
My Lords, it's with great pleasure that I join with others in welcoming the noble lady, Lady Hayman, to this House to congratulate her on her speech, and I'm sure we will hear many marvellous speeches from her, and to say how good it's been to hear her in this a remarkable debate this afternoon. In respect of Part 5 of the bill, I would simply say that the reasoned amendment in the name of the noble and learned Lord Judge speaks entirely for me. And the changes that are made in this bill in another place, which simply make Parliament an accomplice in breaking the rule of law, are totally unacceptable. But I want to focus on the risks in the bill, and particularly on the way the bill threatens to restrict the existing powers of the devolved administrations by imposing overriding constraints on the scope of the common frameworks, and I declare my interest as the chair of the Scrutiny Committee on Common Frameworks. For the past 3 years, and in the context of the incorporation of European law, the 4 countries of the UK have worked hard to create new consensual common frameworks specifically in order to secure a well-functioning internal market. Of the 40 or so frameworks in progress, some will carry their own legislative competence, but they will all, as appropriate, have their own dispute mechanisms in place. This has been done on a collaborative basis by agreeing common standards across agriculture, the environment, health and safety, but all balanced by the respect of the devolved administrations in the future, as in the past, to diverge in detail as they see fit. This managed divergence has led and will lead in the future to welcome innovation, not least, for example, for Scotland to introduce a minimum alcohol pricing, for Wales a more rigorous approach to single plastics or to refusing GM products. So far, so good. The genius of the process is that cooperation and flexibility has built a stronger foundation of trust between the 4 nations just at that time when intergovernmental arrangements have been at their most challenging. And despite the brake on progress that's been caused by the no deal preparations and now the pandemic, we expect 5 frameworks to be agreed in the next few months, more to follow shortly. This bill, my lords, according to the chairs of both the Constitution Committee and the EU Committee, threatens to frustrate and disrupt progress made so far and undermine future cooperation, because it does indeed, despite what the Minister has said, it provides the government with powers to alter the competences of the devolved administrations. Scotland has already withheld consent. Wales and Northern Ireland are deeply provoked. Specifically, the provisions for mutual recognition and non-discrimination would generally require that goods and services that could be legally sold or provided in one part of the UK would have the same legal right to be put on the market in every other part. My lords, forget chlorinated chicken. Wales could not even require different labelling to show the higher levels of fats in a food product. If England were to allow hormones in beef cattle, Scotland could not prevent the import and sale of such cattle. And unlike the European precedent, the only goal is to remove potential barriers to trade at all expense. All other public policy goals are abandoned. These restraints on devolution set out in these extraordinary and unprecedented delegated powers came as a shock to the devolved governments. Far from being designed for cooperation, the devolved governments were not even consulted. And they see it as creating new risks as well as an attempt to reduce their powers. So my fundamental question to the Minister once again is, why is this bill necessary? What is there to gain from it, which cannot be achieved by the common framework process, principles and process? Why take these risks? It cannot be that this bill will provide a dispute mechanism, because each framework already has that to resolve differences. Today, the government received a unique and stern warning from church leaders across the UK not to risk destroying the trust that binds the 4 countries. My lords, I hope that the Minister will not only listen to what the House is saying, he will have the wisdom and grace to change the government's mind.
I call the next speaker, Lord Bridges of Headley.
My Lords, I support almost everything in this bill, although I do regret that Part 5 is in there. I regret that the Prime Minister told members of Parliament last October the treaty is, and I quote, a great deal for the entire country, a great success for Northern Ireland, and that the protocol is, and I quote, an ingenious scheme, but now he wants to rip it all up. I regret, therefore, that the government either did not understand the implications of the treaty and the protocol, or that they did understand its consequences, but privately always intended to breach the treaty. For the issues which the government see as a pretext for breaking their word at some future date have existed and been debated at length for the past few years. And this is precisely why the treaty contains processes to deal with them. Consequently, I regret the government has decided to call into question the treaty before exhausting the dispute resolution process the treaty contains. Yes, my lords, Parliament will be given a vote before these powers can be used. But let's not forget, the government's original plan was no parliamentary vote, which, I regret, says a lot about the government's intent. Furthermore, I regret that it appears that the very introduction and enactment of the bill is in breach of the UK's international obligations, even before these clauses are brought into force or used to make regulations. And I would ask my noble friend Lord True to confirm whether this is so when he winds up. More broadly, my lords, I regret that we are being told by some, just because other nations may disregard treaties they have entered into, somehow this justifies us breaching a treaty we have entered into in good faith. Two wrongs do not make a right. The Prime Minister once said, and I quote, "The rules-based international order which we uphold in global Britain is an overwhelming benefit for the world as a whole." I agree. I just regret that Part 5 is now calling this into question. Above all, I regret that Conservatives, who want to support the government but believe in upholding the rule of law, are being asked to choose between party and principle. What is at stake is not leave or remain. What is at stake here is our approach to public life, how we think about our place in the world, whether we think it still matters that Britain's word is its bond, and of course, underlying all of that, our belief in the rule of law. My noble friends Lord Callaghan and Lord True are men of integrity. I have known my noble friend Lord True for decades, and I will always see him as a good friend. But on this, we differ. Principle comes before party, and so, with regret, I will be voting for the noble and learned Lord Judge's motion.
I call the next speaker, Lord Campbell of Pittenweem.
My Lords, I too congratulate the noble Baroness Hayman on an outstanding maiden speech. But, my Lords, there's little time for niceties because I believe that this is a contemptible bill, in turn contemptuous of law and contemptuous of Parliament. We must, I suppose, thank the Secretary of State for Northern Ireland for his frankness, which may yet cause him to lose his cabinet place, admitting at the outset the illegality inherent in the bill. The noble Lord Lilly suggested that that should now be disavowed. Well, the noble Lord Callanan, had that opportunity when he opened the debate, but far from disavowing, he chose not to mention in any detail whatsoever the particular clauses of the bill which are the most controversial. Following the Secretary of State for Northern Ireland's admission, an amendment was passed in the House of Commons, and there are those who argue that that amendment somehow cures illegality. My Lords, an illegality, whether authorised by Cabinet or Commons, is still an illegality, and it is misleading to claim otherwise. But I go further, my Lords, and I believe it's an abuse of this House to ask us, in relation to a bill at this stage, when we are encouraged to accept the principles contained in it, to invite us to accept the principle of illegality. My Lords, like several noble lords have spoken, I have the privilege of holding the commission of Her Majesty as one of her council, learned in the law. Will those who support the government please tell me how I can fulfil the obligations and responsibilities of that privilege by endorsing the illegality contained in this bill? And if anyone is still in doubt about illegality, they should read the analysis of clauses 42 to 45, produced by the Bingham Centre. They should tell us which parts of that analysis they disagree with. And they should go further. They should tell us what conclusions of the Constitution Committee of this House they regard as being not well-founded. And generally, they should tell us how we discharge the obligations and responsibilities of membership of this House by endorsing illegality at the whim of the government. Well, Lords, we regularly recognise the legacy of John Major and Tony Blair in the production and the continued observance of the Good Friday Agreement. But no one in government paused to reflect on the importance of the Good Friday Agreement in the domestic politics of the United States. Noble Lords better believe the words of Speaker Pelosi. There will be no trade deal for Britain with the USA if there is any adverse impact on that agreement. The fact, my Lords, is this, that whether the government in the end exercises the power to commit illegality or not, the damage is done, the reputation besmirched, and the credibility of the United Kingdom undermined. My Lords, this is shabby business, and we should have none of it.
Lord MP.
May I congratulate the noble Baroness on her maiden speech, and I look forward to many more on a variety of subjects. This bill illustrates how our Constitution has been evolving in such a haphazard way over the last 2 decades, with ill-thought-through lurches into various forms of devolution without a comprehensive plan to coordinate them. We have succeeded in falling out with the devolved administrations and have the consent of none. I want to speak to the clauses 45, 44, 5 and 7, but the reason they exist at all has its roots back in decisions taken 1 year ago. On the 2nd of October 2019, Her Majesty's Government produced a proposal for an amended protocol on Ireland, Northern Ireland. It was entitled Explanatory Note. This note said it was based first and foremost on our commitment to find solutions which are compatible with the Belfast Good Friday Agreement. Well, my Lords, if that was the commitment, it has not been met. The explanatory note did the following things. It proposed to establish a regulatory border in the Irish Sea, requiring checks on goods and produce moving between Great Britain and Northern Ireland. It required the establishment of border inspection posts, and as required by EU law, and traders moving goods from Great Britain to Northern Ireland need to notify the authorities in advance. Her Majesty's Government proposed the establishment of a regulatory border in the Irish Sea with border control posts and the ongoing involvement of the EU courts in Northern Ireland. How on earth is this compatible with unionism? For some inexplicable reason, the explanatory note of the 2nd of October was endorsed by the Democratic Unionist Party. Arlene Foster issued a statement describing it as a serious and sensible way forward. This opened the floodgates for Brussels and Dublin, and 2 weeks later the deal was done. How any unionist can support any kind of border in the Irish Sea escapes me. The establishment of this border and the arrangements contained in the subsequent withdrawal agreement are a clear breach of the Belfast Agreement. These proposals change the status of Northern Ireland and have the same negative effect as having a land border, which everybody has sought to avoid. Her Majesty's Government now sees paragraphs 44, 45 and 47 as essential to keeping some semblance of cohesion in the United Kingdom, illustrating the shoddy nature of the negotiations conducted last year. I have little doubt that some EU negotiator did threaten to prevent food coming from Great Britain to Northern Ireland, and that individual must have very little knowledge of Irish history. Nevertheless, to plunge ourselves into a legal quagmire and various constitutional contortions is not the answer. There is another way. Instead of blethering on about the Belfast Agreement, which has been used as a political football by Brussels, we should use it as part of the answer. It never ceases to amaze me that those of us who negotiated the agreement are never consulted about its intentions or how some legislative proposals might affect it, even though there are many of us in your Lordship's House. The UK could legislate to prevent our territory being used for the export of non-compliant products into the EU market. We could also indemnify the EU if non-compliant products succeeded in getting through. We could, by treaty, establish another cross-border body aimed at educating businesses and preventing any single market contamination, and joining the EU to that treaty if some additional devolution to Stormont was initiated. How, my lords, are we in such a mess because of trade flows across the land border, which accounts for 1.6% of Ireland's total imports, or to put it another way, 0.1% of EU trade flows? If we can break a protocol that we ourselves proposed a year ago, even though I continue to oppose it, then all bets are off with regard to Scotland, Gibraltar and the Belfast Agreement itself. Precedent, dear boy, precedent.
Next speaker, Baroness Boothroyd.
My Lords, I was elected to Parliament some 47 years ago and have witnessed 9 Prime Ministers tread the steps of number 10 Downing Street. But never in my parliamentary experience have I witnessed such a collapse of the people's trust in a government that promised so much and so quickly and is now groping for desperate solutions to problems it said would not arise, or if they did, they could easily be resolved. I've listened. It has been a privilege, quite frankly, to listen to such fine speeches this afternoon. Perhaps I thought they were fine because I agreed with most of them. But let's not beat about the Euro bush. The Prime Minister set the course we're on and shows no remorse for steering it off course. The claim continues to be made that a no-deal end to our membership of the European Union is nothing to worry about and that we have every right to break a clause in an international agreement because we don't trust our European partners. My Lords, it is our European partners who joined us in signing that very agreement. Future historians won't need a test and trace operation to find those responsible if we end up in a legal battle in the Supreme Court and an economic crisis that rivals the 1930 Depression. I was a young girl in the 30s and saw the poverty and misery it caused at close quarters. So, of course, I'm alarmed when I read that the noble Lord Agnew, a Cabinet and Treasury Minister, was reported to have said that British businesses and commerce are not as ready as they should be when our new terms of trade start with Europe in January. What terms of trade is he talking about? Those I know are working in business and commerce would certainly love to know. Also, may I ask the government, can we break future terms as easy as we appear intent on breaking the Northern Ireland Protocol if we don't like the way they work after January? The noble Lord Agnew's low regard for British industry and commerce went even further. He was reported to have said that our traders had their heads in the sand as they approached January's deadline. I'm sorry he didn't heed Dennis Healy's advice. When you're in a hole, stop digging. The blame game has evidently been begun, and the PM started it. He dictates the strategy and blames others if it doesn't work. No sooner had the Prime Minister finished his sunshine forecast on Friday of the prosperity he claims that would surely follow a no-trade agreement with the EU, that a New York analyst made a withering comment that actually took my breath away. Our credit rating had just fallen dramatically, but he didn't write us off. He didn't spare us either. He said, and I quote, "The quality of the UK's legislative and executive institutions has diminished in recent years," unquote. Who can deny it? The Prime Minister's claim that we shall survive no deal because we have, quote, high hearts and complete confidence in the future and be exposed to what it is. It's a sham. The latest line from Downing Street is that we shall insist on legal text in future negotiations. If the government, my lords, had paid close attention to Article 10 of the Northern Ireland Protocol before signing it, they would not need to override it in this bill. Trust, you know, I think, in this government, both nationally and internationally, is in short supply. But our parliamentary democracy has deep roots, and I trust this House will defend our laws and traditions. Who knows? There's still time for yet another U-turn. And one thing I'm certain, we shall not deserve our reputation and regain our self-respect until once again the world knows that our word is our deed and that we are committed to the rule of law. Thank you.
I call the next speaker, Lord Forsyth of Drumlene.
My Lords, as President of the Steamboat Association, I know a bit about boilers. They are potential bombs and have the capacity to blow a vessel to smithereens. By law, they must be tested annually and have 2 safety valves to release steam if the pressure exceeds a safe level. The second valve is there to deal with the unlikely failure of the first. In the words of Lord Judge, it doesn't cure the fault, but it does prevent the destruction of the ship. This bill provides for that second safety valve in the event that the EU does not respect the disputes procedures under the withdrawal agreement, does not comply with its duties of sincere cooperation, and threatens the very integrity of our United Kingdom. After all, the withdrawal agreement was signed on the basis that a trade deal would be implemented in 2020. The Canada-style free trade deal was offered by Mr. Barnier, but now we're told is no longer available. It's easy to make a case now that the EU is negotiating in bad faith, a point made by my noble friends Lord Howard and Lord Lilly. I've some experience of this kind of duplicity on the part of the EU, which I shared with the noble Lord Kerr. I go back to John Major's opt-out from the social chapter, where we thought that that meant employment policies were now subject to a veto by us. But hey-ho, the EU decided that working time was a health and safety measure and therefore subject to qualified majority. And the advice from Lord Kerr and others, as I recall at the time, was there was no point in us going to the court to argue on a point of law because the European Court would always advance the acquis and was a political court. So let's not be starry-eyed about how the European Union acts in the interests of the rule of law. Now, Lords, I very much regret that my right honourable and noble and learned friend, Lord Keane, is no longer on the front bench, and that he was forced to resign, even though he launched a lifeboat for the government. My right honourable friend suggested that the Northern Ireland Secretary had answered the wrong question in the Commons when asked if it breached or potentially breached the law. He was making the point that potentially was the right answer. As Advocate General, he told the House, "In my opinion, the present bill does not of itself constitute a breach of international law or of the rule of law." That's good enough for me to support this bill being given a second reading. It is for the committee stage to consider this further. And I would ask my noble friend, Lord True, to make it crystal clear in his wind-up tomorrow that these provisions in Part 5 would only be used in extreme circumstances and be subject to parliamentary approval. I have enormous respect for the noble Lord Judge, although comparing this to the abuses of apartheid did seem to me to be a little over the top. And of course, my noble friend, Lord Cormac, who is assiduous in his work in this House, but I cannot vote for the regret motion, which is nothing more than parliamentary graffiti. The bill was passed by a huge majority in the House of Commons, and despite the motion, the regret motion before us, and more than 100 speeches, it will be given a second reading in the House tomorrow. Only the Liberals, with their miserable mandate at the general election, have contemplated throwing the bill out. Rightly so, for this bill protects, enhances and strengthens the union. More than 500,000 jobs in Scotland depend on the integrity of the internal market, and scores of powers are being returned from a supranational bureaucracy to our elected representatives. The very act of union itself was about creating a barrier-free internal market, and it has brought about more than 300 years of prosperity. I can't tell the House how disappointed I was to see the Most Reverend Primate, the Archbishop of Canterbury, putting his name, together with other senior Anglican bishops, to a letter in today's FT headlined, "Internal Markets Bill Undermines Strength of the Union." Those who wish to break up Britain will be much encouraged by their efforts.
I call the next speaker, Lord Haskell.
My Lords, may I too welcome my noble friend Baroness Hayman and congratulate her on her maiden speech. My Lords, I serve on your Lordship's Delegated Powers and Regulatory Reform Committee. This committee was formed in 1992 to deal with the growing tendency of governments seeking wide order-making powers, which gives ministers unlimited discretion. My Lords, this bill is a prime example of why this committee is needed. We draw your Lordship's attention to 11 delegated powers in the bill, which include 7 Henry VIII powers, to which the noble Lord Judge referred. Powers which allow ministers to amend, repeal or modify an act of Parliament or a statutory instrument. And under clauses 42, 43 and 45, ministers are able to disregard any international domestic law which ministers consider to be incompatible or inconsistent with the Northern Ireland Protocol. And this is why in paragraph 2 of our report we say that some of these powers are extraordinary and others are unprecedented. As the Minister explained, the stated purpose of the bill is to allow free trade within the United Kingdom. Clause 3 states that any item permitted to be sold in one part of the United Kingdom under devolved legislation, that item automatically is available for sale in other devolved areas under the mutual recognition of goods. And this means that the lowest standard becomes acceptable. And what is more, this requirement applies not only to the goods themselves, but also to their packaging, their labelling, their assessment, registration documentation, as my noble friend Baroness Andrews explained. And this, in spite of government assurances that our standards will not fall when we leave the EU. So standards become a race to the bottom, as Lord Bruce explained. Your committee's view is that that clause 3 should be deleted, and I understand that amendments will be brought forward to do this. And there are further clauses in the bill which override powers granted to the devolved administrations regarding such things as consumer protection, financial aid, social welfare. Indeed, powers are granted to UK ministers to spend money over the heads of devolved administrations, even on devolved matters. Now, clauses 42 and 43 allow ministers to disregard provisions of the international or domestic law for technical reasons. And this is one of the unprecedented powers to which our report refers. When your Lordships reported in September, the bill was in the other place. And as we say in our note dated the 13th of October, the government did not take the opportunity to address the points which we raised. And it seems to me that this disregard of the arguments of your Lordship's committee is yet another example of this government seeking to impose its will rather than to seek parliamentary approval. And in doing so, they ignore the public interest in matters of law, of diplomacy, of the nation's integrity, and this undermines the integrity of public life and allows ministers to break the ministerial code. The only justification seems to be that ministers need these powers to act quickly, especially in an emergency. Well, Parliament can act quickly and act in an emergency, and speed is no reason for imposing the will of ministers on the devolved administration in this divisive manner.
Speaker, Baroness Humphreys.
My Lords, it's been a great privilege to listen to the speeches of noble lords today, especially to those who've given voice to the concerns of so many of us about this bill and the impact its invitation to collude in the breaching of international law has already had on the UK's standing on the international stage. Politicians in Wales are equally deeply concerned by the contents of this bill and the implications it has for Welsh devolution, and none more so than David Melding, the highly respected and long-serving Conservative Senedd member who resigned his position as Shadow Counsel General last month. He cited the need to be able to speak out against what he considers to be, and I quote, a lack of statecraft at this crucial time for the UK's very survival as a multinational state. And my Lords, it is those three words, lack of statecraft, that are the most telling, a stinging criticism from one of the Sened's most loyal Conservatives, and are three words that to me sum up what is so wrong with this bill. Statecraft involves diplomacy, cooperation, consultation, consensus, but these are words no longer to be associated with the delivery of the UK's internal market. And despite the Minister's conciliatory words and tone into introducing this debate, the words on the face of this bill tell another story. It is clear that the UK government's response to dealing with devolved governance issues that arise will be to resort to government by diktat. For example, the principles of mutual recognition and non-discrimination, according to this bill, are to be applied to all goods and most services with a highly limited list of exceptions, which can be changed by UK ministers by secondary legislation without consultation with the devolved administrations. This is seen in Wales as a fundamental assault on devolution, preventing the Senedd from carrying out its duty of protecting the citizens of Wales from substandard goods and services. The proposal that UK ministers should take new funding powers to enable them to fund hospitals and schools in Wales without consultation with Welsh ministers who have the devolved responsibility for these areas is provocative, as is the threat that they would build the M4 relief road against the decision of the Welsh Government, a decision endorsed by the Senedd on cost and environmental grounds. This attempted chipping away at the powers of the Senedd is, my Lords, an example of Westminster colonialism at its worst. I understand the government's dislike of the EU flags seen on Objective 1 projects in West Wales and the valleys, and I understand their need to see the Union flag on new projects. But far better to make an investment in areas which aren't devolved and which the UK government have actually been responsible for years and neglected. The irony of all this, my Lords, as many speakers have already said, is that this bill is mostly unnecessary. Continued work on common frameworks with the devolved administrations would ameliorate the impact of this bill. The work already carried out by the devolved administrations, your Lordships Committee, and the UK government up to now has been an example of statecraft at its best. And most worryingly, the imposition of decision-making by Whitehall in areas of devolved responsibility will do nothing to aid the UK's survival as a multinational state.
Speaker, Lord Lamont of Lerwick.
My Lords, I want to concentrate on Part 5 and Lord Judge's amendment. I have already publicly criticised the statement by Brandon Lewis that the bill breaches international law. Since the government have not withdrawn that statement, I have no choice but to vote for Lord Judge's amendment. But I confess I feel in a dilemma. I feel what the government is doing is certainly wrong. On the other hand, the provisions of the Northern Ireland Protocol are disastrous potentially. It's a choice of two evils. How can we break international law? On the other hand, how could we ever accept tariffs being levied on goods going from one part of our country to another, a border in the Irish Sea? It's not a trivial matter, as Lord Falconer suggested. It is a threat to the Good Friday Agreement. I'm also sensitive to the danger of undermining at this moment the government's position in negotiations if they resume. Many eminent lawyers have spoken in this debate, and their verdict has left nothing for the day of judgment. But is this really just a legal matter? The Northern Ireland Protocol is not a black and white, unambiguous document. It's full of contradictions and full of matters to be resolved later. My Lords, there are plenty of examples internationally where politics has trumped law. One thinks of the Maastricht Treaty and the ignoring of all its provisions on deficits and debt. The disputes between the German Constitutional Court and the EU have some parallels to our present standoff, as Lord Lilly suggested. Then there's the case of the United States tearing up the Iran nuclear deal. That was an agreement, like the withdrawal agreement, lodged at the UN, which was simply torn up because the new president took a different view. My Lords, one may regret these things, but I think it is fanciful to suggest that the provisions in this bill would prevent us criticizing human rights in China. There is one important point I think the House needs to bear in mind when considering this bill. Even if the Commons votes to commence taking the powers in Part 5, the House of Lords is still able to overturn the policy by voting against the statutory instruments that would negate the protocol. I would ask my noble friend Lord True, who knows a huge amount about procedure, perhaps more than anyone else in the House, to confirm that this interpretation is correct. And even after enactment, there will still be opportunities for the Lords to vote against the government if it chooses to activate the policy. My Lords, the government should never have got into this position. I'm not convinced by their protests that the EU is not negotiating in good faith. If you lose a negotiation, it's easy to accuse the other side of acting in bad faith. But the problem that we have has been staring us in the face ever since the protocol was agreed in October 2019. That very month, the then Brexit Secretary told the Lords EU Select Committee that there wouldn't be export certificates between Northern Ireland and GB. A few hours later, he withdrew his answer and admitted that there would be. But the PM continued in denial and said, including during the election, if anyone got such a document, they should tear it up. My Lords, today the government is trying at the last minute to strengthen its negotiating position by rescinding what it had previously foolishly accepted. I do believe the government has made a mistake in trying to take these powers. Lord Judge's amendment regrets the Part 5 provisions. What follows from the amendment, if it's carried, is for us to decide later. But since I certainly do regret what the government has done, I shall vote for the amendment.
The next speaker, Lord Rooker.
My Lords, I welcome the maiden speech of my noble friend and look forward to hearing others. My Lords, the Constitution Committee, in its summary of the bill, mentioned amongst others the following words, and I quote, "Does not justify. It is regrettable. Engagement has been poor, limited and unsatisfactory. Consultation is problematic. Does not mention common frameworks. No time for adequate reflection. Delegated powers are extraordinary and unprecedented. Many are constitutionally unacceptable. Should explain whether Clause 6 seeks to constrain Parliament's lawmaking power. end quote. It's therefore legitimate to ask about the drafting of the bill. 20 years ago, when a minister in the other place, there was an occasion I had to call a halt to a standing committee where I was in charge of a bill. The details are unimportant, but it was then, and only then, I discovered that policy officials do not talk to Parliamentary Counsel who drafted the bill. They commission the department's lawyers who then brief Parliamentary Counsel. I presume this is to lock in the client legal privilege rules. So it's clear, government policy officials have briefed departmental lawyers to request Parliamentary Counsel to draft a bill which, amongst other things, appears to constrain Parliament's lawmaking powers, constrain the judicial review function so as to put ministerial regulation-making powers above the law in an unprecedented manner, and Parliamentary Counsel have carried out that instruction. That, I think, is worrying. Our role in the Lords is to protect the parliamentary process. For this House, it should be a red line. This bill has the seeds of undermining the primacy of the House of Commons. I'll repeat that. This bill has the seeds of undermining the primacy of the House of Commons. Are there any limits as to what can be put in legislation, or will Parliamentary Counsel simply use the Nuremberg defence? As the Joint Committee report on conventions of the UK Parliament in October 2006, in quoting Lord Wakeham, made clear, the Lords should be very careful about challenging the views of the Commons on any issues of public policy. My Lords, it is not an issue of public policy to agree legislation which neuters the parliamentary process, and neither the government nor the Commons can claim it is. As such, this bill, which is in no way a manifesto bill, requires substantial amendments and deletions. And afterwards, I think we should hear from Parliamentary Counsel as to whether they operate within any boundaries with respect to defending the parliamentary process. Thank you.
Next speaker, Lord Wigley.
My Lords, I warmly agree with the words of Lord Rooker, and may I congratulate Baroness Hayman on her fine maiden speech, particularly welcome her Welsh half and her comments on devolution, on rural affairs and on the environment. My Lords, I oppose this bill, which goes way beyond the policy proposed by this government at the general election. And so I believe that this House would be totally justified in refusing to give it a second reading, as the government has no mandate for it. I salute the fine speech by Lord Judge and unite with him in saying, not in my name either. My Lords, this bill gives draconian powers to UK ministers over matters which have been long-standing devolved responsibilities. Those powers which return from Brussels should automatically come to the devolved governments. And if there's a need to establish an all-UK position on some such powers, that should be negotiated between the four governments and implemented when there is consensus. I won't repeat the points made so effectively by the noble baronesses, Baroness Hayman and Baroness Andrews. There is a real belief across party divides in Wales, and expressed by Labour, Plaid Cymru, Liberal Democrat Senedd members, yes, and even by some Conservatives, that the bill in its present form just isn't acceptable. The Welsh Government have lobbied members of this House, begging us to reject the bill as it stands. They make three salient central points, highlighted by Lord Newby. Firstly, the bill would destroy the hard work undertaken by the Welsh Government, in cooperation with other governments in these islands, to establish common frameworks. It would emasculate the Welsh Government's regulatory powers, ranging from the food sold in Wales to the qualifications of teachers in our schools. Secondly, the spending powers abrogated into themselves by Westminster ministers would undermine expenditure policies currently pursued by the Welsh Government, such as free school meals or the funding of road schemes like the M4 Relief Road. If the UK Government asserts that such funds are additional to the Barnett block, let them write that onto the face of the bill, and then it might well be considered. Otherwise, it's a case of Westminster telling Wales how money within the devolved Welsh bloc should be spent. And my Lords, that's just not on. Thirdly, the intention to make state aid and subsidy policies reserved matters gives Westminster ministers control over economic development throughout the UK, when in fact, in that regard, their actual powers are only currently applicable to England. Such steps would demolish the successful buy local policy applied by successive Welsh governments in procuring products and services, a policy which helps bring Welsh unemployment levels down to the UK average level. And the bill gives powers to UK ministers to intervene in Wales over water infrastructure, sending a shiver of dismay that we are about to see yet another Tryweryn foisted upon us. Our experience with Tory government promises of major capital expenditure schemes in Wales over the past decade has been disastrous. They promised to electrify railways, facilitate electricity generation projects, a new Wilva in Anglesey, tidal lagoons around the Welsh coast. They insisted on keeping power in Westminster. They just haven't delivered. Every such election pledge has been broken, so why on earth should we trust them now? And this bill, in terms of breaking solemn commitments, surely goes way beyond what is acceptable in terms of its unilateral abandonment of international treaty commitments. It establishes beyond doubt that the government's word isn't worth the paper on which it is written. And the challenge to this House is to insist that we will not pass any such legislation in our name.
Speaker, Lord Howell of Guildford.
My Lords, I join in congratulating and welcoming Baroness Hayman. But I'm sure most of your Lordships would agree that after the defeating of COVID-19, the highest priority for our country, if we are to face the challenges of the next 10 years, is to hold this United Kingdom of ours together. And the problem is that devolution has created a whole world of delicate compromises and unfinished constitutional business. And then onto this scene comes the bill, which I'm afraid is a bit like a ball in a china shop. My question on the whole devolution side of the bill is this. I admit the timing may be unavoidable, but why, as the chairman of the Constitution Committee, Baroness Taylor, was asking, why on earth could not these issues between the different parts of the kingdom be handled mostly within the common framework procedure or consensually? Why was it decided to try and codify in law the 1,001 different complex and ever-shifting connections between all the myriad businesses in and across the devolved regions, rather than address them as they come along, which they will unceasingly, by ongoing practical cooperation, or just maybe by setting up the new Internal Markets Office? As to the rule of law clauses, which have so greatly disturbed your Lordships and disturbed the legal profession, and indeed many of my good friends, including the noble friend Lord Howard, and now the Archbishops as well, I am a little less worried than some of my colleagues about that. It's quite correct, as the Constitution Committee report pointed out, that the late Lord Bingham warned against a government that routinely, and I repeat the word routinely, disregards its international law obligations. And I would not wish to live for one moment under such an administration. But the reason I'm not so worked up as some are in this instance is that I believe we may be overlooking the degree to which the whole spirit of the Withdrawal Treaty and the Northern Ireland Protocol was already being undermined and is now being undermined by the other party, namely the Brussels negotiators and their legal advisors. I believe this is just what the Lord Chancellor meant when he rightly advised the Constitution Committee to consider the context he emphasised, behind the need for this bill. And here too we are in an area of delicate ambiguity and compromise, as Northern Irish affairs always have been, and the Good Friday Agreement was as well, and as I know full well from my years of working there at the height of the time of violence. So here too my question, before rushing to judgment, is why was it that these tangled problems of treaty interpretation, because that's what they are, were not handled in the Joint Committee for Settling Disputes, which the Withdrawal Treaty sets up? What happened in that committee? Was there a deadlock? Did the EU side make threats which were, in the Prime Minister's words, extreme and unreasonable and undermined the Withdrawal Treaty? So were these clauses put into this bill, in fact, justified as a response on that account? And when it comes to would-be violations of the treaty spirit, are the critics, which we heard so many this afternoon, quite sure that they're looking entirely and solely in the right place? We've asked these questions, but not got no clear answers so far. So please, can we have them now? Can we have a bit of chapter and verse about what actually went on in the Disputes Committee? I know this won't assuage my distinguished legal friends, nor the church leaders, but at least it would explain more fully why the clauses got into the bill and why they were felt to be necessary. And maybe it might persuade me to oppose the two regret motions, even though they have been moved by your lordships and they're most eloquent and by people I most admire.
Brockwell.
Congratulate Lady Hayman of Alloch on her maiden speech, which I heard with great pleasure from the Strangers' Gallery. In the limited time available, I will not dwell on the anxiety and shame I feel about Part 5 of this bill, which others have expressed so eloquently. I hope and believe that your lordships will assent to the motion in the name of Lord Judge. I also hope that in the next few weeks agreements will be reached with the EU which enable the government to assent to removing these clauses from the bill. In passing, I agree with Lord Campbell and others that the amendment passed in another place, that these clauses would not be brought into effect without a positive vote in the Commons, is not sufficient to remove the mischief. These clauses contain a threat which should never have been made and which must have no place in the United Kingdom Statute Book. I invite the noble Lord Forsyth just to consider the precedents that they would provide for an unscrupulous government in the future. My Lords, I want to address my remarks to the situation which will arise if the government seeks to maintain the clauses and can get a majority in the House of Commons to that end. Your lordships will then have to decide whether we maintain our opposition to them in the face of a majority in the elected House. I've argued in the past and continue to believe that this House must recognise the constitutional limitations on our power and must ultimately defer to the elected House. But, my Lords, the issues on this occasion are of a different order. The Northern Ireland clauses in this bill go to the roots of our Constitution. On this occasion, my Lords, the power is in your Lordships' hands, and we may not be used to that. The government needs the internal market provisions in this bill by the 31st of December. They cannot, therefore, use the Parliament Acts to get the bill through. If this House is resolute in rejecting the unacceptable Northern Ireland clauses, the government will have to agree to remove them if they are to get the bill passed. The issues here are the rule of law and our Constitution, as well as our national reputation. I believe that it is the role and duty of your Lordship's House to defend these things, even in the face of an overweening executive with a majority in another place. And I urge your Lordships to be resolute in doing so. We can prevent this disaster.
Call Lord Mackay of Clashfern.
My Lords, I wish to congratulate Baroness Hayman on an excellent maiden speech and look forward to many others. I regard a bill dealing with this subject as highly desirable, as the present law is principally contained in EU retained law, not easily accessible to our citizens. During the discussion of the 2018 withdrawal bill, the question arose of where powers released by the EU went in the level of our constitution and I took the view that the internal market powers went to the UK Parliament as legislative authority for them had to go beyond the geographical limitations of the authority of the devolved legislatures, but that it was highly desirable that any exercise of them were the subject of discussion and, if possible, agreement between all four administrations. The Scottish minister, with whom I was very happy to work closely at that time, was optimistic that agreement would be reached. The Joint Ministerial Committee on European Negotiations was already in place, and intensive work on securing common frameworks as the robust foundation for continuing cooperation has gone well. The Scottish Government has, I believe, played a constructive role in that work. Although the Scottish Government has formally taken up a distinct position, their support for independence has not prevented them agreeing to these matters and participating fully in them. I suggest that this bill would be greatly improved by providing that any issue to be the subject of a statutory instrument should be discussed in such committee and implemented only if it is agreed or otherwise after a full debate in both houses of Parliament, and that the Competition and Markets Authority should report to this committee as a matter of course.
I call Baroness Quinn.
My Lords, it's a pleasure to follow Lord Mackay of Clashfern and to recognise the work that he did in trying to make sure that we did have a good system of common frameworks across the United Kingdom. I'd also like to add my warm congratulations to my noble friend, Baroness Hayman, on her splendid first contribution in this House. The context of today's debate is, of course, the ending of the EU transition period and indeed the ever closer threat of ending that transition without a deal. Last week, the Prime Minister sent to all of us what I thought was an extraordinary letter, which not only repeated the usual misleading claims about the pro-Brexit referendum result, but then airily proclaimed that we were going to prosper mightily while completely ignoring the practical concerns and worries that businesses across the country, across our own internal market, have about the prospect of no deal. And perhaps I could ask the Minister, coming as we both do from the northeast of England, and given that the head of Nissan has said that Nissan Europe would be unsustainable if there is no deal and tariffs are imposed, is the government prepared to see that outcome? And how could such an outcome help its alleged policy, its stated policy, of levelling up the regions across the UK? It's against this background and the end of the transition period that we have to consider this bill. And my Lords, given that there is almost total support in Parliament and outside for ensuring that the UK's internal market does work properly and effectively after the Brexit transition, it is actually incredible that the government has managed to produce a bill that has been so roundly and universally condemned both in Parliament and outside. Inside Parliament, indeed inside this House, we have had powerful reports which I hope will get a lot of publicity from the Constitution Committee, from the EU Select Committee, and also from the Delegated Powers and Regulatory Reform Committee. Both inside and outside Parliament, we have had concerns expressed by eminent lawyers, by Lord Neuberger, by the report of the Bingham Centre, and indeed by the letter, which I strongly agree with, that the archbishops had published in today's Financial Times. The worries about the bill are of course, focused on the fact that it breaks international law and that it breaks it not just once, but actually provides for future breaking the law, and in some clauses exempts the government from judicial challenge, which again is a very dangerous principle. It also seems to break the ministerial code. Perhaps the minister can confirm whether this is true or not. It adds a lot of extra Henry VIII powers. And also, of course, it has managed to elicit opposition from the Scottish Parliament, from the Welsh Senedd, and from the Northern Ireland Assembly. I simply don't understand, and others have asked this question, but I'd like to reinforce it. I don't understand why the government did not decide to build on the common framework approach rather than coming forward with the provisions in this bill. The situation in Northern Ireland is very serious, and indeed became serious the minute the government agreed to establish an effective border in the Irish Sea. And I do hope that the comments that were made by the noble Lord MP, which I'm sure will be reinforced by my noble friend Baroness Ritchie of Downpatrick, will be taken on board and dealt with properly by the government. My Lords, in conclusion, opposition to this bill is strong, and it's not a question, as been alleged, of just moaning Remainers. It's strong because there's a strong feeling that this bill is not in our national domestic interest, and it also does huge damage to our international standing. And for that reason, I shall vote for Lord Judge's amendment, and I hope too that the House of Lords on this occasion will be prepared to use the powers that have been given to it in our Constitution and stand resolute, in the words of Lord Butler, which he spoke a few minutes ago.
Spent 6 days in committee on the trade bill debating how we make treaties and listening to the Minister say continuously how we will be a trusted partner around the world. I also regret that we are having to debate on how the government has breached one and intends to breach it more. And alas, I had also hoped to hear from the Minister in opening why and when agreed processes in the joint committee with the EU and joint ministerial committees with our nations broke down, and why those agreements were not able to be reached and therefore necessitate this bill. But I want to address parts 1 to 4, and I do so as someone who was born and lived on the border between England and Scotland and represented a border constituency all my life. So therefore, my personal, professional and political life, I have seen at close hand the daily interaction between laws, systems, standards, approaches, regulations, everything from licensing, trade, speed limits, even the COVID-19 regulations, building regulations and others, many of which predate the European Union in that approach. And I also have seen closely the work within the framework agreements, because I do recognise that there are powers that are being repatriated. The 2020 framework analysis by the government showed that of 154 policy areas where the EU law interacts with devolved competences that are being repatriated, 115 require no framework at all, 22 a non-legislative framework, but just 18 a legislative framework. Now, the Minister didn't refer to a defence of Part 5, but I was curious that he referenced whisky and this odd situation where it will be news to English barley providers that they are not able to sell to Scottish distilleries. They've never been barred from doing so since 1933 in the first legislation, and there's no restrictions. And it will be news to the distilleries who buy their malted barley from Simpson's Malt in my hometown in Berwick in England that there's somehow some threat to this. So I hope the Minister can clarify that point. And in fact, that will be under labelling, the composition and standards, that will be covered in a common framework. In fact, that framework was published on the 9th of October. So where is the necessity for these elements, for that example that the Minister gave? Now, the Joint Ministerial Council approach on the frameworks was outlined in a joint communiqué with ministers on the 16th of October 2017, where it outlined the definition and principles. And 1, enabling the functioning of the UK internal market while acknowledging policy divergence. 2, Frameworks will respect the devolution settlements and the democratic accountability of the devolved legislatures based on conventions and practices. And subsequently, the Cabinet Office update, which the Minister who is responding to this debate is responsible for, last year in the update, the government frameworks said that a dispute resolution mechanism was progressing. It said, I quote, "The UK government continues to seek development of a shared approach to the UK internal market and how to manage the areas framework going forward." But this bill now, as the Constitution Committee reported, gave 2 days' notice to the devolved administrations of the text, has a litany of over 30 areas where there will be no consultation or limited consultation. They will be overlooked, and indeed where England is going to be treated differently from the other nations. My Lords, it doesn't have to be this way. In other countries, which the Prime Minister is very keen to quote, of Canada and Australia, both in the 1990s introduced internal markets. Canada introduced an agreement on internal trade, which came into effect on the 1st of July 1995. And Australia, which the Prime Minister wishes to quote a lot, after a Premier's conference, agreement was reached on principles for a mutual recognition scheme. And an MOU was signed, and it has very symbolic, the signatures of all the Premiers and the Prime Minister. My Lords, the border area is one where we will be living with the consequences of this, and we have seen nearly a decade of significant division and polarisation. Please, Minister, do not force a bill against the spirit of what has been developed over the last 3 years, which is consensus and agreement. And I don't herald a bad omen for a decade of danger for our beloved union.
Lord Skidelsky.
My Lords, I join others in congratulating Baroness Hayman on her excellent maiden speech. I want to confine my remarks to part 5 of this bill. I find myself swayed by 2 completely opposite accusations of bad faith. The government accuses EU negotiators of bad faith in seeking to erect unreasonable customs barriers between Northern Ireland and the rest of the UK. Opponents of the bill say the bad faith is our own government's. The withdrawal agreement set up a joint committee to resolve trade issues. The government have chosen not to use it. So, as Ed Miliband argued in his powerful Philippic in The Other Place, the government was proposing to breach international law for bogus reasons. However, having reflected on all this, I cannot support the regret motion and would like to explain why. To my mind, international law is not the main issue. Never before, many noble lords have said, has a British government sought to break international law. But never before has Britain faced the problem of extricating itself from as complex a political, economic and legal structure as the European Union. Law, as Lord Howell explained, has to take account of political context. And as my hero, John Maynard Keynes, once said in an answer to the legal fundamentalists of his day, what I want from lawyers is to devise means by which it will be lawful for me to go on being sensible in unforeseen circumstances. Noble lords know very well that not every contingency can be foreseen. So, my lords, I ask you to judge the legislation before the House on 3 different grounds: sufficient reason, motive, and consequences. On the first, I agree with the argument that sufficient reason has not been established for the override of Part 5 at the government's discretion. But by Amendment number 66, the government has agreed to obtain parliamentary approval before activating Part 5. And I think that's a reasonable compromise between those who think Part 5 is unnecessary and those who think it's essential. Second, I sympathise with the argument that the government signed the agreement in bad faith in order to meet the Prime Minister's political requirements. However, most noble lords have ignored the argument that it was always going to require some bad faith and legal creativity, to coin a phrase, to make the Brexit decision consistent with the Good Friday Agreement. When Ed Miliband said a competent government would never have entered into a binding agreement with provisions they could not live with, I'm afraid he was setting the bar of competence much too high. contrary to Baroness Humphreys, deliberate ambiguity has always been the hallmark of statecraft. And finally, what will the consequences be? The legal fundamentalists say it will damage our ability to get an agreement because it will damage trust in the government's word. A powerful argument. The pragmatists believe it will force the EU negotiators to come up with a workable exit formula. Time will tell whether the government has calculated the balance of risks properly. My own feeling, contrary to much noble rhetoric, is that we're still largely in the world of posturing. That's the way the EU and many other international negotiations work. Public posturing followed by a last-minute outbreak of common sense. I think that's the way it'll turn out, and I don't want to do or say anything which will weaken the hands of our own negotiators.
Dunlop.
My Lords, I declare my interests as independent reviewer of UK government union capability and as a member of your Lordship's Constitution Committee, whose detailed report on the bill I commend, like others, to the House. My Lords, I doubt there is anyone in this House who doesn't support the goal of ensuring our UK domestic market continues to work seamlessly at the end of the EU transition period. This market and the trade it generates is, as the Minister said, an engine for providing jobs and prosperity in all parts of our country. The UK domestic market is an essential feature and asset of the Union. So the government is right to want to protect frictionless trade within the UK once we leave the EU's legal orbit. And they are right also to want to be able to guarantee to international partners that the terms of new trade agreements will be implemented throughout the UK. Today, the assurance regime is provided by an EU single market framework, and I agree with the government that going forward, we need an equivalent UK framework. There are, however, two questions that need to be asked and have been asked during this debate. Is this bill necessary to achieve the government's stated aims? And if the bill is necessary, perhaps as a belt and braces insurance policy, is this the right way to legislate? On the first question, I'm doubtful. The EU Withdrawal Act 2018 already provides a mechanism for constraining the ability of devolved administrations to diverge while a common frameworks process is taken forward to agree UK-wide approaches for the powers flowing back from Brussels, a process that has been yielding results. And as we've heard, the devolved administrations are also already required by law to adhere to international obligations, including trade treaties. Moreover, the government's own analysis makes clear the considerable economic costs for devolved territories should there be any disintegration of the UK market. So there are strong incentives for all those involved to agree common frameworks. On the second question, by bringing forward a bill in this form, the government has reached for the proverbial sledgehammer to crack a nut. For example, the UK government previously agreed with the devolved administrations a set of principles for common frameworks. One of these is, and I quote, to maintain as a minimum equivalent flexibility for tailoring policies to the specific needs of each territory as is afforded by current EU rules. However, the regime created by this bill is more restrictive with less public policy exclusions than the EU framework it replaces. And whereas common frameworks are subject to joint decision-making involving the UK government and the devolved administrations, the bill confirms on UK ministers extensive delegated powers to alter devolved competence in places to exercise them without even the modest requirement to consult devolved administrations. All this strikes me and the Constitution Committee as an unnecessarily heavy-handed approach to balancing the demands of free trade within the UK with respect for the roles and responsibilities of devolved institutions. Devolution is now integral to the UK's constitutional arrangements. At a time of national crisis, when it has never been more important for central and devolved governments to work together effectively, to risk destabilising these arrangements seems careless to say the least. The broader question for the House and for this Union Parliament is, do we want our country's future to be all about endless intergovernmental competition and conflict, or about cooperation and confidence? I'm in no doubt a modern, thriving, forward-thinking and inclusive UK union needs to look and feel like a joint endeavour, a union less preoccupied with battling over competencies, a union more concerned with winning over hearts and minds. That's why I hope the government will demonstrate enlightened and imaginative leadership by working constructively to amend this bill.
For Lord Hayne.
My Lords, I was delighted to listen to my noble friend Baroness Hayman, who will add high-quality, youthful value to our Labour benches. My Lords, this bill will breach the European Union Withdrawal Treaty, freely entered into by the Prime Minister less than a year ago, and the rule of law, as the noble and learned Lords Judge and Faulkner so eloquently argued, significantly backed, amongst others, by a very recent Conservative Europe Minister, Lord Bridges. It has also further damaged British-Irish relations by undermining the Irish-Northern Ireland Protocol necessary to avoid a hard Irish border. As with the trade bill, there's an urgent need to insert clear protections for two international agreements the United Kingdom has entered into recently and ratified, namely the Belfast Good Friday Agreement and that very protocol. As the bill undermines the Good Friday Agreement of 1998, US leaders have stated bluntly it could jeopardize any chance of a UK-US trade deal. Without the unifying framework provided by the EU, responsible for policies including state aid, the environment, agriculture, food manufacturing, and animal welfare, the bill represents a clear power grab to London away from the devolved governments. The Prime Minister suddenly discovered the benefits of having a single market, the UK internal market of 66 million, rather than the much larger, richer EU single market that we've been a member of over 500 million. Under the bill, not only is state aid policy to be returned from the EU to Westminster, but the UK government also gets new financial powers, both proposals further weakening the current intergovernmental arrangements whose fragility has been exposed by COVID-19. Perhaps we should not be surprised that the government adopts the posture of a public schoolyard bully when it comes to the devolved nations of these islands, where Number 10 seems to believe it holds all the cards and has nothing to lose, apart from perhaps destroying the United Kingdom. For more than 3 years, the government of Wales, Scotland, and Northern Ireland have sunk their very large political differences with the UK government over Brexit in order to address its fallout in terms of managing the UK internal market. This led to the Common Frameworks Programme, which was intended to take the areas of the economy where, and I stress this, the UK government believed there to be a risk to the integrity of the UK's internal market from the removal of the constraints to regulate in accordance with the EU rule. This bill brushes all those common frameworks arrogantly aside. Whether or not there's an orderly end to the transition period in December, Brexit will have implications for the totality of the relationships between Westminster and the nations and regions within the UK, and for those within the island of Ireland, with the financial provisions of the bill tightening Westminster control over economic, industrial, and regional development policy throughout the UK. This is likely to fuel calls for Indy Ref 2 in Scotland and eventually a unification referendum in Northern Ireland. It may be that this internal markets bill serves to hasten the breakup of the UK, another strong reason to oppose it.
I call Lord Brown of Belmont.
My Lords, when we as one nation fully transition out of the EU, we must face the new reality and its challenges together and continue to work to maintain and grow the links and ties between all four corners of this country. That means building on the work to date and improving relations throughout the United Kingdom. For the avoidance of doubt, I wish to emphasise that my party, the Democratic Unionist Party, believes that the progression of this bill is of the utmost importance. Vast swathes of the withdrawal agreement were wholly unsatisfactory, as they in essence created an unthinkable scenario for anyone who values the United Kingdom, namely a virtual border in the Irish Sea. Strands of the withdrawal agreement also made provision for a series of potentially complicated and burdensome checks on food and agricultural products entering Northern Ireland from mainland Britain. As a result, some in Northern Ireland, instead of benefiting from the removal of red tape as we leave the European Union, would be required to endure extra layers of it. I welcome government's assurance to the contrary, but we really must continue to do all we can to ensure that there are no long-term damaging barriers between different parts of our nation. My Lords, the withdrawal agreement and the political declaration, although in parts unsatisfactory, do recognise the autonomy of the EU and of the UK. However, there remains a unique difference between the two parties. While the United Kingdom is a legally defined, globally recognised sovereign nation state, the EU is simply an international body. During the course of its history and at the outset of the withdrawal negotiations, the EU recognised the sovereignty of the United Kingdom. Regrettably, since then, negotiators and some spokespersons have appeared to disregard this sovereignty by ignoring the settled status of Northern Ireland and thereby interfering in internal matters and potentially undermine the defined constitutional status of Northern Ireland. Comments from officials in Brussels have been unhelpful and have shown a disregard for Northern Ireland's unique and deeply troubled past, our shared future, and the UK's legal status as a sovereign nation. Noble Lords, though I welcome the bill, it remains true to say that businesses in Northern Ireland are confused. They may still have to adhere to conflicting regulations. There may still be divergence and associated costs. A scenario could also still exist where a firm located in Belfast is unable to benefit from financial assistance available to a firm in Birmingham or Swansea, and therefore finds it disadvantageous to relocate elsewhere. I wonder if the Noble Lord, the Minister, could specify whether the government plans to include Northern Ireland in the provisions outlined in clauses 42 and 43. In the other place, my party sought to allay fears by ensuring through amendment that the government carries out impact assessments. Our purpose was to bring some reassurances to businesses who are potentially unfairly disadvantaged compared to their counterparts in mainland Britain. It is essential that we ensure the long-term prosperity of Britain and the viability of businesses. One part of our nation should not be left behind simply because of the proximity of a land border. I firmly believe there is widespread support for a sensible free trade agreement with the EU, which allows the UK to establish itself as a strong outward-looking trading nation. A free, independent and united kingdom can and should world stage be a major global force once more on the world stage. I support this bill.
I call Lord Cavendish of Furness.
My Lords, it's a pleasure to follow Lord Brown. My Lords, I've heard it suggested that there is no need for this bill. Indeed, such doubts are rehearsed by the Distinguished Select Committee on the Constitution in its 17th report. This may be technically and legalistically correct. However, it would be my contention that such a view overlooks a significant historical consideration. Before we joined what was to become the EU, a single unified internal market was for 300 years the constitutional bedrock of Great Britain, extended to Ireland 100 years later. The absence of taxes, custom duties and other restrictions that were so crippling to much of mainland Europe created the conditions to usher in the Industrial Revolution. Now, my Lords, as we prepare to leave the EU, it seems imperative to me that we have legislation that restores conditions of a single UK market tailored to the 21st century. My Lords, yes, this bill is necessary. There can be no doubt that the government finds itself in a bind, and to a large extent, a bind of its own making. Furthermore,
the EU Select Committee, of which I have the privilege of being a member, has long warned of the problems which are now become so critical. I was also deeply saddened that a Minister of the Crown should speak in the other place as he did. And as my noble friend Lord Bridges said, it is no mitigation to say that others, including the EU, breach international law. However, there does appear to be no agreement among senior lawyers as to the legitimacy of the proposed measures that have given rise to such controversy. I cannot agree with the Constitution Committee's witness who said, "Let us accept that the bill breaks the law." The bill does not break the law, and it does not threaten to break the law. According to Mr. Martin Howe QC, no breach of international law could possibly occur until regulations under the clauses in question were actually brought into force. And even then, whether or not making such regulations would amount to a breach would depend on the circumstances then prevailing and the reasons for making those regulations. I've heard it said that the inclusion of the controversial clauses is part of a negotiating tactic. There are further suggestions that the tactic has worked to the extent that the EU withdrew from its indefensible position of threatening to withhold third country listing. The problem could arise from a failure to address the problems that could arise from the failure to address the nightmare so-called direct effect could have catastrophic consequences, something largely ignored by the media and sadly has earned scarcely a mention in contributions today. Scandalously, the opposition front bench was entirely silent on the matter. I support a government that upholds and defends the country's vital interests. I sometimes gain the impression that I'm in a minority in your Lordship's House. I hear it claimed that objections to the bill are unrelated to Brexit. And it is certainly the case that many of your Lordships, and much to their credit, have buried their pain and sadness occasioned by our leaving the EU and chosen to move on. However, this House is essentially a Remainer House. Its committees are Remainer committees, and there is nothing dishonourable in that. But it has led your Lordship's House, it seems to me, to have morphed from acting as a revising chamber to being one of opposition, a position apparently supported by the noble Lord Butler of Brockwell. As I've been a member of this House for 30 years, I can remember being on the opposition benches with a built-in majority. I recall how we acted with considerable restraint, as we certainly should have done. In those far-off days, cross-bench peers tended to vote only on matters of their field of expertise. The Lords Spiritual were reticent in their displaying their partisanship. It all seems such a long time ago. I mention this because it occurs to me that this House is serious about trying to influence government. It might alter its tone. I reflect that on the great issues of the times and many others, this House has put itself at odds with the government, with the other place, and to judge by the general election, the people of this country. It bodes ill, I believe, for an institution to persist in saying it knows better than the people it's supposed to serve.
Lord Howarth of Newport.
My Lords, I add my warm welcome and congratulations to my noble friend Baroness Haymond of Alloch. My Lords, despite the case just made by the noble Lord Cavendish of Furness, it is a puzzle to me that the government have introduced this bill, given the commitment agreed in the Joint Ministerial Committee of Ministers of the UK and devolved governments to develop by consensus common frameworks for the UK internal market. We are told good progress has been made on this. Yet, with perfunctory consultation, the bill has been brought in. It contains no mention of common frameworks. It takes powers to override, by means of regulations passed at Westminster, devolved legislation, and to spend money in areas of devolved competence, and contains only patchy and vague provisions for future consultation on the exercise of the powers it creates. It has provoked indignation in Wales, Scotland, and Northern Ireland, and legislative consent is highly unlikely to be forthcoming. The bill is disrespectful to the devolved administration. When the Union is under great stress from Brexit and COVID, it is also reckless. The bill is disrespectful towards this Parliament. It contains egregious Henry VIII clauses, most notably 53(2), which says any power to make regulations under this Act includes power to amend, repeal, or otherwise modify legislation. The bill is disrespectful towards our treaty partners. It authorises breaches of the Northern Ireland Protocol and the Withdrawal Agreement. The government offers as justification that the EU may intend to interpret ambiguities in the Withdrawal Agreement, ambiguities that the government was happy to write in a year ago, to the detriment of the UK's internal market and the Good Friday Agreement. Ministers may see this as a suitable tactic in the Brexit negotiations. It may also be seen as a reckless reminder to other countries not to trust perfidious Albion. The brutal declaration in the House of Commons by the Northern Ireland Secretary that the government are deliberately taking power to break international law sounds a loud alarm. The bill is disrespectful to the rule of law and to the judiciary. In this regard, it echoes thinly veiled threats to the judiciary in the Conservative Manifesto, the notorious remarks in Conservative Home by Suella Braverman shortly before she was appointed Attorney General, and the attacks on lawyers by the Home Secretary and the Prime Minister at the Conservative Party conference. The government make the case in self-exculpation that the defiance of international law is legal under domestic law. They also insist that they are not precluding judicial review, although in clause 47, they go to extreme lengths to insulate regulations made under the bill from challenge. The government cannot justify what it is doing by quibbling. Constitutionality entails acting in a spirit of respect towards the rule of law, including both international law and, in our domestic jurisdiction, the effective ability for persons to have redress in court for the misuse of executive power. It consists in respecting conventions, which, though uncodified, ought to be binding on ministers and on Parliament. These conventions include respect for the role of other institutions which form part of the Constitution, among them the devolved administrations as well as the judiciary, and therefore acting with restraint towards them. Proper government keeps the convoy moving along together. It shows itself to be trustworthy. The doctrine of the omnicompetence of statute, undoubtedly valid, is gratifying to the vanity of parliamentarians and convenient to governments, but such ill-judged deployment of statutory power as we see in this bill risks imposing intolerable stresses on the cohesion of the Constitution and of the United Kingdom. The bill is an expression of a loutishness that characterises this government's political dealings. Where will this debasement of our democracy take us?
Noble Lord, of the advisory speaking time, we cannot go beyond midnight, and if everybody goes over, some noble lords will have to wait until tomorrow to speak.
In this House, my lords, we must do all we can to limit the damage the bill causes, starting by supporting the amendment of the noble and learned Lord Judge.
Lord Thomas of Gresford.
My lord, since I'm speaking from Hayman House, my home in Gresford, it would be churlish of me not to welcome Baroness Hayman and to congratulate her on her excellent maiden speech. My lords, on the 2nd of October of last year, the Brexit Secretary, Stephen Barclay, told the EU Committee of this House that Northern Ireland businesses would have to complete export declarations for goods moving from the Northern Ireland to the rest of the UK. On the 7th of November, shortly afterwards, the Prime Minister told exporters in Northern Ireland, in answer to a question, that if any business was asked to fill in customs declarations, he would direct them to throw the forms into the bin. That's his typical jocularity. He said, there will be no forms, no checks, no barriers of any kind. You will have unfettered access. And that's what the provisions in clauses 44 to 47 of this bill are all about, to save face. The Prime Minister cannot admit that he told off-the-cuff porkies, or more likely that he didn't understand the written agreement he had signed. The government says that this bill does not in itself breach the written agreement, only potentially, as Lord Forsyth of Drumlin argued earlier in the debate. The noble Lord Cavendish of Furness went further a moment ago.
and asserted there is no breach of the law at all. If I give a knife to a person of unstable temperament with the foresight that he will use it to stab somebody, I break the law. It's no defense to say I thought he would only use my knife potentially. These clauses in this bill are an instrument positively designed to empower ministers, first, to act illegally, and secondly, to ensure that the powers of the court to stop them by judicial review are removed. It's as though I told the potential murderer, look, here's a knife, and I guarantee that you will not be prosecuted if you use it. The noble Lord Lamont said, well, all they're doing is they're threatening to rescind an agreement they should never have made to strengthen their negotiating position, Well, it hasn't worked, has it? As the noble Lord Butler said, it's a threat which should never have been made. It would have been 1945, with Christmas approaching, when my father decided to make me a toy gun. He carved and varnished a wooden stock and added black piping to look like a barrel. And on Boxing Day, I proudly took this toy gun out to play. Well, it was quite a tough area, and it's in my mind's eye now. I was approached by two youths who were 4 or 5 years older than me. They threatened to bash my face in if I didn't hand the gun over to them. I did so, and you can see that it rankles after 75 years. A threat is not in the long run a good negotiating tactic. You may succeed for the immediate moment, but the resentment lasts for years. The reputation is damaged beyond repair. Why should the European Union believe any compromise the Prime Minister puts forward this coming week on state aid or fisheries or the like? He's weakened his bargaining position. The Lord Chancellor justifies taking these powers on the basis that there, and I quote, could be a material breach by one of the parties. It doesn't say which party or what breach of the withdrawal agreement. Do you have a better point, Mr. Buckland? Robert Buckland comes from Llanelli. And when Lord Campbell of Pittenween referred to the oath of Queen's Counsel in his speech today, I remembered that it was another Llanelli boy and Lord Chancellor, Lord Elwyn Jones, who took my oath of office in the Moses Room some 46 years ago. What I wonder would he have thought of such a manifest breach of his oath of office, which commences, I swear by Almighty God to uphold the rule of law.
I call the Duke of Wellington.
My lords, it is a privilege to speak in this debate, but I do notice that only a handful of noble lords appear to support this bill as presently drafted. I also want to put on record that I very much welcome the intervention of the Most Reverend Primate and the letter signed today by the Archbishops. This bill has a significance for this House considerably more than almost any other bill we are or have been asked to consider. Having over the weekend read the excellent report by the Select Committee on the Constitution, I'm even more concerned, as a layman, by certain clauses in this bill, particularly clauses 44, 45, and especially 47. In a single piece of proposed legislation, the government has managed to antagonize almost everyone, a multitude of counterparties and international public opinion. Firstly, many members of the United States House of Representatives are concerned about any move which could undermine the Good Friday Agreement. And they have made it clear that this legislation puts at risk the future approval by Congress of a US-UK free trade agreement. Secondly, the government have antagonized the European Union, who see the legislation as abrogating parts of the withdrawal agreement signed only 10 months ago. Thirdly, they have antagonized the devolved administrations, who feel that they have not been properly consulted and that the legislation goes against certain parts of the various devolution settlements. The government has in fact admitted that in certain respects the bill does break international law. It is therefore difficult to believe that government ministers and their political advisors have really given sufficient thought to the consequences of this proposed legislation. Clearly, legislation is required to ensure an internal market can operate in these islands. But it was always inevitable in Mr. Johnson's withdrawal agreement that there would have to be some sort of documentary border in the Irish Sea. That was not true of Mrs. May's deal, which unfortunately the other place repeatedly rejected. But the Northern Ireland arrangements can still be negotiated in the Joint Committee. And as for the arrangements with the devolved administrations, these can surely be negotiated within the common framework process. So parts of this bill would seem to be unnecessary, a phrase so liked and used by ministers when rejecting other Lords' amendments in other bills. The most effective way in which this House performs its duty is to ask the government and the other place to think again. Surely there could be no more important bill than this one to perform that duty. Having read the various reports from the committees of this House, we must ask the other place to think again, particularly about Part 5. Should it return to us unamended, it may well be necessary, as Lord Butler suggested, to do so a second time. And in the meantime, I will vote tomorrow for the learned and noble Lord Judge's amendment when it is put to a vote.
I call Lord Mancroft.
My Lords, I would not dream of questioning the noble and learned Lord Judge's judgment in matters of the law. Of course I wouldn't. But I would say that the rule of law, as a matter of principle, is as important to me as it is to any noble lord, however learned. But like many legal matters, it's a question of fact and degree. I'm not a lawyer, but I've been involved in enough litigation to know that two silks of equal distinction can produce very different and equally persuasive arguments for or against almost any legal question that any of us could pose. These things are not, as some would like to have us believe, black and white. Like everything in life, they come in shades of grey. To my father, as a newly qualified barrister in 1938, the invasion of Poland in 1939 was not grey. It was completely black and white. But having sat through the debates in your Lordship's House at the time, it was clear to me that many of the lawyers in this House came to a very different conclusion about the legality of the invasion of Iraq in 2003 than the Labour government did. To them, it was not black and white. It was a matter of opinion. In terms of degree, my belief in the rule of law, which I believe is probably the most important principle we espouse, has not stopped me from time to time, and I hang my head in shame today, from parking on a double yellow line. And I don't suppose I'm the only noble lord to have broken the law at some time or another. It would be hypocritical of us not to admit that we can all be flexible when it suits us. I share with others regret that my right honourable friend, the Secretary of State, made the statement in another place that set this hair running. I don't know if it has been suggested that the government felt that this declaration from the dispatch box would provide some form of legal cover in the event that some Remainer obsessive decided to run another case to the Supreme Court in the hope that that court would be prepared to compromise its reputation by indulging in another political judgment. Because it is primarily a political and not a legal matter when a foreign power seeks in negotiating an agreement, supposedly entered to in good faith, to use that negotiation deliberately to interfere with the delicate relationship between the component parts of an independent nation-state, such as those of the United Kingdom and Northern Ireland. It's perfectly obvious that the European Commission very early on worked out that this was our Achilles heel, and has done its level best to exploit this for its own ends. That is not, my lords, the conduct of a good neighbour and trading partner acting in good faith. That's the behaviour of someone who does not wish us well. It is in effect a trap, deliberately placed where it would do the most harm. But what government, having spotted this trap, would continue to blunder on, rather than take whatever measures it could to avoid it? It is the government's duty to avoid a trap, almost at any cost, which is precisely what this bill seeks to do. The final point I would make on the issue of national reputation. Who is it, I wonder, who will think so much less of us for having ducked this punch, aimed as it was, below our belt? I'm not very interested, for example, in China's view of our trade arrangements with Northern Ireland, particularly in comparison with their behaviour towards Hong Kong. Nor will I take any lectures from Mr. Putin about the rule of law. President Trump thinks we're mad not to have walked away from the EU years ago, and Mr. Biden has already made his views firmly in line with those of his Irish Republican voters clear, and there's no changing that. The current members of the EU obviously think the worst of us, and they always have done. But who cares? I do business in South America and in Africa, and no one I've ever met in either of those continents has the remotest interest in this squabble, but they would all love to do business with us. Our Commonwealth friends are not fooled by this stuff. Saudi Arabia and our allies in the Gulf share the same view as their new Israeli friends, that business is business, and a view shared by our Pacific trading partners also. So, my lords, if our reputation is harmed, I'm struggling to see with whom.
I call Lord Morris of Aberavon.
My lords, as the Attorney General, I had a duty to advise ministers of their legal obligations. This was not always straightforward, and I'm particularly aware of how I strove to achieve and advise compliance with the law, particularly in Kosovo and the rules of engagement in Sierra Leone. Parliament and ministers accepted my advice, though as a leading counsel, I had to defend the United Kingdom before the International Court in The Hague. As the greatly admired Lord Bingham wrote in his book, The Rule of Law requires compliance by the state with the international law and national law. Ministers, civil servants, and our armed forces are bound by the need to observe international law. The rule of law is not negotiable. To defer breaches does not alter the fact that Parliament is being asked now to legislate in breach of its obligations. It is similar to blessing a potential burglar or murderer for any future wrongdoing. We have already lost one esteemed and distinguished law officer. Is it not the time that we have a clear statement of where they stand from the Lord Chancellor, who has a statutory duty to maintain the rule of law, as well as the remaining law officers who are clinging to office? I turn now to devolution legislation. As one of the architects of the Welsh devolution, which I began as a graduate student in Cambridge in 1953 and culminated in 1999, I regard it as my duty to safeguard the settlement. Once powers are devolved, they cannot be withdrawn. The bill drives a coach and 4 horses through the devolved settlement. The Welsh government tell me the United Kingdom government have the United Kingdom governments have worked collaboratively on the Common Parliamentary Programme for 3 years. This bill neuters it and hollows out the powers of the devolved legislatures to regulate policy areas. There is no time to give examples. In the memorandum from the Welsh Assembly, they spell out their grievances. I will make 2 points. First, the bill contains, for the first time, powers for the UK government to spend money over the heads of devolved ministers in. I ask the Minister to confirm that interpretation by the Welsh government is right. Secondly, that the bill seeks explicitly to amend the Government of Wales Act to add and design the operation of state aid policy to the list of reserved powers. Again, examples have been given. Could we have a statement on that issue, or whether the Welsh Government are right or not? And again, the Minister confirms that I would like to hear his confirmation of what the position is as he started out his speech. The brief for the bill states that devolved administrations will see their powers increase significantly following the transition period and the transfer of EU powers, and will be able to use new existing powers within the international market system. Who is right? Is it the Welsh Government or is the Minister, as he started out in his speech today? Is that factual brief correct or not? I ask one further question. Is it a wish and intention of the government to go back on the settlement of devolution over 20 years, or is the bill an inadvertence which will undermine the unity of the United Kingdom? Is that what they want?
My Lords, may I begin by congratulating the noble Baroness Lady Hayman of Alloch on her excellent maiden speech, and say how much I look forward to hearing from my noble friend Lord Sarfraz very shortly. Because of Part 5 of this bill, very few are prepared to give it their wholehearted support, and I'm not one of them. And in the event of a division tomorrow, I will without hesitation support the regret motion moved by the noble and learned Lord Judge. To do otherwise would be wrong as a matter of principle, but as a former law officer like Lord Morris, and as a member of the other place and of this House since 1992, it would also be a matter of personal shame to agree to such flagrant abuse of the rule of law and our international treaty obligations. Set against last year's unlawful prorogation and the fact that Mr. Dominic Cummings is the instigator of Part 5 and is the last person to have been found in contempt of Parliament, I'm not surprised, although I ought to be shocked that first a Cabinet Minister could say that the government were intending to break international law, and secondly, that the Attorney General could apparently advise the government that what was proposed was defensible as a matter of law. It plainly isn't, even if some may think it has political advantages. I've heard excuses for Part 5 of this bill, which contains provisions that unquestionably breach international law or authorise such breaches. I've heard them from members of Parliament not previously noted for their interest in questions of international law, and I've heard them from government ministers. They appear to confuse the sovereignty of Parliament with the government's treaty obligations. My Lord, if sophistry is an unparliamentary description of what we have been asked to believe, let me say instead that the explanations for Part 5 are risible. They amount to bad law, to poor diplomacy, and inept politics. Let us be clear. The European Union Withdrawal Agreement is not some ancient treaty entered into by two medieval monarchs when our customs and usages were very different, nor is it as difficult to understand as the Schleswig-Holstein question. It is only a year since this Prime Minister agreed to it, not just bits of it, but all of it, including the Northern Ireland Protocol, the clauses referring to EU law, and the trading arrangements between Great Britain and Northern Ireland and the Republic of Ireland. It is barely 6 months since Mr. Johnson, in the triumphant afterglow of the general election, recommended it to Parliament for translation into United Kingdom law. My Lords, we have not heard publicly from the Attorney General. It's entirely normal for the law officers to keep confidential their advice to the government, albeit that the Attorney has published a digest of the opinion of the 3 lawyers she selected to advise her. Its conclusions are not, in my view, convincing, save perhaps as a political manifesto. Certainly they didn't impress the Treasury Solicitor, Sir Jonathan Jones, who resigned rather than being party to this unlawful policy. Nor did they impress my noble and learned friend Lord Keane of Ely, who, despite valiantly trying to bring the government to a proper understanding of the rule of law and their obligations freely entered into as parties to international treaties, resigned as well. But it's not just a breach of international law. Part 5 also undermines our domestic law. Clause 47 is breathtaking. It will give ministers the power to make regulations and renders those regulations unassailable even if they break the law. Thomas Cromwell would be proud of this clause. It prevents legal challenge so that no court can rule against them. Government by ministerial decree is certainly not what we should see in a parliamentary democracy. Under Section 25 of the Theft Act 1968, going equipped is a crime. It's an offence when not at home to be in possession of an article made or adapted for use in committing a theft or burglary. Part 5 is the equivalent of the burglar's jemmy. Government and law officers should not advocate their use and expect to retain the respect of Parliament or the legal profession.
Yeah, very good. I now call Lord Stirrup.
Like other noble lords, I wish to focus today not on the broader provisions of this bill, but on Part 5. Giving ministers the power to break the law seems to me an astonishing thing for Parliament even to contemplate, let alone agree to. Now, I quite understand that there are situations where there may be argument about what the law is, or about whether particular matters fall within the provisions of a given law. But that does not appear to be the case here. The government has acknowledged that it wishes ministers to be able to break the law. The fact that it would be in a specific and limited way seems to me to be irrelevant. Why should the residents of Greater Manchester not now feel that they can break the law in a limited and specific way? The government has advanced the argument that this is a provision which would only be applied if the EU had previously acted in an unreasonable way in implementing the withdrawal agreement. But there is, as we've heard many times, already a dispute resolution mechanism in place to deal with this situation. And if this is deemed insufficient and the government sees the need for new primary legislation, why not enact it once the other party has patently broken faith? Emergency legislation could then be made specific and pass swiftly, and the UK would be reacting to a breach of trust rather than creating one. But I wish to make another broader point this evening, a point about power. In setting and carrying out its foreign policy, the UK is essentially seeking to persuade countries to do things they would otherwise not do, or to dissuade them from doing what they otherwise would. Such persuasion rests upon the ability to convince or to compel, which in turn is based upon the power that we wield in the international arena. Now, the underlying foundation of that power is undoubtedly our economic strength, but it also depends upon a degree of moral authority. If we are to convince others of the force of our arguments, they need to know whether they can rely upon what we say, whether we deliver on our obligations, whether we are steadfast or blown by the latest wind, whether they would be prepared to buy a used car from us. Even when we seek to compel rather than to convince, both our hard and our soft power are most effective when arrayed alongside that of our partners. Partners who know the quality of our contribution. Partners who know we can be relied upon to fulfill our undertakings. Partners who trust us. It's clear that certain clauses within Part 5 of this bill have already undermined international trust in the United Kingdom. EU leaders are looking for harder and more specific conditions in any new agreement with the UK because they now view us as untrustworthy. Our power in the world has been diminished by this bill and will be diminished further if it is passed unamended. My lords, this seems a strange way to advance the cause of global Britain. So there are very clear practical reasons for doing something about Part 5, but above all, there is the fundamental issue of principle. The government exercises authority through the law. If it undermines respect for the law, it undermines both itself and the stability of our society. This is surely not the path we as a nation wish to follow. I urge the Government to think again, and I shall certainly support the amendment of my noble and learned friend, Lord Judge.
Now call the noble Lord, Lord Sarfraz.
My Lords, it is with great pleasure that I stand to give my first contribution in your Lordship's House. I would like to congratulate the noble Baroness Lady Hayman for her very thoughtful maiden speech. I haven't been a member long, but I've learnt that this House is full of very kind and generous people who have been incredibly welcoming to me. I would like to thank the wonderful doorkeepers, Blackrod, the Clerk of the Parliaments, and all the staff for their warm welcome. I'm very grateful to them, as well as to my supporters, my noble friends, Lord Goldsmith of Richmond Park and Lord Chaudhry. I'm particularly grateful to the Prime Minister for giving me an opportunity to be part of your Lordship's House. I've learnt about the procedures of this House from my whip, my noble friend Lord Borwick, and my mentor, my noble friend Lord Lee of Hurley. And there's a tremendous amount I hope to learn from members of this House across all parties who have had such distinguished and diverse careers. My Lords, I grew up in Pakistan in a family with a tradition of military service. Both of my grandfathers were officers in the British India Army, and my father was commissioned as a naval officer at the Britannia Royal Naval College. I couldn't serve in the military because I have asthma, but I now have the opportunity to serve in a different way from the floor of this House. I understand that maiden speeches are meant to be uncontroversial, so I'll keep my contribution short and sweet. In global Britain, entrepreneurs in the technology industry will play a huge role. I'm a proud member of the ethnic minority community of the United Kingdom and would like to work with my own community so we can continue to make important contributions in the global economy. For example, the CEOs of Google, Microsoft, IBM, MasterCard, and Adobe, amongst many others, are all from ethnic minorities. My Lords, I refer to my interest in technology venture capital as set out in the register. We in the United Kingdom have been at the forefront of innovation for centuries. Many people believe that venture capital was invented in Silicon Valley, but actually it was invented in Birmingham. In the 18th century, members of the Lunar Society would meet monthly to discuss, demo, and fund the greatest technology innovations of their time. In my career, I had the privilege of observing that one of the determining factors of success and failure is entrepreneurs having access to a strong domestic market. As global as technology markets are, entrepreneurs who can quickly and easily build a foundation in domestic markets are often the ones who have the necessary platform to then scale internationally. The history of virtually every successful technology company started with early commercial wins in a sizable domestic market. We are fortunate that the United Kingdom is a strong domestic market, especially for entrepreneurs. We must make sure our startups, whether in space technology in Glasgow, cybersecurity in Belfast, digital health in Cardiff, artificial intelligence in Oxford, life sciences in Cambridge, the Internet of Things in Manchester, virtual reality in Liverpool, all have access to a strong, stable UK internal market with certainty of rules and regulations. I'm therefore pleased to support this bill in your Lordship's House. Finally, my Lords, with your permission, I would like to thank my family, my parents, my wife, and my beautiful daughters for their long-standing love and support, and to you, my Lords, for giving me an opportunity to participate in this important second reading.
Anna.
I'm delighted to follow my noble friend Lord Sarfraz and congratulate him on his excellent speech, and also congratulate Baroness Hayman of Ulloch too. As he rightly said, maiden speeches are meant to be uncontroversial. This contribution was in no way controversial. In fact, the contribution was deeply encouraging and seriously important for the House as a whole. It was the Governor of Punjab, amongst many political and business leaders in Pakistan, who paid tribute to Lord Sarfraz on his elevation, saying, "Ahmad Sarfraz has helped build the bright image of Pakistan in the international community." And to quote, he said, "You made Pakistan and British Pakistanis proud." At such a young age, Lord Sarfraz brings enormous experience as an entrepreneur and a venture capital investor. He's also initiated many social projects, including training thousands of small holder farmers in the Punjab and supported many charitable endeavours, including horse riding therapy for children with special needs. I have no doubt that Lord Safraz will make many important contributions going forward. And from a proud British Jew to a proud British Muslim, I look forward to continuing to work closely with my noble friend for the benefit of British society from within our House of Lords. My Lords, Lord Safraz made a strong point about the need to have access to a strong and stable internal market with certainty of rules and regulations. I noted that the Scottish Government called this bill a power grab. On that point, the goods and services sold in a part of the UK must be available for sale in the rest of the country. The Scottish Government said it would effectively be limiting standards across the country to the lowest of the four nations. I just cannot understand their pessimism. As for power grab, it was no surprise that MSPs voted 90 to 28 to reject a legislative consent motion. It is clear that the SNP would really like to hand back powers to the EU and or keep most of them for themselves as an independent country. My Lords, I joined the Conservative and Unionist Party and I support this bill's intention to maintain high standards across the whole of the UK. My Lords, I too, like my Lord here, I'm not a lawyer, nor are most of the people in our country. And they want clarity. My Lords, I was a reluctant Remainer back in 2016. I am now not one today. I am neither reluctant nor a Remainer. Permit me to put these last few words simply. The sort of words that would be uttered in a pub if we could get to one. We were a member of a club of 28, where throughout there was a rocky relationship. We voted to leave and tried to negotiate a mutual and sensible exit in good faith. But it seems that the good faith has not been reciprocated. There is still time for the EU to act in good faith, and there would be no need to break any laws at all. But ultimately, my Lords, we can create our own rules for our own club, the club of the United Kingdom.
I call Baroness Bryan of Partick.
My Lords, I'd really like to congratulate my noble friend Baroness Lady Hayman of Alloch and the noble Lord Safraz on their maiden speeches of excellent quality, and it's really good to have two younger members join us. I must also congratulate the government for doing so much to bring about harmony. It has managed to unite so many speakers in this chamber and all but one of the parties in the Scottish Parliament, to name just two groups. One of the purposes of this bill is to enact the political ideology of the ruling faction of the Conservative Party, which demands that unfettered access of business across the UK should be able to overrule any democratically decided public policy goals. BASE's own impact assessment makes it clear that market access principles will reduce the ability to pursue targeted social and environmental policy objectives. We were told that Brexit would result in the return of powers to the devolved administrations, but instead significant powers have been retained by Westminster, and this bill goes even further as it will take away existing powers. Lord Callanan said, as I understood him, that industry subsidies had never been devolved, but Part 7 of the bill amends Schedule 5 of the Scotland Act 1998 to eliminate state aid from the devolved powers that have rested with the Scottish Parliament for over 20 years. This happened without negotiation and with only the most cursory consultation. The so-called level playing field is far from fair. How can it be when the players on the field are of massively different size and strength. It would be the equivalent of a football match between Chelsea and Partick Thistle. The big firms in the large countries flourish, small firms in small countries struggle. The bill does not establish independent arbitration or dispute resolution. Once again, the UK government will act as both participant and final arbiter and will, as usual, find in its own favour. This legislation confirms what many of us have already known. The current system of joint working between the UK government and involved administrations is not fit for purpose. It does nothing to guarantee high regulatory standards. Instead, it creates incentives to lower standards. It prioritises the removal of potential barriers to trade at the expense of other public policy goals, such as health or the environment, regardless of the democratic decisions of the electorate in the devolved administrations. Andrew Bowie, Conservative MP for West Aberdeenshire and Kincardine, gave a stark warning in a recent newspaper article. He said, "This internal market bill is just the start. The UK government is back in Scotland. Get used to it. If ever there was a wedge that will serve to divide the United Kingdom, this is it. We cannot in all conscience allow this dreadful piece of legislation to be rushed through Parliament. We must ask the government to think again."
Lord McNally.
My Lords, my first duty is to congratulate Lord Sarfraz and Baroness Hayman on two excellent maiden speeches. It's not always like this, by the way. My Lord, in his speech earlier today, the Archbishop of Canterbury made it clear that we are an unelected second chamber and has a mainly advisory and revisory role. But my Lords, along with those responsibilities is another power, rarely used but very important. In 2006, along with my noble friend Lord Tyler, I sat on a joint committee of both houses set up to examine the conventions which govern the relations between both houses and between Parliament and Government. The report and recommendations of that committee, chaired by the noble Lord Cunningham, were adopted by overwhelming votes of both houses and stands as the basic rules of the conventions between these houses, not Addison-Salisbury, but the Cunningham Conventions. Paragraph 281 of that report said this about the powers of the House of Lords. Nothing in these recommendations would alter the right of the House, in exceptional circumstances, to vote against the second reading or the passing of any bill. My Lords, it is that right to say no which stops this House being simply a debating society. In the 110 years since the first major reform of this House, its most passionate defenders have argued that the Lords was the safety catch to prevent an abuse of power by a temporary majority in the other place. A constant in all our deliberations has been the special responsibility of this House to uphold the rule of law. Over the next 2 days, we are considering a bill in which a Minister of the Crown in the other place admitted a proposed breach of the UK's international obligations, and where the government's senior law officer in this House, the noble and the learned Lord Keane, has resigned rather than be at the dispatch box today to try and defend this bill. My Lords, when all 5 living ex-Prime Ministers expressed concerns about the bill, when the joint briefing on it from the Law Society and the Bar Council calls for the removal of the offending clauses, and the Bingham Centre for the Rule of Law says these clauses are in fundamental opposition to the rule of law and damaging to our standing internationally, and when our own Select Committee on the Constitution calls in aid the late Lord Bingham when it states, We agree with Lord Bingham that respect for the rule of law requires respect for international law. One is bound to ask whether this House could ever have before it a piece of legislation which more fits the terms exceptional circumstances than the one before us today. My Lord, the amendment put down by Lord Judge I will vote for, and it will undoubtedly be carried tomorrow. But it does not use the power of this House that we have to remove the offending clauses 44, 45 and 47 from the bill. In that respect, it will allow us to go home feeling good, but without changing the mischief in the bill. I make it very clear that I believe we should refuse this bill a second reading, but I am told by my more herbivorous colleagues that the bill should go to committee. I hope that during its passage through committee and report, we will see an amendment to remove the offending clauses, and that however many times it is brought back to this House, we will say no. If this is not an exceptional circumstance as set out in the 2006 report, I feel to say when this House will ever summon the courage to use that power. Those who have a contempt for our parliamentary democracy and the rule of law will be emboldened by our failure, and this House will be diminished in the process.
I now call Baroness Jones of Moulscombe.
My Lords, I too would like to welcome the noble Lord Sarfraz, whom I've had the pleasure of meeting already, and also welcome the noble lady Hanway of Alec, apologies. And I do hope to work with her on the environment and on animal welfare. That would be fantastic. My noble friend, Lady Bennett, isn't able to be here this evening, but I know if she were, she would like me to explain that we are dividing this bill up between us, and she will be speaking on the internal and devolution issues. And I know she'd like me to say that she abhors the destruction of this bill by of the rights of democratic devolution that have been embraced and actually exercised by the people of Scotland, Wales and Northern Ireland. And in the case of Scotland, of course, they've had long existing distinct education systems with higher qualification standards for teachers. And in the case of the Senedd, of course, plans for better control of single-use plastics than we have managed in our meagre efforts here in England. And so I will focus on the international and rule of law issues in the bill. And first, I really would like to congratulate the Constitution Committee for their wonderful report on this bill. I actually read it through and laughed with pleasure. So thank you very much for that. And I think this debate has also been extremely interesting because I really didn't think anybody would be able to have the audacity to defend this bill, apart from the Minister moving it, of course. But the Constitution Committee expressed the problem very well on law when it said, society cannot afford to take this principle for granted or acquiesce in its violation. The rule of law is essential to an open and democratic society and the institutions which embody and protect it. Any government that seeks to secure widespread compliance with the law must itself adhere to it. And it's absolutely indicative that there are two regret motions when, of course, one of them is from the convener of the crossbenchers, who's an ex-Lord Chief Justice of England and Wales, and the other is from a peer who was a Conservative MP for 40 years. These are hardly rebels of the usual kind. And this bill actually, I feel the government's got some cheek actually moving this now, because it's less than a year since they campaigned on Boris's deal as their main election gambit. And your Lordship's House then passed that deal in recognition of the fact that the government had won the election almost as a quasi-referendum on the deal itself. And now the government comes to Parliament to try and unpick key provisions of the deal that they negotiated themselves. It's too easy to get bogged down in seeing this as a narrow political issue around Brexit and Boris's deal. It is much, much deeper. And for all those few noble lords who've been talking about Ramonas, I voted for Brexit, and I still am deeply unhappy with this bill. And the government tries to use the principle of parliamentary sovereignty to justify this course of action, but that is wrong. And a classic example of parliamentary sovereignty that others have also attempted is that nothing stops Parliament from passing a law to ban Frenchmen from smoking in the streets of Paris. But this, of course, would have absolutely no effect. Parliament has the power to pass legislation which violates international laws and agreements. But just because it has the power to do it doesn't mean it's justified in doing so. So there is scope for your Lordship's House to amend the bill to remove the offending provisions. However, if this bill can't be sufficiently amended, then our role as guardians of the Constitution will require us to reject the bill in its entirety. I will, of course, support the amendment.
My Lords, I beg to move that the debate be now adjourned.
The question is that this debate be now adjourned. As many as are of that opinion will say content. The contrary not content. The contents have it.
I beg to move that the House now adjourn during pleasure for 30 minutes until 8 o'clock.
The question is that the House do now adjourn until 8 o'clock. As many as are of that opinion will say content. The contrary not content. The contents have it.
My Lord, to resume debate on the United Kingdom Internal Markets Bill, I call the next speaker Lord Hamilton of Epsom.
My Lords, I'd like to join in the congratulations to Lady Hayman of Alloch and indeed Lord Saveras on their maiden speeches, which I much enjoyed. I hope they enjoy this House as much as I have. I hope they also listened to my noble friend Lord Cavendish of Furness, who gave a slight word of warning that we've lost many of our friends in the other place and we haven't made any new ones. And I think our future is not quite as straightforward as we might all hope. I really want to talk about the extremely shabby way in which my noble and learned friend, Lord Keane of Ely, was treated by this House and by others in government. He was a very fine lawyer, and he was probably one of the best advocates general for Scotland that we have ever seen. Those are not my words. Those are the words of Lord Wallace of Tanganes earlier on today. So we have lost an extremely able man, and I think that the contributions of rather lesser men in your Lordship's House have contributed to him being removed from office. And I don't think that's done any great favours to our House or to Scotland. In the previous administrations in which I used to serve in a very junior capacity, we've always had these problems of how you interpret legal situations, and a tremendous onus is put on our law officers to decide whether things are legal or illegal. And the noble Lord Morris of Aberavon made reference to this during his time as Attorney General under a Labour government. My noble and learned friend Lord Keane, on the 15th of September, made it absolutely clear that he thought that the Internal Market Bill, which we're now considering, was within our obligations under the withdrawal agreement and was legal. A number of noble lords have chosen during this debate to try and obscure that fact and say that somehow my noble friend Lord Keane was conflicted. He wasn't. He said on that occasion, on the 15th of September, that the EU had materially breached its treaty obligations, in which we find that it may have acted in such a way as to fundamentally alter our obligation under the treaties. So he was quite unequivocal of the fact that the government was acting completely legally over this, and he was the law officer. And in my opinion, what he was referring to, I think, was, these are my words, was the fact that the EU had decided to say that the border in the Irish Sea should remain even if we left the EU with no deal. And that would, of course, completely have undermined the single market of the United Kingdom and was totally unacceptable to this country. So it seems to me to be quite straightforward that my noble friend Lord Keane considered the actions of the government to be legal, and therefore what we have to ask is what on earth was my right honourable friend the Secretary of State for Northern Ireland doing, saying that in some way this was a minor infringement or a technical matter which only was slightly illegal. I don't think you can have things being slightly illegal. I think they're either legal or illegal, and I don't really know what Brandon Lewis was doing. He was actually had been called to the bar himself in his youth, and why didn't he actually question what he was doing, getting up saying that this was only slightly illegal? Because I think that's rather like the curate saying, you know, excellent in parts, my lord, or a woman saying she's only half pregnant. So I think that at the end of the day, the advice that should have been taken by this government was from its law officers. There may be many noble lords in your lordship's house who don't agree with the judgment of my noble friend Lord Keane, but he said that this was legal. I believe it to be legal, and for that reason I will be voting against Lord Judge's amendment and supporting this bill.
I call the next speaker Baroness Kennedy of the Shores.
Let me join with others in welcoming new members to this House and hope that they have had as happy and fulfilling a time as I have had. I wanted to also add my respect and admiration for Lord Judge and indeed for all the other noble lords who have spoken up for the rule of law and our obligations under public international law. Some members of the House have spoken about...
We can't hear you. Can somebody please try and change the sound for you, and we'll come back to you?
My Lords, in view of Lady Kennedy's difficulties, we will move on to Lord Lisvane.
There is so much wrong with this bill that it's hard to know where to start, apart from, of course, warmly congratulating and welcoming today's maiden speakers, Baroness Hayman of Alloch and Lord Saffraz. 3 points. First, the use, or I should say abuse, of delegated powers. The Delegated Powers Committee has done its usual excellent job, and it notes that this bill contains 11 delegated powers and describes some as extraordinary, others as unprecedented. There are 7 Henry VIII powers, allowing ministers simply to rewrite primary legislation with a much lower level of parliamentary scrutiny and public exposure. Overall, the bill exemplifies the decline in the legislative process, which I've observed for nearly half a century. Now it is, I fear, a disaster area, which the promised Constitution, Democracy and Rights Commission should examine as a high priority, although I have little hope that it will do so or that it will be allowed to do so. Second, the bill's effect on the devolution settlement. It successfully united 3 of the constituent parts of the presently United Kingdom in a chorus of execration at what they see as an attempt to undermine the devolution settlements and to change the nature and scope of reserved powers. Noble lords are expressing strong views on this aspect, but I would simply draw the attention of your lordships to the Act of Union Bill, which I introduced towards the end of the last Parliament, and in which the Constitution Reform Group, chaired by Lord Salisbury, seeks a more effective and equitable settlement between the constituent parts of the United Kingdom. A moment ago, I described it as the presently United Kingdom. I don't think that history will deal kindly with an administration that contrives to take us out of not one union, but 2. And I conclude with the rule of law issues. Yes, Parliament can legislate in the way proposed. Of course it can. But it should not, and I suggest must not. The rule of law is not something just for lawyers and academics. It is for us all. As my noble and gallant friend Lord Stirrup said, if I break the COVID-19 restrictions, will the government come to my aid when I say, yes, I was breaking the law, but only in a specific and limited way? Now, the attempt to present the law-breaking powers in the bill as more acceptable by making them subject to approval by the House of Commons is, I suggest, naive. It is as though I were to say to your lordships, I have a revolver, but don't worry, it's empty. I've given the ammunition to a friend of mine. But when I ask, he'll give it back, and I'll put the rounds into the weapon. The answer is, of course, that I shouldn't have the revolver in the first place. I shall certainly vote for my noble and learned friend Lord Judge's regret motion, and when the bill goes back to the Commons, it should do so without at least Part 5. What happens then? I agree with my noble friend Lord Butler that this is an issue on which your lordships should be prepared for a bumpy ride. It would not be possible to use the Parliament Acts in the time available, so the government would have to rethink its approach. And please, my lords, let us have no chuntering about the Salisbury-Addison Convention. In 2006, the Joint Committee on Conventions of the UK Parliament acknowledged the change in the nature of the convention over time. That's hardly surprising, as it arose from very specific circumstances 75 years ago, but they still linked it only to manifesto commitments with a reserve responsibility of this House in exceptional circumstances, as the noble Lord McNally reminded us. No one could seriously suggest that departing from the rule of law has received electoral approval. So I suggest that your lordships should not be deterred by any assertions of unconstitutionality. If there is unconstitutionality anywhere, it is in this bill.
My Lords, I believe we can now hear from Baroness Kennedy of the Shores.
I'm very sorry if people couldn't hear me. I hope you can hear me now. Can I just start by welcoming our new members to the House? Let me also add my respect and admiration for Lord Judge and all the noble lords who have spoken in support of the rule of law. I would have thought all of us would be committed to it. Some of our colleagues have mentioned our role as a revising and scrutinising House, but our role goes beyond that. We are stewards of the Constitution, those of us who have the fortune to be in this House. We are also the protectors of the rule of law. We are the people who guard rights, who preserve for future generations the things that really sustain this society. We are also the people who are supposed to look at the long term when government may be pressed into or encouraged to think short term. I am going to urge that this House does support Lord Judge's amendment. I'm a director of the International Bar Association now, as well as a practitioner at the English Bar. And I recently hosted 2 webinars on this very bill, and thousands of lawyers attended from not just the United Kingdom, but around the world. One of the webinars was on the impact on international law, and the other on the effects here in the United Kingdom. The legal profession in this country is absolutely united in its opposition to the bill. The bar councils, the law societies, the lawyers and judges. It's a very small club indeed, let me tell you, who think this bill does not contravene the rule of law. And it seems to me to be following a trend, a regrettable trend, of undermining law more generally, where we're seeing attacks on lawyers, we're seeing attacks upon the judiciary and an effort to undermine the judiciary and their discretion, and we're seeing also attacks upon judicial review and other aspects of law. When the webinars took place, international lawyers, much to my surprise, engaged from all over the world, shocked at the fact that Britain was doing this, and said it's to you that we look when we're having difficulties with our own governments. It's to you in the United Kingdom that we look as the standard bearer for the rule of law. One of our distinguished commercial judges, recently retired, said that the city's position as a world-leading financial services centre is underpinned by our reputation in law. That is not something to play around with, even if you're doing it for a pragmatic reason rather than out of principle. And like 1 or 2 others have said, this is a matter of principle. And I do believe that principle at times has to take precedence on your party loyalty. Lord Neuberger, in one of the webinars, reminded us that we are asking for a lot of our citizens at this time in the United Kingdom because of the pandemic, asking them to abide by certain rules that constrict their lives. We're asking them to obey the law. And that our government should be dismissive of law and be prepared to break law at this time sends a very bad message. The government should listen, and it should remove the offending clauses and the whole of Part 5. I'm afraid that to disregard the law is really a very poor prospect for this country.
Next speaker, Lord Alderdice. Our microphone appears not to be unmuted.
My Lords, my perspectives are shaped by my Northern Ireland roots and the implications I draw from Part 5 of this dangerous bill. The inevitable consequence of Brexit was a series of difficulties with the Belfast Good Friday Agreement, which had brought to an end not only 30 years of terrorism, but also a disturbed historic relationship with Ireland that went back many centuries. Those of us who spent many years of our lives negotiating and implementing that agreement had assumed that if we could find a new future for the people of our islands, we could find a way of maintaining our relationships with the rest of the European Union. However, when it became apparent that Brexit was the will of a majority of people in England and Wales, the challenge was to negotiate arrangements that would maintain the Good Friday Agreement while taking the United Kingdom out of the European Union and at the same time hold together the constitutional union of England, Scotland, Wales and Northern Ireland. Since Northern Ireland's relationship with the rest of the UK and Ireland was already a singular one, it was clear there would be significant challenges, especially if the British government chose to leave the customs union and the single market. This was widely discussed in Northern Ireland during the referendum campaign and was probably the chief reason that the Ulster Unionist Party became pro-Remain. When Mr Johnson became Prime Minister, he and his party, including the members of the European Research Group, abandoned their Democratic Unionist allies and last October signed up for the revised protocol on Northern Ireland that Mr Johnson had negotiated. The DUP were betrayed, but Mr Johnson went on to fight the election on what he called this, quote, good arrangement reconciling the special circumstances in Northern Ireland with the minimum possible bureaucratic consequences at a few points of arrival into Northern Ireland, close quotes. The Conservative Party won the December 2019 general election, their manifesto based on the Great New Deal that the Prime Minister said he had done. Now, in presenting this bill for the approval of your Lordship's House, he has abandoned the commitment to the British people on which he was elected and seeks not only to break his manifesto commitment, but also international law. But we should not be surprised. The Prime Minister has been entirely consistent. He has never felt a need to be bound by any commitments he makes to people, nor by any rules or law. He was even prepared to mislead Her Majesty the Queen into approving a prorogation of Parliament, advice ruled to be unlawful. And now he wants the rest of us in Parliament to collude with him in a flagrant breach of international law. That, my lords, creates a constitutional crisis. For while this House should generally restrict itself to giving advice to the government of the day, it has, I believe, a responsibility of constitutional guardianship, which has now been called into play by the government's premeditated breach of international law. Even the tabling of this bill is a breach. It is possible in the short term to toss facts, truth and law to the side. But as this government is beginning to discover, facts, truth, the law and broken relationships have a way of coming back to bite. Bluster, hyperbole and waving one's arms around does not impress the COVID-19 virus, nor increasingly does it convince ordinary people in this country. When one does manifestly the wrong thing, not make a mistake, but do what is morally wrong and unjustifiable, history will find you out. Members of your Lordship's House who support this government's disregard for the law should reflect on how past leaders have been hauled before the bar of history and their reputations irreparably shredded. It may even be that today's remarkable debate in your Lordship's House is the beginning of the end of this government, for this is not a mistake or a misjudgment, but a consistent pattern of behaviour which must be stopped before it destroys our United Kingdom.
I call the next speaker Lord Barwell.
My Lords, can I start by congratulating Baroness Hayman and Lord Sarfraz on their maiden speeches and for their extreme skill in staying uncontroversial on this most controversial of topics. My Lords, I find myself in a curious position, wanting to defend today a withdrawal agreement, parts of which I strongly disagree with. Those of your Lordships who know my background will know that I preferred a different withdrawal agreement, negotiated by the former Prime Minister. And the current Prime Minister and many members of the government opposed that withdrawal agreement and the backstop within it because they argued there was no way out of it and it would be unthinkable for the United Kingdom to break international law. What was once unthinkable is now government policy. And as Lord Judge said, we are being asked in Part 5 to give ministers powers to break the law, powers to override that agreement that was not some dim and distant past but agreed just a few months ago. And what justification are we offered for that course of action? Well, we've had two. The Prime Minister, in an article, said that these were incredibly turbulent times, it was all done in a bit of a rush, and now problems have come to light. And it has also been suggested to us that the EU have been unreasonable. I will leave it to your lordships to decide whether you believe the EU's approach is unreasonable. I doubt I will convince anybody on that point. But what I would say is it has been entirely consistent. From the word go, they have argued that there could be no free trade agreement without a resolution of the issue in Ireland and Northern Ireland, and that the UK could never have a Canada-style agreement because of our geographical proximity. And the issues that have come to light, and which this bill seeks to address in relation to customs declarations, exit declarations if goods come from Northern Ireland to Great Britain, or state aid, they've not materialised overnight. They're in the withdrawal agreement. The explanatory notes for the bill say that they're in the withdrawal agreement. So these are consequences of the agreement that the Prime Minister signed, and they are consequences that were pointed out by those of us that had reservations about that agreement at the point at which it was agreed. And indeed has made very clear there was no need to go down the course the government has gone down in this bill. Article 16 of the withdrawal agreement provides a procedure if the agreement is leading to economic, societal or environmental difficulties where parties can take unilateral action. And none of these things are the real reason for what has happened to your lordships. The real reason is that David Frost, the Prime Minister's chief negotiator, asked Number 10 to come up with something that would shift the EU in its negotiating position. My noble friend Lord Hamilton asked why the Secretary of State for Northern Ireland said what he said. He said those words because he was told to say them. And the opposition of this House, of 5 former Prime Ministers, of the Right Noble Prelate, the Archbishop of Canterbury, is what Number 10 wanted. It wanted to demonstrate to the European Union the extent to which it was prepared to take a different approach from all previous governments. I will end by just making 2 very brief points. First is that I am not a lawyer, but you do not have to be a lawyer to think that the rule of law matters. This is not some abstract concept. It has real-world consequences. On Friday, Moody's downgraded the UK's credit rating, and they referred to the weakening in the UK's institutions and governance in recent years. And the final point that I would wish to make is that the tragedy of this bill and the situation that we find ourselves in as a country is that the reason that the Brexit negotiations have proved so difficult is because the EU believed all along that the UK might end up breaching faith. And I well recall a meeting that I was in with Theresa May, with EU officials, where she argued why did the backstop have to be set out in all of that operational difficulty, and was told, because bluntly, we do not think you will be there for much longer, and we do not trust what is going to follow in terms of living up to any commitments. So that is the tragedy of this bill. This behaviour was predicted and is one of the reasons we are in this problem. And let us hope that we reach a deal, that the government can withdraw these clauses, and we can find our satisfactory way out of this situation that we now find ourselves in.
I call the next speaker Lord Hope of Craighead.
My Lord, it's a real pleasure to follow such an impressive speech by the noble Lord Barwell. For myself, I wish to concentrate on the consequences of this bill for the devolution settlement. I'm aware that this issue may seem to be a sideshow compared with Part 5 of the bill, perhaps a moment, especially for those of your lordships like me participating virtually, to go away and do something else. But like so many others, I urge your lordships to take notice of it and to take it very seriously. Frictionless trade against all parts of the United Kingdom is, of course, what we all wish and must aim for. But this depends on the principles of cooperation and on mutual trust between all 4 nations. As presently drafted, this bill and the way it has been introduced is deeply damaging to those principles. Mutual trust between the nations has never been lower than it now is. Scotland has refused to give legislative consent to the bill, and Wales, as we have heard, has indicated that it cannot give consent to the bill in its present form. Of course, this Parliament can do what it likes, but a different approach is essential if the Union is to hold together against a growing trend towards fragmentation that, if this government is not very careful, will bring our precious Union to an end. My Lords, the devolution settlements were guided by the market access principles of proportionality and subsidiarity that operate under EU law. There was room for a carefully worked out devolution of legislative power, which enabled the devolved authorities to pursue their own legitimate policy aims as to the sale of goods where, in their judgment, this was in the public interest. Nobody doubts that the way this freedom has been handled works well at present. It is not in any way a barrier to trade between our nations. On the contrary, it has real benefits. It enables new trading policies to be tried out in one area before the rest. The bill itself accepts that such divergences as exist at present can remain. What the bill seeks to do, however, is to replace the freedom to develop local standards or separate policy aims in the future with centrally driven, overriding market principles. It does not seek to repeal the various exceptions to the list of reserved powers that are set out in the statutes, but its effect would be the same, as there would be no stopping traders bringing goods in from other areas that do not conform to the home area's rules. The devolved powers are rendered worthless by this new system. UK ministers are given powers to do things which contravene the devolution settlements without consultation, let alone consent. The opportunity to create an internal market by agreement through the continued development of common frameworks, about which Baroness Andrews spoke so well earlier today, is being undermined because it is being ignored. The common frameworks are not even mentioned in this bill. The effect of the bill has been described as a power grab by the Scottish National Party. I'm not given to hyperbole, which I thought this was, but now having read the bill and the well-founded and withering report of the Constitution Committee, I can see why this expression has been used by them, and now in Wales too. There is something very far wrong here. That is the challenge that we face. We do not need this bill, but if we have to have it, it must be put right.
Baroness Neville-Rolfe.
My Lords, I congratulate my noble friend Lord Saffraz, a dynamic entrepreneur, on a very fine maiden speech, and also Lady Hayman of Ulrich. I look forward to you boosting the parliamentary choir and hearing a bit more about that Welsh farm. I rise to pursue 2 points. First, I want to address the operation of the internal market provisions, and second, I will comment on the great issue of the day and provide some much-needed support for the government's position. The bill makes a great deal of sense. We need the internal market to function smoothly. As we leave the EU single market, our own UK single market will be even more important. As an economist by training, I believe in the theory of comparative advantage, and that applies across the UK. We need to avoid protectionist measures. So, for example, the Scots and English can exchange Scotch whisky and London gin without hindrance or charge. I apologise for resorting to GCSE economics, but the point is a very important one, and the point is equally valid for services, 80% of the economy. I declare my interest in the register. That does not mean small variations in law need to be prevented. The Scots have different rules on minimum alcohol pricing, and the Welsh were early regulators on plastic bags, both areas in which I'm interested. And that has worked fine. But devolution can only go so far, or it will harm the common interest immeasurably. I'd like to congratulate my noble friend the Minister on producing an impact assessment and his help with getting the promoters of the Agriculture and Fisheries Bill to do the same. However, it is disappointingly light on numbers. I think a better effort could have been made at economic assessment and at the dynamics of growth, or lack of it, with a proper free market, and that this would have shown how vital the UK internal market measures in this bill in fact are. I also have a question for my noble friend. Why has the Competition and Markets Authority been chosen to gather information and monitor the new arrangements in a fancy new office for the internal market? Now, I can see the advantages in terms of recruitment and retention for the CMA. However, they are much more focused on the consumer than on business success. And at a time when we face grave economic difficulties, I find this worrying. It's also a politically charged area, so does it really make sense to delegate these vital powers to a supposedly independent body? PHE and Ofqual spring to mind as not wholly satisfactory analogies. Now, much has been said about Part 5 of the bill. I agree that, in principle, this approach is undesirable. However, there is at least a theoretical possibility that EU action could place the UK in an impossible position as regards the coherence of its own internal market. If that came to pass, we would be presented with a very unpleasant choice. The real problem stems from the nature of the withdrawal agreement, which the present Prime Minister inherited in an extremely unsatisfactory state from the previous administration. As my noble friend Lord Hull hinted, the UK-EU Joint Committee has not stepped up to the mark in resolving the issues for whatever reason, as they would have done had everybody acted in good faith. So having a safety net provision in the bill for use in extremis, and only after a special parliamentary vote, is probably the least damaging way forward. The fact is that treaty requirements do sometimes conflict with one another, and some member states fail to observe important treaty provisions, such as the Maastricht criteria, as my noble friend Lord Lamont reminded us so eloquently earlier today.
I call the next speaker Lord Hendy.
To follow the noble lady Baroness Neville Rolfe. I too welcome my noble friend Baroness Hayman and the noble Lord Sarfraz to the House and compliment them on their excellent speeches. My lords, like so many others of your lordships, I share the view that the bill would cause this country to be in breach of the rule of law. Having spent over 40 years in practice at the bar, over 30 years of them in silk, I consider myself, like other Queen's Counsel in this House, to be under a duty to oppose this bill on that ground. I support the noble and learned Lord Judge in his amendment. Lords, I shan't weary the House by repeating in a pedestrian way the arguments so elegantly and powerfully put by him and others. I wish to raise another and different point. The bill seeks to create a uniform internal market for goods and services, but it says nothing about the protection of those who actually make or provide the goods and services, the workers of the United Kingdom and beyond. I use the term worker as a lawyer, meaning someone who works for a living, whether under a contract of service or a contract for services. The EU single market, from which this bill takes inspiration, had much in the way of protection of affected workers. This bill has nothing. I accept that labour law, the law of the workplace, is not a devolved matter and therefore applies across the UK with minor variations in Scotland and Northern Ireland. But this doesn't avoid the issue of social dumping. It is entirely foreseeable that measures are taken in Wales, Scotland and Northern Ireland to protect workers in those countries from being undercut in England or abroad. Take, for example, agriculture. In 2013, the coalition government abolished the Agricultural Wages Board for England and Wales, a negotiating body representing employers and workers, the agreement of which on wages, housing costs, and of course, dog allowances became binding on every farmer and farm worker in England and Wales. The board was originally set up in 1924, a daughter of the Trades Boards Act of 1909. Scotland retained its AWB. The Welsh government, having lost the AWB for England and Wales, set up its own under its devolved power over agriculture. The UK government considered it intolerable that Wales should exercise this kind of sovereignty to maintain higher pay rates for its farm workers, and therefore challenged the Welsh government in the courts, a case it ultimately lost in the Supreme Court. Wales therefore retains now its own AWB. In consequence of the COVID catastrophe, there will be more such differential measures of worker protection. Even before COVID, the Welsh and Scottish governments were considering the use of conditions attached to public procurement contracts in order to enhance worker protection and to develop social dialogue with trade unions, a concept alien to the government in Westminster. This bill should make provision for permitting national governments to discriminate on goods and services in order to maintain labour standards, as well as on the grounds set out in Schedule 1. I propose to move an amendment to this effect at committee stage, should the bill proceed.
Lord Brown of Eton under Hayward.
My Lords, always good to follow my old friend Lord Hendy. Lords, I too start by welcoming and congratulating the two excellent maiden speakers. I have to say, I doubt they were as nervous as I am making my maiden remote Zoom speech. My Lords, I shall vote for Lord Judge's amending motion here. Like him and so many others who've spoken in this remarkable debate, I too deplore these clauses 42 to 47 in part 5, and I express my deep regret that this great country of ours champions for centuries of the rule of law domestically and internationally has reached the point of prospectively repudiating binding treaty obligations entered into less than a year ago. The damage to our international reputation and standing needs no additional emphasis from me. Similarly, the damage to our prospects of finding, as now we need, trusting new treaty partners, and the damage mentioned by Baroness Kennedy of the Shores, the damage to London's standing as the economically very valuable centre of international legal practice and dispute resolution by both litigation and arbitration. My Lords, I now want to turn to a rather different aspect of this Part 5. It's my contention that not merely are these clauses unlawful and intrinsically objectionable in principle, therefore, but they are quite unnecessary. They're quite unnecessary, let me say, unless quite outrageously they're in the bill merely to shift the dial, to try to bully the EU into a more helpful stance, as Lord Barwell tended to suggest. But assuming that they're in the bill for good faith reasons, I strongly agree with Lord Stirrup. Were it ever to be necessary to legislate to breach international law, well, then that should follow, not as here precede, that need. But I would go further and say it never would be necessary. And I'll explain why. Naturally, I recognise the imperative under the protocol that it's applied to honour and not imperil the Belfast Agreement, and that it doesn't destroy the essential unity and integrity of the United Kingdom internal market. Now, this requires reaching sensible, workable agreement by negotiation, or if necessary, by the decision of the Joint Committee under Article 16, on, for example, issues like what are reasonably to be regarded as goods at risk. But if, and this is really the crunch point, if, as the government says, it truly fears the EU playing hardball on the wider negotiations, are threatening to act quite unreasonably, to act in bad faith in its interpretation and application of the protocol, then instead of our preemptively, as these clauses do, breaking the agreement ourselves, we would be able to treat them as being in breach. And this would entitle us not merely to invoke, as we would, the dispute resolution mechanisms provided for, but meantime, temporarily, pending the eventual outcome of any arbitration, to take all necessary and proportionate measures to protect our fundamental interests which obviously include the Belfast Agreement. And so that's it. Both parties owe the good faith obligations, and that is plain under Article 5 under the Vienna Convention. Neither side is entitled to act unreasonably, and such as to frustrate the essential objects of the agreement. And with those thoughts in mind, it seems not merely outrageous in principle, but in fact, the ultimate absurdity to include provisions which could never be properly required, given that there is, as government fears, bad faith on the EU side. Thank you.
I call Lord Vasey of Didcot.
My Lords, may I begin by congratulating Baroness Hayman and Lord Savras on their excellent maiden speeches during the second reading debate. This is the first debate I've taken part in where I've had the opportunity to have a dinner break and the chance to discuss with colleagues how the bill is progressing. And one of them, I thought, made rather an interesting remark that you know the government's in trouble when the debate has barely got going before they're condemned by a former Lord Chief Justice and by the Archbishop of Canterbury. But maybe there is something that we can salvage during the second reading debate. I think the first point that all of us must remember is that this bill is still an important and necessary bill, leaving aside the controversial Part 5 and Clause 47. After Brexit, we do need an internal market bill, and as was remarked earlier by the noble Lord, Lord Cavendish, we've had an internal market in this country for 300 years. It was taken over effectively when we joined the European Economic Community, and now as we leave the European Union, the government must make provision to restore, as it were, the Union and the internal market that existed before we became members of the European Economic Community. And certainly it is my impression that although there is a lot of politics surrounding some of the provisions in terms of putting in place the internal or replacing the internal market, none of the devolved assemblies will lose powers that they already have and will have the same powers when this bill begins to pass. So in that sense, perhaps I could say that the glass is half full. But we face, of course, some very controversial measures in this bill, and they are entirely of the government's own making. We face a conundrum which has been present ever since the country voted for Brexit and ever since we started looking at how we could implement the referendum result. And that was either to have a border between Ireland and Northern Ireland, or a border between Northern Ireland and the rest of the United Kingdom. The then Prime Minister Theresa May tried to find a way out of this conundrum, and she did so, I think, very elegantly by seeking to keep us within the customs union. And indeed, I voted when I was in the other place for her withdrawal agreement, and I was fond of remarking to some of my more ideological colleagues that I had voted for Brexit more times than they had. But then the government decided to return to a form of Brexit which brings us to where we are today, where inevitably we have to choose potentially between a border between Northern Ireland and the rest of the United Kingdom, or a border between Ireland and Northern Ireland. But again, my glass gets slightly fuller, because I do think that there may be a way out of this impasse. We know that despite the confrontational attitude that seems now to be adopted by both sides, who are negotiating the future of millions of people, both in this country and the rest of the European Union, there is potentially a way forward, and we may have a free trade agreement. And indeed, the European Union has said that it will hold a special council in order to achieve that. And I hope very much that that will come about, because if it does not come about, and what we see the provisions contained in this bill, if we see them reach a conclusion without a free trade agreement, then we face some very serious consequences. If we preserve, as I hope we will be able to preserve, the internal market in the United Kingdom, but we do so under the provisions of this bill without a free trade agreement, then it seems to be inevitable, my lords, that we will get a hard border between Ireland and Northern Ireland, one either that Ireland itself feels it has to impose or the European Union chooses to impose on its behalf. And that will be extremely damaging for everyone in this country.
I call the next speaker Baroness Finlay of Llandar.
My Lords, among the historic speeches today, including superb maiden speeches, I venture to address part 1, the application of market access principles to goods and public health. Why does the government say this part of the bill is necessary to ensure that no new barriers arise to trade after the end of EU transition? How might these barriers arise, given that on the 1st of January, the whole UK will be governed by retained EU law? The current legal frameworks, which limit but do not eliminate the rights of the devolved institutions to implement progressive policies in areas such as food safety or labelling, will still be in place. But, my lords, I expect the government will warn that barriers could arise from new policy initiatives from the devolved governments. That is why they propose automatic application of market access, meaning that any goods which can be legally sold in one nation must automatically be offered for sale across the whole UK. What does this mean in practice? If, for example, the Welsh Government wishes to change food labelling to improve warnings on the sugar or fat content, or wants to ban sugary fizzy drinks, they could, in theory, still do so. But the law would be wholly ineffective because products legally made in or imported into England and which did not comply could be freely sold in Cardiff and Carnarvon. This would neuter the ability of the elected legislatures in Cardiff, Edinburgh and Belfast to act within their devolved competences. My lord, there is no imminent threat which renders this necessary. For the last 3 years, all 4 governments have been working to create common frameworks in those areas which the government here in Westminster identified as requiring limits on the extent to which any one part of the UK could diverge from the standards we will inherit through retained EU laws. Quietly and without any publicity on it in this House, good progress has been made on developing these voluntary frameworks, which will bind all governments by each forswearing the right to diverge too greatly. A great deal of work has been undertaken by the committee, chaired by the Noble Lady Baroness Andrews, and which was reported to the House on the 24th of September. Now, this bill renders all that work superfluous. The government, representing the overwhelming share of the UK economy, is reneging on its commitment to the agreed frameworks. It can do whatever it wants and whatever it agreed in a trade deal without consulting the devolved administrations. This bill stops devolved governments from adopting more progressive policies. It suddenly changes the rules of the game from those agreed and seems to tear up the common frameworks approach that devolved administrations have been supporting. Amendments in my name seek to protect these negotiated common frameworks and ensure that market access principles are only used when all efforts to agree a common framework have failed. Thank you.
My Lords, Baroness Gardiner-Parkes has withdrawn from the debate, so I call the next speaker, Baroness Crawley. Baroness
My
Crawley.
Lords, I welcome Baroness Hayman of Ulloch and Lord Saffras, and I commend their excellent contributions today. My Lords, this bill comes to us with a reputation, rather like the Vikings: dangerous, unloved, little respect for the law, and disrespect for the kingdoms of Great Britain. It obviously leaves out the pillaging, for which much thanks. First, to add my voice to the rising chorus against Part 5 of the bill, which, as we know, allows parts of the Northern Ireland Protocol to be disapplied. The protocol, being part of the withdrawal agreement, is an international treaty and trumps, if you'll excuse the expression, domestic law. Lord Judge is right. Part 5 must go. But, replies the government, the EU is acting in bad faith. However, there is no evidence. Show us the evidence. No evidence at all for that, states our own House of Lords European Union Committee. My Lords, are we really no longer a member of the international rules-based order? Because I didn't get the memo. Perhaps this bill is the memo. This bill allows ministers to make regulations that are inconsistent with the UK's obligations under Article 4 of the Withdrawal Agreement. But, says the government, we may never use these powers. We'll just threaten to break the glass, pull the emergency cord. Meanwhile, not actually being in breach of the state aid and customs provisions of the Northern Ireland Protocol. Ireland, my lords, our nearest and most important trading partner, does not agree. And on the government's claims that these disapplying provisions are needed as a safety net against the possibility of a no-deal Brexit, the Irish government have been very clear that the protocol is designed and indeed empowered to operate in all circumstances, including the absence of an agreement on the future relationship between the EU and the UK. The UK government may disregard the views of the Irish government, but may wish to take notice of the House of Lords Constitution Committee and the House of Lords European Union Committee, whose recommendations on this sorry bill are damning, to say nothing of the views of the Anglican Church. The second and final point I wish to make is as a member of the new House of Lords Scrutiny Committee on Common Frameworks. There are strong arguments made by my noble friend Baroness Andrews earlier, and many others, that common frameworks are better instruments for creating the new internal market than is this bill. Indeed, it was the government itself that said that common frameworks and the programme that they imply would in fact map out the area of the UK internal market. These frameworks, be they on food safety, emissions trading, company law, whatever, have been worked up in partnership with the devolved administrations. And though based on regulatory consistency, respect the flexibility of the devolved settlements, as did the EU. Could the noble Lord the Minister say why the government is not putting its energy into these consensual frameworks rather than this divisive bill?
Ms Ludford. My Lords, I add my congratulations and welcome to the maiden speakers, whom I look forward to getting to know. I sincerely thank our committees on the Constitution, EU Affairs and Delegated Powers for their expert and powerful reports. Part 5 of this bill, with its attempt to override an international law commitment in an agreement the government itself signed and then enshrined in domestic law less than a year ago, is breathtaking. The comment by the Secretary of State for Northern Ireland that this bill breaks international law in a specific and limited way is destined to go down in history, similarly to economical with the truth. It was commendable, if regrettable, that the noble Lord Keane of Ely felt compelled to resign, as of course did the Treasury Solicitor Sir Jonathan Jones. I regret that this means we do not have a law officer here to answer the debate. The noble Lord Wilson of Dinton pithily summed up the situation in testimony to the Constitution Committee. The constitutional position is that this bill is an outrage, and the political position is that it is hugely damaging to our reputation internationally. And the Constitution Committee concluded that Part 5 clauses represent a disregard for the rule of law. The bill is only one aspect of the cavalier attitude of Conservative governments in the last few years to the law and constitutional convention. Examples include trying to trigger Article 50 without parliamentary approval, illegal prorogation, launching a tax on lawyers as lefty human rights lawyers, activists and do-gooders. Was it any coincidence that a knifeman threatened to kill a solicitor last month? Then they are grossly under-resourcing the justice system, taking back control not for Parliament but for itself through an accumulation of executive power and overuse of statutory instruments, to the extent that led legal commentator for the Financial Times, David Alan Green, to call it government by decree. He actually quoted Lord Hewitt, a Liberal politician and judge who became Lord Chief Justice, and who said in his 1929 book, The New Despotism, that, quote, the strategy is different from the old despotism of Charles I, but the goal is the same. It is to subordinate Parliament, to evade the courts, and to render the will or the caprice of the executive unfettered and supreme. Sounds very modern. The government's claim that the bill is simply an insurance policy or safety net has spectacularly backfired. As our EU committee observed, it has in effect placed the United Kingdom in the wrong. The EU accordingly responded by insisting on tougher enforcement provisions and sending a letter of formal notice, the first step in infringement proceedings. The Irish Equality and Human Rights Commissions from North and South, as well as the Anglican primates, have expressed deep concern that the Irish protocol to the withdrawal agreement might be breached and the human rights and equality provisions of the Good Friday Agreement overridden. Then, as the Bingham Centre for the Rule of Law notes, the idea of Magna Carta, that no one is above the law, is a source of global inspiration. And the Bar Council and Law Society highlight the prejudice to the position of London as a centre for international practice and dispute resolution, and to our attempt to accede to the Lugano Convention. The 20th anniversary of the Human Rights Act has just passed, and it is the 70th anniversary of the European Convention on Human Rights in a few weeks. It was a Conservative lawyer and politician, Sir David Maxwell Fyfe, as he then was, who was largely instrumental in drafting the ECHR. It is shameful not only that the modern Conservative Party is weakening its commitment to the Convention and the HRA, but that our Prime Minister had to be forced by the EU, in order to protect security ties, to pledge not to materially alter the spirit, whatever that means, of the Human Rights Act. This was billed as a compromise by Mr Johnson. My Lords, Part 5 of this bill is a disgrace. Lord Howard was quite right in saying that Parliament should fix this bill, not leave it to the courts. Hence, the regret motion of the noble and learned Lord Judge should be supported.
I call the next speaker, Lord Jay of Ulm.
My Lords, there is much in the Internal Market Bill which I am happy to support, but I have two reservations. The first is devolution, bringing back for settlement within the United Kingdom questions which have for a generation been settled at the level of the EU was always going to be difficult. This is particularly so if, as I suspect, the United Kingdom is moving in the direction of a federal state, one of the great ironies of Brexit. The right way forward must surely depend on genuine consultation and negotiation among all four countries of the Union, as has been happening over common frameworks. The bill seems to be putting all this unnecessarily and indeed dangerously at risk, for reasons which I simply do not understand, though look forward to Lord True explaining why tomorrow. My second reservation relates to Part 5 of the bill. I have read the reports of the EU Committee and the Constitution Committee and the Bingham Centre's analysis of the bill, and I agree with every word of the letter from the Most Reverend Primate, the Archbishop of Canterbury, and his colleagues. It is clear that clauses 44, 45, and 47 would constitute a breach of international law, and as the Bingham Centre's report makes clear, and I quote, "A breach of the rule of international law is a breach of the rule of law." And these clauses go against all that the United Kingdom has stood for nationally and internationally for as long as I can remember. How can we persuade other countries to observe the rule of law if we are willing to break it ourselves? These clauses not only contribute nothing to the Brexit negotiations, indeed, it seems to me rather the reverse, but also reduce the future effectiveness of global Britain. They must be removed from the draft bill. And meanwhile, I will be glad to support the motion in the name of my noble and learned friend, Lord Judge, tomorrow. Thank you.
Baroness Stroud.
My Lords, I want to begin by adding my congratulations to Baroness Hayman and Lord Sarfraz on their maiden speeches, and I look forward to hearing further contributions from them both over many years. The bill that we have before us today is a bill that, as we've heard, makes provision for the continuation of the UK's single market when the transition period ends on the 31st of December. This single unified internal market is a key block in the constitutional foundations of the United Kingdom. It is my understanding that the 1707 Articles of Union between England and Scotland and those between Great Britain and Ireland in 1800 abolished all customs duties between the different parts of the United Kingdom. Accordingly, free and uninterrupted commerce across all parts of the newly United Kingdom was seen as one of the most important advantages of the Act of Union, particularly in Scotland and Ireland, whose citizens could freely trade into and out of the larger English market. When Ireland was partitioned and the separate Parliament of Northern Ireland was established, the Westminster Parliament was careful to ensure that Northern Ireland and Great Britain should continue to remain a single integrated internal market. The devolved legislatures in Scotland and Wales were created after the UK had joined the European Community. Because the EU single market rules on free movement of goods and services and on state aid apply to regional governments and legislatures as well as the central governments of member states, there was no need during our EU membership for specific UK-based rules maintaining the UK internal market against fragmentation. Now that we are approaching the end of the transition period, a vehicle is needed to maintain the free flow of trade across the nation in the post-Brexit world. As we are all aware, though, there are two clauses in particular that will be subject to much debate and has already been subject of much debate during the passage of this bill. These would allow the government to restrict the so-called direct effect of two parts of the Northern Ireland Protocol, which is part of the EU withdrawal agreement. These clauses have the goal of protecting the basic functioning of the United Kingdom's internal market as it operates between Great Britain and Northern Ireland in the event that it is not possible to reach an agreement with the EU on the UK's future relationship with them, and of allowing state aid in Great Britain to be dispensed under a framework of rules devised in this country rather than being subject to EU Commission control and European Court of Justice jurisdiction. During the passage of this bill, it is my intention to focus on and scrutinise first the degree that under the UK's constitutional law, international treaties in general do not form part of the law. It is my understanding that where an international treaty has made it necessary to make changes to the UK's internal law in order to comply with it, the general practice has been for Parliament to pass legislation to make any necessary changes to the law. Second, the degree to which the jurisdiction clauses represent a gross departure from normal international treaty practice, under which sovereign states simply do not accept binding rulings by the courts of the other treaty party, and only agree to subject themselves to neutral international courts or tribunals. And third, the degree to which, as a matter of UK constitutional law, the UK Parliament is entitled to legislate to remove direct effect from part of, or indeed, if it so chose, the whole of an international treaty. My Lords, I look forward to engaging in the debate on this bill and hope that in doing so, we can find a way through that addresses the challenge that this bill seeks to address, and remember that having UK law subordinated to EU law and to ECJ rulings was one of the main drivers leading to the British people's decision to leave the EU.
Bethan and Oaksey.
My Lords, while listening to the many powerful speeches which have condemned part 5 of this bill, I wondered to myself how the arguments in favour of these controversial provisions might be best presented. First, the phrase breach of international law is a loose expression, and the Minister in the Commons might well wish now that he had not used it. What is contemplated here is a breach of an obligation arising under an international treaty. That, I think, is a better way of defining the matter, because this is a contractual problem of quite a familiar sort. One party to the agreement wants to tear up certain provisions that it does not like. Second, it is probably accurate to say that the contemplated breach is potential, not actual. The Constitution Committee has concluded that this is an open question at paragraph 152 of its report. The actual breach may only occur if the power to disapply parts of the Northern Ireland Protocol is in fact exercised. So it can be argued that there is no current breach of a treaty obligation, only something rather less objectionable, the equivalent of a solicitor's letter saying, "We intend to continue to negotiate in good faith, but you need to know that we reserve all rights, and in particular, we reserve the right, if we have it, to tear up parts of the present agreement that we do not like, if it seems to us necessary to do so." This is close to being what English lawyers call a repudiatory anticipatory breach of contract, but it is probably just the right side of the line. Third, Article 184 of the agreement requires both parties to use their best endeavours, acting in good faith, to negotiate the agreements referred to in the political declaration. That obligation should be read as being informed by the recitals to the Irish Protocol. These repay careful reading. In particular, the parties affirm that, and I quote, "the Good Friday Agreement should be protected in all its parts." There is ample scope, it seems to me, for argument of what may follow from this. It may be argued, and the government has already argued, albeit faintly and without particulars, that the EU has in various ways itself been in breach of this good faith obligation. So, reserving the right at some future point to disapply certain provisions of the agreement is not, it may be said, properly characterized as an outrageous and unlawful threat to renege. It is something different, namely making it clear that if the EU persists in conduct which the UK regards as a breach of Article 184, then the UK reserves its right to treat the agreement or part of it as terminated or suspended. That, it may be argued, is a right that exists under Article 60 of the Vienna Convention, which provides that a material breach of a bilateral treaty entitles the innocent party to terminate the treaty or treat it as suspended in whole or in part. Fourth, moving away from the law of contract, it might be said that the dealings between the EU and the UK over the last 4 years show very clearly that in zero-sum adversarial contractual negotiations, it is sometimes necessary to play with a hard ball. The speech of Lord Skidelsky displayed hard-headed pragmatism, which Mr. Keynes would surely have admired. The noble lord correctly observed that the most complex treaties involve constructive ambiguity and often a degree of what might be called covert bad faith. Those are the arguments. However, I don't suppose that I would or have persuaded the noble and learned lords, Lord Judge and Lord Brown of Eton under Haywood, with whose speeches I agree, and I have not come close even to persuading myself that Part 5 of the bill is defensible. Section 47 is an astonishing provision, and in that respect I listened with dismay to the Lord Chancellor's recent answers to questions put to him by the noble lord, Lord Panic. The government seems to be largely ignoring the detailed and exhaustive dispute resolution provisions in the agreement. See in particular Article 168, which makes it mandatory to use them. Nor has the government done much more than sketch faintly a case that the EU has acted in bad faith. If it wanted to rely on that case, it should set it out in detail. This is a very wobbly position from which to launch a case that the counterparty is acting in bad faith. And in the absence of such a case, there is no legal justification for threatening to tear up part of the agreement. Accordingly, I indeed regret Part 5 of the bill, and I would add that while this House must act in accordance with its perception of what the rule of law requires, it should also bear in mind Lord Skidelsky's admonition about the risk that we may weaken the hand of our negotiators.
Trenchard.
My Lords, I too would like to congratulate the noble Baroness Lady Hayman of Alloch and my noble friend Lord Sarfraz on their excellent maiden speeches. I congratulate my noble friend the Minister for introducing this bill under fire, so to speak. It builds upon the common frameworks approach to which the UK government and the devolved authorities are sensibly committed in order to preserve the status quo of intra-UK free trade. At the time of devolution to Scotland in 1997, and Wales in 1999, the United Kingdom Parliament was free only to devolve those parts of legislative competence which it, as a member state, still retained. High-level principles and frameworks in many areas had already been transferred by the member states to the Union. The Scottish and Welsh governments are now disingenuously arguing that responsibility for these high-level principles and frameworks should be transferred from Brussels to Edinburgh and Cardiff. I would ask my noble friend if he agrees with the arguments advanced by Nick Timothy in his article in today's Daily Telegraph, entitled "Devolution is a Mess that Fails the Public and Endangers the Union." As I am not a lawyer, I should not presume to enter into discussion of the finer legal points. However, I would ask my noble friend if he agrees that the EU and the UK had already broken international law when they signed the withdrawal agreement in October 2019, because it was a breach of the conditions of the Lisbon Treaty. According to the website of the European Union, Article 50 provides for the negotiation of a withdrawal agreement between the EU and the withdrawing state, defining in particular the latter's future relationship with the Union. The wording of the article itself refers to negotiation with the withdrawing state, taking account of the framework for its future relationship with the Union. However, my lords, that did not happen. I don't think for one moment that the UK's international reputation as a country which upholds the rule of law is placed at risk by this bill. I believe the conclusion of the Bingham Centre that this bill has serious implications for the rule of law is based on a narrow legal interpretation of the facts, ignoring the refusal of the EU to negotiate Article 50 and our withdrawal in accordance with the treaty provisions. Our acquiescence to the EU's demand for the two-stage negotiation was surely predictably going to lead to the present impasse. The world knows that the UK is still negotiating to leave the EU, and to suggest that our trade partners will be shocked or surprised by this turn of events is not true. Indeed, the Prime Minister has always been clear and consistent that we want a Canada-style trade agreement and that we will not agree to an internal border between Great Britain and Northern Ireland, dividing the United Kingdom customs territory into two. I have the highest regard for the noble Lord Judge, but I would ask him if he knows why the EU, and indeed the learned lawyers of the Bingham Centre, have remained silent and expressed no outrage at the finding of the German Constitutional Court that the ECJ exceeded its powers in its recent approval of the ECB's public sector purchasing programme. I would also ask him whether he thinks Lord Diplock was right in 1964 in defending the sovereign right of the Crown to change its policy. The Crown needs the flexibility to use its sovereign rights as much as ever today, which should help it to reach an 11th hour agreement with the EU in the interests of all our citizens.
Faulkner of Worcester.
It's been a fascinating debate with many important issues raised with skill and eloquence in all parts of the chamber, and enhanced by two excellent maiden speeches. I am a member of the EU Select Committee. The views I express in this debate are, of course, my own, though I should make clear that I agree with every conclusion contained in the report which we published last week on Part 5 of the Internal Market Bill. The report was agreed unanimously, and I pay tribute to Noble Earl Lord Kinnoul, who chaired our proceedings with skill, distinction, and humour. I also congratulate my noble friend Baroness Taylor of Bolton and her colleagues on the Constitution Committee for their report, which focuses on the devolution arrangements in the UK and on the rule of law. Other speakers have dealt devastatingly with those issues, the consequences for Britain's reputation abroad if we appear prepared to ignore the rule of law, the threats to the 1998 Belfast Good Friday Agreement, and the aggravation of the risk that Scotland will leave the United Kingdom. One concern that has not received much attention in this debate, except I think by the noble Baroness Lady Finlay of Llandaff, is the threat that it poses to public health. Public health is a devolved responsibility, and the individual nations of the UK have different populations and different priorities. Scotland, for example, pioneered minimum unit pricing for alcohol, and England led the way on prohibiting tobacco displays in shops. But the narrow drafting of this bill substantially undermines the ability of all parts of the UK to innovate and improve public health policy. And this is because of the very limited exceptions for public health. And what's more, the current exclusions, including the list of legitimate aims that override non-discrimination, can be removed or weakened by statutory regulation. In my view, my lords, this bill must be amended to allow the governments of the 4 UK nations to protect the health of their populations. Protecting human health must be included as a legitimate aim for overriding all market access rules, and I should be supporting amendments to this effect at committee stage. In my last few moments, I just want to make a couple of other points. First, to emphasise that this is not a rerun of earlier Brexit debates. If anyone was in any doubt about that, one only needed to listen to the powerful speech by the noble Lord Howard of Limp earlier today. And this is despite the intemperate attack by some Conservative MPs on the Most Reverend Primate and his fellow archbishops for daring to have a letter published in the Financial Times today. The second point concerns the role of your Lordship's House. The work of our committees, Constitution, European Union, and delegated powers, has been outstanding and has hugely informed today's debate. And if your Lordships believe that Part 5 should not be included in this bill, we should not be afraid to say so when we vote on Lord Judge's amendment tomorrow and when we consider the bill line by line in committee. If Part 5 survives, however, I hope your Lordships will look closely at new Clause 56, which provides for the House of Commons to have to approve a resolution before ministers can use the powers in Part 5. But it is silent about any role for your Lordship's House. This is something which I hope that we can address as well.
Great advocate of our great union of nations, I will never shy from expounding the benefits of belonging to and strengthening the deep ties and bonds across the United Kingdom. In an Ulster-Pacific context, we must continue to do all we can to work across all sectors to ensure that Northern Ireland plays its full part in the long-term future growth of these islands. And working together does not always mean agreeing on every issue. Focusing on the job of work at hand means working together, even if you disagree on certain issues. And as we look to the matter before us this evening, we should remember just how far Northern Ireland, in particularly, has come. We're especially minded of the lives lost and the families who have fewer seats at their table today. And as we acknowledge this and reflect the historical differences, we should let the relevant peace and prosperity over the past 2 decades be an important guide looking forward. Noble Lords, turning to the specifics before us, the bill allows the United Kingdom to prosper together, and importantly, the bill goes some way towards protecting businesses in Northern Ireland in all eventualities. The bill makes certain provisions for the regrettable flawed scenario in which parts of the withdrawal agreement would create potential barriers to internal trade. It is for that reason, above all else, that I support the bill before your Lordship's House today. My Lords, presently the EU has the ability to exert significant economic damage on the people of Northern Ireland if a deal is not achieved. In the other place, my party colleagues tabled amendments which sought to protect Northern Ireland further still. This bill is therefore a necessary insurance policy at this stage, though perhaps it does not yet go far enough. Concerns still exist regarding, for example, the bill excluding Northern Ireland from protection against EU interference in state aid. It would be wholly unfair if business owners in Northern Ireland were unable to avail of the same assistance available to similar companies elsewhere in Britain. My Lords, I support the general principles of this bill as it is aimed at preventing any fundamental undercutting of the Union, which would damage business, create uncertainty and dampen prosperity. There should be no question that further hurdles being introduced that would be a barrier between parts of the United Kingdom. Regardless of the eventful free trade deal with the EU, there is a need for a sensible, mature approach to Northern Ireland. Regrettably, in some respects, that approach has been missing to date. Key to all of this is Northern Ireland's economic reliance on the United Kingdom market, where total trade to the Great Britain is significantly greater than trade to the EU. My Lords, it is the duty of government and political representatives to put the interests of the people of the United Kingdom first. That means leaving the EU fully, securing our sovereignty, controlling our borders, and protecting the integrity of the United Kingdom internal market and our union. Equally, we need to work collaboratively to ensure the whole of the United Kingdom benefits equally from the various trade deals, economic opportunities, and further prosperity that will come by being a free and independent nation state. We have to remain focused on ensuring that our exit from the European Union is a launchpad for a stronger and more determined and more united Britain.
Baroness McIntosh of Pickering.
My Lords, I'm delighted to have the opportunity to participate in this debate, and may I warmly congratulate Baroness Hayman of Ulloch and Lord Strathfires on their excellent maiden speeches and bid them a very warm welcome to the House. My Lords, my noble friend Lord Callaghan set out the reasons in his view why the bill is necessary, in particular to extend market access of goods, services, professional qualifications and others, and to create a coherent internal market now that we've left the European Union. My Lords, it was always going to be the case that there will be questions, and complicated and complex questions, which arise following from Brexit, such as what does happen to the powers which are returned to the United Kingdom, and what those powers, how those powers will be exercised by the Parliament at Westminster and by that of the devolved administrations. But I pay tribute to the work of both the government and the devolved administrations through the common frameworks. And this has been an example of excellent cooperation and achievement in reducing to just a few, I think it's 16 or 18 now, pieces that will require further legislation. Now, there's one area that hasn't been referred to a great deal during this debate, and that is how agriculture will be dealt with following the adoption of this bill in its present form. Scotland had a separate agricultural policy, which is much the envy of North Yorkshire and Cumbria, Northumberland and other farmers in the border regions. And it begs the question as to how those policies will be administered now through the common frameworks. And I would follow what a number of other noble lords have said earlier, particularly Baroness Andrews and Baroness Finlay of Clondarf, and the noble Lord Hope, the noble and learned Lord Hope of Craighead, in asking, I'd like to put up a specific question, if I may, to my noble friend, the Minister, in summing up this debate. What now is the situation, and where does the bill leave the common frameworks? Is it intended that work will continue to proceed on the achievements that have been made to date in the common frameworks? I feel that I have really no quarrel with what the noble and learned Lord Judge set out in moving his amendment, nor my noble friend Lord Cormack. And I found myself in absolute agreement with my noble friends Lord Howard and Lord Lamont. And I think what I regret most about the bill in its present form, not just Part 5 to which many have referred, but Parts 1 and 4 as well, but I suppose particularly Part 5 of the bill, is the fact that the government is increasingly standing alone, internationally and domestically. The government is claiming that they alone are right and everybody else is wrong. There are 27 member states in the European Union who have reached and maintain a common position in their negotiating position, and it is a matter of note, and it is to be welcome if there is a change in the negotiating position announced by the EU today. But also I think this bill shows in its present form how we risk forming barriers and disagreements with the devolved assemblies, who will be hoping to work as closely with the Parliament at Westminster as possible. And as my noble friend Lord Vasey has said, there is time and hopefully scope to retrieve this situation. And I wish the passage of this bill well, but in a heavily amended form before its adoption.
I call Baroness Bowles of Berkhamsted. Hear you.
My lords, I too welcome our maiden speakers. Like many noble lords, I find the Constitutional, EU and Delegated Powers Committee's conclusions chime with my own concerns about this bill. I concur with the many magnificent speeches today, led by the noble and learned Lord Judge, about the rule of law. My humble offering is that the government has made its bed, must lie in it, and use internationally respected ways to work with it to best advantage. Regrettably, the theme throughout this bill seems not about working with things, but a rush to legislate around primitive principles, lacking the refinements of consultation, consent, or even continuity concerning devolution. And really, the question is why? It seems designed to upset. Is it part of the revolution by disruption plan, or was it thought boxes needed ticking right now? The UK internal market must be taken seriously, but why isn't there time to stand still and work intergovernmentally, then legislate where needed, without recourse to Henry VIII clauses to make up for not yet really knowing what to do? The powers in this bill are a land grab, taking the soul, if not the territory, of the devolved nations, as well as sidelining Parliament, allowing anything to be changed by regulation. I want to make points about the CMA and whether it is the right body and construction to be the embryonic unelected guardian of the single market. Paragraph 35 of the Constitution Committee's report says it all. Why choose the CMA? Why not establish a properly independent body representing all four nations? Further, the input tenets in the EU lookalike texts of mutual recognition and non-discrimination have neither been agreed by all nations via the frameworks or otherwise, nor maintain the degree of flexibility and subsidiarity already existing within the UK. On the CMA itself, it is sponsored by a government ministry, and all the appointments are still governed by the Secretary of State, despite, for the OIM side, after consulting the devolved authorities. But why? And this is a serious question. Why the hermetically sealed and secretive CMA inquiry panel process? I understand it for matters of competition, where commercially confidential information is considered and policy is well developed. but for the internal market, it will be a matter of public interest and constitutional development that surely should not be secretive. And it won't be simply technical analysis. That leads to overbearing harmonisation. And how often have we fought the EU over that? Analysing the EU-UK internal market must encompass subsidiarity and degree, at least once that has been properly agreed. Does the CMA have that expertise? And surely the evidence, procedures and reasoning need to be seen and, if I may say so, robust enough to withstand public scrutiny. The Minister has already twice referenced the support of what are, in the end, relatively few of the total of UK businesses. And even within the unsuitable structure, unsuitably appointed, a minimum task group of 3 is too small and exclusive. Why should it be potentially smaller than the minimum number of judges sitting in the Supreme Court? Are panellists so superior? For such a constitutionally important matter, this all needs a rework.
Can I remind everybody that it is a 4-minute advisory time, and we are getting quite late and there's still a lot of speakers to come.
I call Lord Anderson of Ipswich.
My Lords, shortly after the Singing Revolution restored democracy to Estonia, that country's legal profession welcomed a British delegation in Tallinn's largest law firm. At the centre of its new partners' table was a brass disc proudly engraved with the words Pacta sunt servanda. As a newly independent nation, our hosts knew the importance of ensuring that promises are honoured, whether in commercial agreements or international treaties. The precise meaning of such promises is often disputed. But Part 5 of this bill is no inadvertent or merely arguable breach of some vague or trivial international undertaking. Its whole purpose is to signal to our negotiating partners a kind of anarchic disdain for this government's recent, specific and binding commitments on export declarations and state aid, and disdain for the very principle, fundamental to our status in the world, that treaties must be observed. With respect to the noble Lord Lilly, the Cardi case in which I appeared against the EU is no sort of precedent for a similar attitude on the part of the EU or its court. In that very case, the Court of Justice affirmed its long-standing insistence that, I quote, the European community must respect international law in the exercise of its powers. Both the Secretary of State for Northern Ireland and a unanimous Constitution Committee have expressed the view that the bill itself is in breach of the withdrawal agreement, or will be by the time it is entered into force. I agree, though perhaps it matters little, since whether itself unlawful or not, the whole point of Part 5 is on any view to enable unlawfulness. Then there are the judges, Francis Bacon's lions under the throne. Here too, the bill is deeply troubling, for it not only authorises the government to act unlawfully, but deems such unlawful actions to be lawful. The lions are still on show, but they are comprehensively defanged by successive subclauses of Clause 47. Deprived of their usual power to strike down unlawful regulations, they might as well be mounted on the wall. Imagine, if we can, that the EU were to renege on the guarantees it gave to British citizens in the withdrawal agreement. There would be justified accusations of perfidy and duplicity. Yet it is, I'm afraid, precisely such duplicity that we are asked to facilitate today. Can the strategic damage to our reputation as a trustworthy international partner be mitigated by any tactical advantage in the negotiations? Rather the reverse, I suspect, as Lord Jay has suggested with all his diplomatic experience. Showing contempt for our existing agreement with the EU will hardly encourage them to sign a new one. More likely, it will enhance both the unity of the 27, at just the time when we should be testing it, and their determination not to give us the benefit of any doubt. This bill seeks to make Parliament complicit in a scheme that openly flouts two foundational principles: that agreements once made should be kept, and that government is not above the law. My lords, how could we possibly go along with that? This is not a house of opposition, as the noble Lord Cavendish has rightly reminded us, but it is a guardian of constitutional principle, and as such needs to send a strong and clear signal. For my part, I look forward to supporting the motion of the noble and learned Lord Judge, to voting at the earliest feasible opportunity, not for some messy compromise, but for the simple removal of clauses 44, 45 and 47. And like my noble friends Lord Butler and Lord Lisvane, to strapping in, if necessary, for a bumpy ride.
I call Lord Bowness.
My lords, it's a little daunting to follow the noble and the noble Lord Anderson of Ipswich and his learned speech and the excellent maiden speeches that we've had this evening. However, Brexit is a phantom which still haunts and divides us. And the major issues in this bill, whether the stated intention to flout the freely entered into withdrawal agreement or the potential disputes around the devolution settlements as affected by this bill, are a manifestation of that divide. I put it to your lordships, with some regret, that the fault for this rests fairly and squarely on the Prime Minister and his cohorts of hardline Brexiteers. He said that the divide should be healed, but nothing's been done to bring those of a different point of view close. Most of those who voted Remain are ready to accept the realities of leaving the European Union, but wanted a closer collaborative settlement. There's been no attempt to accommodate those views. We rejected the single market, the customs union, the Norway option, membership of agencies such as the European Aviation Safety Agency, and all the matters which benefit citizens: mutual recognition of driver's licenses, blue badges, the European health insurance card, which are currently in limbo. But my lords, fear not, we do have a blue passport. The Prime Minister told us he'd achieved an oven-ready deal. He crowed about it and fought an election on its basis. The electorate were, it seems, sold a gold brick, because as it turns out, much of the political declaration which accompanied the oven-ready agreement has been abandoned, if not rejected. No more talk of the ambitious, broad, deep and flexible partnership and more, or the level playing field. And now, the famous agreement, signed by the Prime Minister and approved by this Parliament, is now considered defective. And this bill seeks power to flout international law and amend this agreement to make it acceptable to the leader of the Brexit Legion. The enormity of what the government want to do has been more than adequately expressed by other noble lords of both Remainer and Brexit tendencies. To produce a measure considered constitutionally and legally appalling certainly unites both sides, but not in a way one would have hoped. It's convenient to blame the European Union for the current situation, but whatever difficulties we face in the negotiations, we're the ones who decided to leave. We have a very integrated market with the European Union. We're 22 miles from mainland Europe, and we've been part of the system for more than 40 years. It's just unrealistic to expect the European Union will treat us just as another third country. And now we have the spectacle of the government almost rejoicing at the prospect of no deal. We should be like Australia, that has such good arrangements that it's seeking a free trade agreement with the European Union. We want a Canada free trade agreement, but not just a Canada deal. We want Canada Plus, because we believe that we are in some way entitled. We refused an extension of the transition, pointless bravado. Now we don't want to continue talking, even when the EU negotiators are ready to come here. More bravado. Small wonder that the EU has reacted to this bill with a determination to stand by what's been freely agreed and signed by this Prime Minister. We should drop the provisions in this bill which seek to undermine and change the withdrawal agreement.
I will vote for the amendment of the noble and learned Lord Judge, and vote for any amendments which are presented during the passage of the bill which seek to amend the offending provisions. And in considering how far we should press our objections, we need to revisit the 2005 Prevention of Terrorism Act, when Conservatives and others maintained our objections for 5 rounds of ping pong. We must not acquiesce in recreating our reputation as perfidious Albion.
I call Baroness Clark of Kilwinning.
I'm pleased to join with others in welcoming Baroness Hayman of Ulloch, who I've known for a number of years, and also Lord Sarfraz, who I met this evening on their maiden speeches, and I hope they enjoy their time in this place. I'm going to focus this evening on the devolution aspect of this legislation. We've had a number of speeches, a number of powerful speeches, focusing on various technical aspects of the devolution aspects of this legislation, but I'm not going to focus on specific provisions as to whether it will still be possible for the devolved institutions to regulate on issues such as single-use plastic, or indeed on the state aid provisions. But I'm going to focus on the politics of the situation, and I do that as a former Labour MP in Scotland and someone who was heavily involved in the independence issue in the lead up to the 2014 referendum. And the constitutional debate in Scotland has completely dominated Scottish politics, both during the lead up to that referendum, which was a 2.5-year-long referendum, and increasingly as the referendum went on, the issue completely dominated Scotland, and indeed the issue has not gone away, and it's still centre stage in Scottish politics. As the House is aware, the Scottish Parliament voted 90 to 28 against giving legislative consent to this bill. And it was suggested earlier on that that was the SNP. And I want to make it absolutely clear to this House that the only members of the Scottish Parliament that voted in favour of giving legislative consent were the Conservative members of the Scottish Parliament, and every other political party and every other MSP voted against giving legislative consent. The government will no doubt say again, as they did at the beginning of this debate when they sum up, that there are further powers being devolved as part of the changes that are taking place, and that some of the powers that are coming back from Europe will be devolved to the devolved institutionals. But I would respectfully say that that's not really the point. The issue is that certain powers are being eroded without consent, and certain powers of the devolved institutions are being eroded at a time when the direction of travel should be transferring powers to those institutions. So I was really interested in listening to the speech of Lord Hope of Craighead, who was considering whether it was a power grab or not. It's absolutely clear that in Scotland in particular, and I will focus on Scotland because that's, if you like, my background, there is a genuine view that this legislation undermines the devolution settlement. And of course the backdrop is that since the 1950s, a significant divergence has taken place in the political views and voting of people in Scotland to those south of the border. And to put it simply, Scotland has tended to vote for social democratic type politics, whilst nationally we've actually had few Labour governments elected in that period. And those political differences and the differences in voting habits have had a major impact in Scotland over many decades. And it has thrust the constitutional debate into the centre stage of Scottish politics, because people in Scotland, and most people in Scotland, simply believe that decisions in Scotland that affect Scottish people should be made in Scotland, and they don't think it's fair if they are getting policies that they feel they haven't voted for. And it's often said that it was the Margaret Thatcher government that delivered devolution. And I have to say to this House that the behaviour of this government is again having a big impact on the constitutional debate. And I hope very much that the government will think again.
I call Baroness de Souza. Baroness de Souza, we can't hear you.
My Lords, this bill is littered with Henry VIII's powers, the government's justification being that it allows for speed in decision-making and safeguarding trade within the UK, that notwithstanding that Parliament has already shown itself to be adept at speed in dealing with the current COVID crisis. The tendency, my Lords, on the part of a government to extend its powers is a slippery slope, and power, once conceded, cannot easily be won back. It is therefore, to my mind, of great significance that relevant committees, the House of Lords European Union Committee, the House of Lords Delegated Powers and Regulatory Reform Committee, the Constitution Committee, have questioned and even strongly advised the deletion of such clauses that empower the government through secondary legislation. The Internal Market Bill goes beyond what is actually needed to ensure economic and regulatory coherence between the 4 UK nations, and it undermines the purpose of the Common Frameworks Programme as well as the principles of mutual recognition. The bill challenges the Seoul Convention as evidenced by the motion agreed in the Northern Ireland Assembly on the 22nd of September and the Scottish and Welsh governments' stated intentions to withhold consent for the bill. The powers the government affords itself are breathtakingly wide, including the non-recognition or enforcement of rights, powers, obligations, restrictions, remedies contained in the Withdrawal Act. The bill allows ministers to interpret, modify, or disapply any of the provisions set out in international and domestic law, defined as any provisions of the European Communities Act, any other EU or retained EU law, and any other legislation, convention, or rule of international domestic law whatsoever, including any order, judgment, or decision of the European Court or any other court or tribunal. The concession to parliamentary approval for the implementation of derogation clauses allowed the bill to pass in the other place. But, my Lords, the government has shown its willingness to ride roughshod over an international treaty. Can it not therefore also do the same with this commitment, citing, for example, bad faith on the part of the EU in order to gain parliamentary consent? Legislation, once on the statute books, has a habit of being resuscitated for a purpose other than that originally intended. As such, this so-called safeguard amendment could well become hostage to fortune. Meanwhile, my Lords, statutory instruments are increasingly bolstering skeleton bills, and both recourse to judicial review and mechanisms to counteract secondary legislation are severely limited. My Lords, a precedent is being set that challenges the rule of law. Clauses 44, 45, and 47 of this bill must not reach the statute book. My Lords, I too will be supporting the motion in the name of the noble and learned Lord Judge.
Call Baroness Ritchie of Downpatrick.
My Lords, it is a pleasure to follow Baroness de Souza, as I can concur with a lot of her views expressed here tonight. I would like to also offer my congratulations and best wishes to Baroness Hayman and Lord Sarfraz in making their maiden speeches, and I look forward to working with them. In this bill, I would like to concentrate on part 5, because I believe that that part is totally unnecessary and it is very damaging to this bill. And in that respect, I make reference to the bits that deal with trade between Britain and Northern Ireland and the Northern Ireland Protocol. When the Conservative Party jettisoned Theresa May's proposals and decided that getting Brexit done meant leaving the EU customs union, then a formal border between the EU and the UK became inevitable. As regards Ireland, this interface could only be located either along the north-south border on the island of Ireland or at UK ports, effectively a border in the Irish Sea. The government, in signing the withdrawal agreement and the Northern Ireland Protocol, despite much rhetoric to the contrary, chose the Irish Sea, a point that has already been made in this debate by the noble Lord Clark of Nottingham. In the process, the government managed to set the nationalist and unionist communities against each other and undermine relations with Dublin by leaving the possibility of a hard border on the island of Ireland on the table for so long, the very issue that the Northern Ireland Protocol sought to provide for and ensure did not happen. Let me be clear at this point that while all Irish nationalists, and I'm one myself, as well as the EU and others opposed customs infrastructure on the north-south border and were concerned about the damage it would do to our historic settlement, no nationalists, and I want to emphasise that, my lords, want a hard border in the Irish Sea. And I share, my lords, many of the concerns of my unionist colleagues in Northern Ireland and want to see minimal friction on goods travelling from Britain to Northern Ireland. I also want to see unfettered access to the GP market for Northern Ireland businesses, and this should not be a cause of division. No one on the island of Ireland, north or south, wants heavy bureaucracy around trade with Great Britain. But, my lords, I believe that the way to maximise the possibility of this highly desirable outcome is to sign a zero-tariff comprehensive trade agreement with the EU, something which is achievable. And I would like the noble Lord, the Minister, to comment on that in his wind-up. But instead today, we have the Internal Market Bill, which under clauses 44, 45 and 47 proposes to empower UK ministers to breach their legal obligations under the protocol, and which reopens dangerously the whole political argument, something, my lords, which I am totally opposed to. And tomorrow I will be voting for the noble and learned Lord Judge's regret motion. Thank you, my lords.
I call Baroness Altman.
My lords, I join in congratulating the noble Lady Baroness Hayman of Ulloch and my noble friend Lord Sarfraz on their maiden speeches and welcome them warmly to this House. Regarding this bill before us, I would just like to say that I wholeheartedly support the regret motion in the name of the noble and learned Lord Judge for all the reasons he so admirably and eloquently laid out, and the regret motion of my noble friend Lord Cormac. I share the deep regrets expressed by my noble friend Lord Bridges and agree with my noble friend Lord Clark in all his remarks. The damning reports of 3 House of Lords select committees and the exceptionally clear explanation presented to the House by my noble friend Lord Barwell are clear indications of why I believe it is our duty to ensure this bill, including Part 5 in particular, does not pass through this House. I cannot in all good conscience support the measures in this bill, particularly, as I say, Part 5, but much else too, and I'm afraid that I will have to vote against the government's intentions to break international law on every occasion. I congratulate the Most Reverend Primate, the Archbishop of Canterbury, on his brave intervention and join with other noble lords' warnings about the potential of this bill as presented to us to pave the way to authoritarian rule. My lords, principle must come before party, and this is the moment of truth when we must face up to the consequences of seeking to have the same rules within the 4 countries of the UK, while pretending that these rules can somehow differ from those of the EU and particularly Ireland, without erecting borders either in the Irish Sea or on the island of Ireland. Should those mythical alternative arrangements that we had been promised a year or 2 ago would materialize to do away with the need for such borders, that would have been fine. But in the absence of those, I'm afraid, my lords, we must ensure that this bill does not pass through as presented to us tonight.
I call Lord Shipley. Lord Shipley, we can't hear you.
This bill, my lords, will represent a further stage in the eventual breakup of the United Kingdom should it proceed unamended. It centralises power away from the devolved administrations, gives excessive powers to ministers, and it undermines the rule of law. In the minister's opening address in justifying this bill, he said that the government wanted a coherent internal market within the UK with control of subsidies and fair competition. This approach sits oddly with his government's negotiating position with the EU, where we are leaving a coherent internal market, seemingly to do the opposite in terms of subsidies and fair competition, and in the process to override the devolution settlement. The minister referred to a huge transfer of powers from the EU to the devolved nations following Brexit. He neglected to say that the devolved nations under this bill will lose some crucial powers they currently have. It is little surprise that the devolved nations have reacted as they have. My lords, in the face of the coronavirus pandemic, it has been beneficial to have the devolved administrations devising and piloting different approaches. We need to encourage new thinking that tests potential solutions to problems, not to stifle them on the basis that Whitehall knows best. As an example, the Welsh Government is proposing a ban on the sale of 9 single-use plastic products, when the UK Government is proposing to ban only 3. This bill would mean that in Wales, the 6 other products could still be sold because they've been made in England, Scotland, or Northern Ireland. So we would have lower environmental standards, levelling down, not levelling up. My lords, this bill should have derogations in it for matters of environmental protection, which limit the primacy of mutual recognition. Wales led the way in 2011 in introducing a charge on plastic carrier bags. It worked so well, the other parts of the UK followed, and the outcome today is a higher standard of environmental protection for us all. Public health is another area where devolved powers really matter, because they can help effect positive changes more quickly than centralised structures can. We have seen devolved administrations give the rest of the UK a sense of direction with policies which improve public health. As the Noble Lord Falconer of Worcester said, examples include Scotland's minimum unit pricing for alcohol. There are others. But as it stands, this bill could lead to poorer public health outcomes in one country because of the right of market access from others. And there is, my lords, a solution. It is that the government sets out a general public health exception to the mutual recognition principle, along with the necessary derogations on matters of environmental protection. However, as the Noble Baroness Lady Finlay of Llandaff pointed out, these are matters first for common frameworks. Market access principles should only be considered when discussions on common frameworks have failed. Even then, the power to introduce derogations would remain essential.
I now call Lord Vaux of Harrowden.
My Lords, I will leave detailed discussion of Part 5 to other colleagues, but would just say that I find the idea of a UK government knowingly and deliberately breaking the law to wriggle out of a deal signed less than a year ago repugnant. It's not something this House should accept. But in the justifiable outrage about Part 5, there is a risk that the other flaws of this bill get lost. As the Constitution Committee has explained so well, it has significant implications for the UK's devolved structure. My Lords, there are 3 elements that are necessary for the efficient operation of an internal market. First, rules for market access. Second, a framework for agreeing minimum standards. And third, a mechanism for resolving disputes. This bill only provides the first element, the market access rules. If the EU single market had worked only with market access rules, it would have allowed, say, Romania
to reduce its standards so that its businesses could produce or import substandard goods that could be sold freely here. We would not have accepted that as part of the EU. So why would we think it appropriate for our own internal market? I don't often say this, but the Scottish Government are right. This bill undermines their devolved competencies. But this does work both ways, and the UK government should be just as worried about, say, Scotland reducing its standards and selling substandard goods into the rest of the UK. As the Welsh government have pointed out, it incentivises a race to the bottom. To avoid this, a system for agreeing minimum common standards is essential. Now, we've heard that good progress has been made towards agreeing common frameworks, but the bill completely ignores them. Indeed, it would undermine them. I would go as far as to say that if the bill is not amended to take account of the common frameworks, including the necessary flexibility described by my noble and learned friend, Lord Hope of Craighead, the bill will be more damaging to the UK's internal market than no bill. Like the Constitution Committee, I do question whether this bill is really necessary. Perhaps the noble Lord the Minister could explain why the common frameworks have been ignored and how a race to the bottom will be avoided. The third element required for an internal market to work is a mechanism for dispute resolution. To be acceptable to all parties, any mechanism needs a high degree of independence. All parties should be represented, and it must have the ability to resolve disputes. The bill creates the Office of the Internal Market, but that is neither independent nor representative. And indeed, it can't actually resolve a dispute. All it can do is issue advice and reports. Does the noble Lord the Minister not see a contradiction in being ready to die in a ditch to prevent the European Court being the arbiter of a trade deal, but not allowing an independent arbiter in our own internal market? Well, there is general agreement throughout the UK, and I agree with it, of the need for an efficient internal market. But this bill does not achieve that. We must adopt a more consensual approach between the UK's constituent parts. After all, there is one overriding requirement for an internal market. Parties must want to be part of it. This government, in particular, must know that the heavy-handed imposition of rules from the centre can lead to countries wanting to take back control. If the government wants to keep this kingdom of ours united, it would do well to remember that.
Call Lord Bourne of Aberystwyth.
My lords, it's an immense pleasure to follow the noble Lord, Lord Vaux, who made some very, very powerful points. My lords, could I too pay tribute to the maiden speeches of the Lady Hayman, making some very valuable points on the environment, and to my noble friend, Lord Sarfraz, who spoke powerfully about entrepreneurship. My lords, could I pay tribute to the Constitution Committee's report, which I found very compelling. This bill, for me, presents two very real concerns. The first of these relates to the relationship with the devolved administrations. Over the years, we have made progress on handling devolved relationships. Naturally, it was a little bit raw in the early years, but it's improved noticeably. There is a carefully constructed balancing of interests in the devolved world, and we have seen that with the common frameworks. It exemplified that. I had the opportunity, indeed the privilege, to see that at first hand, discussion, consultation, and often agreement. This bill throws all that over. That is regrettable. It is heavy-handed, pulling of rank, and that is unwise. Acting like Goliath with the flexing of muscles is not an approach with much to commend it, particularly given the outcome of that particular engagement. What is needed, my lords, is consultation and real engagement if we are going to keep our union united. My second real concern, of course, relates to Part 5. Could I say, my lords, how much I regret the resignation of my noble friend, Lord Keane of Ely. I understand the reasons for it, but he was a lawyer of considerable ability and integrity. And he, of course, went on a point of principle, and we should not lose sight of that. The breaking of international law quite openly, and even when challenged, confirming the breach, is not a pretty sight. It represents a move against a treaty and a protocol that were only recently concluded and indeed hailed as a triumph. This bill goes against a fundamental principle of our law, our national character, our constitution, and our history, and indeed our deeply held principles as a country, taken on with mother's milk, the upholding of the law. My lords, there can be no excuse for it. It is no excuse that we may not use it. It is no excuse that it needs a vote in Parliament. It is no excuse that other countries may breach international law. It is quite frankly inexcusable, and our ministers must in their hearts know that. My lords, openly breaking international law, that is not the British way. From Magna Carta onwards, this country has stood for the rule of law, and this bill should alarm us all greatly. It is not in our national interest for this bill to pass, as we see the tearing up of this deeply held principle, sending a shudder through the reeds at Runnymede. My lords, I will certainly be supporting the noble and learned Lord Judge, and seeking to improve this legislation, which is deeply flawed.
Lord Berkeley and Baroness Bennett of Manor Castle have both withdrawn, so I now call Lord Arbuthnot of Edram.
My lords, it's a pleasure to follow my noble friend Lord Bourne, with whose words I agree entirely. We have 4 minutes. I shall try to take no more than 1. My lords, the government invites us in this bill to pass a law to break a law. That is not only wrong, it is patently absurd. If we believe in law, we shouldn't break it. If we don't believe in law, then we shouldn't be passing it. If the government can break the law, then why should the people obey it? If the UK can break the law, why should other countries obey the law? So the damage of this bill will last for the long term. In signing the protocol, we gave our word. Nothing has changed since then, and we should keep our word. I shall be supporting the noble and learned Lord Judge's amendment, because this bill brings shame on this country.
I now call Lord Brooke of Alverthorpe.
Lords, I'd like to congratulate my noble friend Baroness Hayman of Alec, and also Lord Salfraz on their great maiden speeches, and look forward to hearing them in the future. But Lords, this has been a quite extraordinary long second reading, and an exceptional one in many respects. I think it's worth reflecting, however, that some of the topics on which there have been the strongest feelings and arguments, for example, on Part 5 of the bill, in which I fully support the opposition to it there, it is not actually the topic which will be the foremost in the minds of the public at the moment. That, of course, is COVID-19 and their health and their well-being. So, like Baroness Finlay of Llandaff and Lord Faulkner of Worcester have spoken, and Lord Shipley just a few moments ago, I want to focus on a fairly, what might seem to be a narrow area, on protecting the UK's public health, insofar as this bill will do so. Will the bill improve it or not after we leave the EU internal market? Does it provide the framework which Lord Shipley referred to, that will raise standards, or indeed may they possibly be at risk, the existing ones? The devolved administration's views are very clear indeed. They fear the balance between market interests and the public health policies they've been pursuing will be at risk, that the bill could undermine and diminish their ability to enact essential public health legislation for their countries. They pointed out to me, for example, on alcohol labelling. Currently, alcohol labels lack basic information, such as how many calories are in the product, or the Chief Medical Officer's low-risk drinking guidelines. They're not there. In recent years, both the Scottish and the Welsh government have worked hard at moving forward for significant changes there. The English lead is well behind. We're looking to consult, but we're well behind on most of these issues. Now, they say the drafting of the mutual recognition principle within the bill which, unlike the current rules, allows no general exemption for protecting health, means that governments within the UK may set higher labelling standards for products originating in their own nations, but these standards will not apply to the products sold within their borders that come from other parts of the UK or from overseas via another UK nation. Instead, these products must only meet the standard required in the part of the UK in which they originated. This is just one of the many key public health policies that will be hampered by the bill. Though government has included a public health exemption for non-discrimination, there is no corresponding exemption for the mutual recognition principle. Others have raised this point, and I again say, would the Minister please explain why it is necessary to water down the public health protections that have existed in our markets up to this point?
I now call Lord Kerr of Kinlochard.
I should say it's a pleasure to take part in this debate with so many distinguished speakers, such excellent maiden speeches, and a debate informed by 3 such good reports. But it isn't a pleasure because I feel like Lord Arbuthnot. We shouldn't be here. We shouldn't be debating this bill. It's a bad bill. Like the Constitution Committee, I can't see the need for it. And I can't support the reopening of the devolution settlement, putting new limits on devolved competence or binning the common frameworks. But for me, the central issue is stark, simple, and shockingly simple. A treaty is a contract binding on the states party to it. Exactly 12 months ago today, Mr. Johnson concluded a treaty. Some of us here said that we found its Irish protocol offensive in principle and likely to prove problematical in practice. But Mr. Johnson said we were wrong, it was fine, indeed it was fantastic, his triumph. And he won his majority and he used it to ensure that this Parliament ratified his treaty. And so it became binding on the country and on all of us, whatever reservations we may have had about it. Binding in law, binding in honour. In honour, that's what this is all about. That's what makes it so shocking that Mr. Johnson now asks us to empower him to override his treaty, not to seek to change it, just to choose to break it, and require the courts to ignore it whenever he decides they should. No wonder the head of the government legal service, Sir Jonathan Jones, resigned, and I pay tribute to him for doing so. I can't see how this House could, in honour, collude in legislating to break a treaty. This isn't about frontier checks. It isn't about Brexit. It's about honour and reputation. And for what purpose are we going to throw all that away? The noble Lord Clark of Nottingham pointed out that Mr. Johnson hasn't told us what arrangements he does envisage for the border between the EU single market and our single market. If he overrides the protocol, what's going to replace it? What's going to sustain the Good Friday Agreement? And why, if Mr. Johnson believes he's grounds for complaint against the EU, doesn't he use the dispute resolution procedures in the treaty he signed? I refer the House to the 9 questions in the letter that the noble Lord Kinnoul, as chairman of the EU committee, sent to Mr. Gove a month ago. They're at the back of the committee's report. They remain unanswered. I think they're unanswerable. It's hard to avoid the conclusion that what we have here is a simple case of buyer's remorse. Mr. Johnson now dislikes what his treaty said. And just as he chose in the current negotiation to tear up the political declaration he agreed on this day last year, so he proposes to tear out bits of the treaty. What price honour? My lords, he gave his word. Moreover, worse, he gave our word when at his urging, we ratified his treaty. So ours is the responsibility for saving the national reputation, and in honour we must. I will vote for the motion in the name of the noble Lord and learned Lord Judge, and I trust that we will then move on to remove Part 5, and if necessary, we will insist with Lord Butler and persevere. Perseverance, dear my lords, keeps honour bright.
I now call Lord Wallace of Saltaire.
My Lord, some of the language of this bill brings back distant memories from over 35 years ago. Proponents of free trade and open markets, including Margaret Thatcher as Prime Minister, then argued that the absence of a common framework for regulation across the European community disadvantaged UK exports to our neighbours. It also meant that British standards increasingly copied US standards. American regulators exercised what lawyers termed extraterritorial jurisdiction over foreign markets like the UK. For Mrs. Thatcher, a European single market would mean that British ministers could take an active part in negotiating international standards rather than swallowing American ones. A generation later, in a far more integrated global economy, it's become clear that standards and regulations will emerge from one of three major global players: the United States, China, or the European Union. But our government is pursuing an antique and absolutist version of Westminster sovereignty, breaking free of the EU. In practice, that means that we will end up following either American or European standards on food safety, financial regulation, and the internet, without much influence on either, losing control, not taking back control. The doctrine of sovereignty that underlies this bill was set out by Albert Venn Dicey in his 1885 Introduction to the Study of the Law of the Constitution. Dicey insisted that Westminster sovereignty was supreme and indivisible, internally and externally. Sir William Cash frequently quotes him. Lord Keane cited Dicey in this House when challenged about the subject. But Dicey was writing at the high point of British imperialism when English politicians could assume that Britain shaped international law and other countries had to follow. The empire has gone, but the mixture of imperial nostalgia and English nationalism that motivates hard right conservatives resists negotiating international law with other states. That's disastrous for British reputation, for London as a global centre for litigation and legal expertise, and for our ability to negotiate future trade deals with others, as Lord Carlisle and others have noted. Dicey's approach to domestic sovereignty was shaped by his bitter opposition to Irish Home Rule. He refused to accept that powers could be shared with the Parliament in Dublin. Conservative Unionists followed Dicey, insisting that all authority in the United Kingdom rests in Westminster. That absolutist view, through the opposition to successive proposals for Home Rule, led to Ireland breaking away from the United Kingdom. This is a constitutional bill. It goes to the heart of the rule of law within the UK, as well as in relations with other states. And it threatens the further disintegration of our state, with Scotland leaving and Ulster moving towards reunification, to leave England diminished and internally divided. We're now watching right-wing Republicans bend America's written constitution until it is close to breaking. We've even seen the embittered partisanship of American politics spilling over into this debate in Baroness Noakes's attack on the bishops for addressing the moral dimensions of the bill. We should not allow our increasingly authoritarian government to bend the conventions of our own unwritten constitution any further.
Baroness Mayer. My Lords, of course the government's bill has my support. It is sheer common sense. If the EU continue their obstinacy of a fishery and a level playing field, we are unlikely to have in place by the end of the year an agreement on the future relationship. It would be the height of folly not to have an insurance policy against this possibility. This is what this bill is providing, no more, no less. Without such an insurance, we could find ourselves in a situation where the EU is able to tell us what we can and cannot do throughout the United Kingdom by way of state aids. That would be to continue to submit to the authority of the European Union and the European Court of Justice. How on earth is that compatible with the decision taken by the British people in 2016, which politicians across the spectrum committed to honour? It would also be in breach of the Act of the Union 1800 and the Good Friday Agreement. Our American friends must understand that any threat to the agreement comes not from London, but from Brussels. The EU has for 4 years sought to exploit the Good Friday Agreement to its negotiating advantage. To change the terms of the trade between Great Britain and Northern Ireland without the explicit consent of the people of Northern Ireland is to violate the Good Friday Agreement. Those in Washington and in Brussels who profess concern for peace in Northern Ireland would do well also to consider that, without a UK-EU agreement, the only authority that could conceivably want a hard border between the North and the South is the European Commission, to protect what Brussels calls the integrity of the single market. The UK has no intention of erecting a hard border. My lords, the withdrawal agreement and its Northern Ireland protocol do not stand in isolation. They are organically linked to the intended agreement of the future relation through Article 184 of the withdrawal agreement and the political declaration. As was confirmed by the noble learned Lord Pannick in his letter to the Times in March 15 last year, without such an agreement, we would be entitled under Article 62 of the Vienna Convention to terminate the withdrawal agreement. Article 184 obliges the signatory to negotiate the future relationship in good faith. The EU has failed to show good faith, and thus is itself in breach of the withdrawal agreement. There is no other way to describe a negotiation position which, to take one example, insists on the historic pattern of fishing quotas, the common fishery policy, by any other name. There are two falsehoods here: that the UK is in breach of international law, and that the British government would violate the Good Friday Agreement. The reality is precisely the opposite. The Internal Market Bill seeks to remedy a situation where, thanks to the EU's bad faith and intransigence, the Good Friday Agreement and the British Constitution are imperilled. Can the Minister reassure the House that the government is making an intensive effort to explain to our friends and allies around the world, including, especially in the United States, the true state of affairs?
I now call Baroness Greengross.
My Lords, like many of the previous speakers, I'm genuinely concerned about what is being proposed in this bill. My main concern, the one I will address, is that the bill could well undermine areas of medical research and access to new medicines, that the bill might also do considerable harm to the economic prosperity of the country, and the bill would breach international law, something I never expected to see a UK government try to do, particularly through legislation. My Lords, I am the co-chair of the All-Party Parliamentary Group on Dementia. According to NHS figures, there are 850,000 people living with dementia in the UK, and this figure is set to rise to 1.6 million people by 2040. My Lords, this bill increases the likelihood of a no-deal Brexit. In this scenario, access to new drugs and medicines could be delayed by 12 to 24 months, as the UK would no longer be covered by the European Medicines Agency regulations and instead by a separate UK regulatory system. Also, dementia research that up till now has been carried out collaboratively with researchers and academics in the UK and across Europe could be delayed or undermined if we fail to negotiate a deal with the EU. My Lords, I did not support Brexit, but I accept the referendum result. What I cannot accept, however, is that the government now seeks to breach the terms of the withdrawal agreement with the EU only months after it voluntarily agreed to its terms. Britain is a trading nation, my lords. One of the things that makes us so successful at this is that we're a nation that has a long-standing reputation for respecting the rule of law, including international law. The withdrawal agreement, the reputational damage to the UK that Part 5 of this bill will cause cannot be overstated. A no-deal Brexit and Britain gaining a global reputation as a nation that doesn't stick to international agreements will harm us for many years to come. From an intergenerational fairness perspective, we lawmakers have a duty to do all we can to stop such an outcome. Otherwise, my lords, we risk reducing the prosperity and well-being of those who will live in this country when we have gone. There are many who are critical of the House of Lords and do not believe it makes a useful or important contribution to our democracy. My lords, with this legislation, we have an opportunity to show the nation the value of the second chamber. Further, by opposing Part 5 of this bill, the Lords has the opportunity to show the world that the UK is a country that does indeed respect the rule of law.
Lord Shinquin.
My Lords, imagine this. A foreign power, a trading bloc, is desperate to make an example of a former member state to discourage any others tempted to follow them to freedom. So desperate is this foreign power to protect its empire that since a withdrawal agreement was signed with the former member state, it has issued new threats to the very viability of the former member state's internal market and therefore to its future prosperity and security. In short, the empire cannot afford for the breakaway member state to succeed. It must be seen to fail. My lords, that is the reality this country faces. A reality that I am amazed so many still choose to ignore. Surely, when any UK government realises that the UK is in great danger of being put in a headlock by new threats made since the withdrawal agreement was signed, it is the government's duty to counter the new threats through legislation empowering it to act if necessary. My lords, I hear what some of my noble friends have said about Part 5 of the bill, and I hope they know that while I may beg to differ, I have the utmost respect for them. However, I fear other noble lords' views remain rooted in a refusal to reconcile themselves with the reality of the referendum result to leave the EU. Nothing, it seems, will extinguish the Euro-federalist dream. But, my lords, at a time when coronavirus casts such a dark shadow over so much of our lives, neither should we extinguish hope. Hope for a better future beyond coronavirus, and hope for a return to the growth that will underpin our economic recovery, and with it, the security of the NHS and all that we hold dear. We should not underestimate how much the Eurocrats stand to lose if the British people are allowed to make a success of their lives after Brexit. Their empire will implode. My lords, Brussels can go for broke if it wants to. The United Kingdom must go for growth. Preempting a foreign power's threat to the integrity and viability of our internal market is essential if we want all parts of the UK to benefit from that growth. People will not understand if we fail now to protect them from the very real threat posed to their future well-being and prosperity by a foreign power, the EU, which above all else needs Brexit to be seen to fail. My lords, that means poverty, not prosperity. In conclusion, no government could wish that on their own people, and that is why, for the people's sake, this bill deserves our support.
I now call Lord Desai.
My lords, I do not want to speak of the legal aspects because I'm not a lawyer and the topic has been covered very well. I want to just share with you my curiosity as to what made the government enact this piece of legislation, which, as many have said, is totally away from the normal character of the constitutional behavior of the United Kingdom. And I think some noble lords have referred to this, but let me say this is really arises out of a amnesia, a historical amnesia and a contemporary amnesia, which has struck the party in power. First of all, let me say I was a Remainer, but I have always respected the decision of the people. But notice one thing which not many people have realized, that the decision in the referendum was more or less a decision by England and not by the United Kingdom. Of the 34 million votes cast, 18 for exit and 16 against, 32 million were cast in the English by the English electorate. And the difference in the English electorate, 17 million to 15 million, was exactly the final result margin of 2 million. So Brexit has always been not a UK decision, but an English decision. And I think because the party in power has always been predominantly an English party, that they have now begun to renege on devolution in which they had no part. It was my party which initiated devolution during the Great Blair government, and I think that is now being undermined. What the present party in power did was 100 years ago created the partition of Ireland and the creation of Northern Ireland. At that time, people may remember the behavior of the Conservatives was when they were in opposition against the Liberals and then later on even in a coalition, was almost amounting to subversion of the law and taking and encouraging people in the Northern Ireland region to defy all manner of our laws. Now we have come to a stage when the party in power has almost forgotten Northern Ireland. Boris Johnson inherited this proposition of Brexit. Of course, he supported it. But I don't remember anybody at the time of the referendum or the discussion going on there realizing that the geography of the United Kingdom is not just England, Scotland, and Wales, but there is a region out there, Northern Ireland. And everybody forgot that because Northern Ireland shares a border with the Republic, and because we have signed an international treaty to keep that border open all the time, it was logically and legislatively impossible for Northern Ireland to leave the European Union and also have a free border. That logical and legal impossibility of separation of Northern Ireland from the Republic of Ireland while the Republic stayed within the European Union was not, to my memory, ever discussed. And indeed,
My Lord, can I remind you of the time, please?
I stop.
Lord German.
My Lords, it's a pleasure to follow Lord Desai because I want to talk about the Union of which we are all members. And I want to remind the government that the Union which we now call our United Kingdom is very different from the Union which existed prior to our membership of the European Economic Community, because we've now had more than 20 years of devolution, and this bill threatens the Union as we know it. Many noble lords have already given examples of how it threatens devolution, and I must pay tribute to my noble friend Lord Shipley, who just talked about the health implications, and to Baroness Laura Finlay, who also spoke on this matter. So there are big questions about the Union, and it's these big questions I want to address. So, firstly, do we need this bill now? Well, my lords, I don't think we do, because there is no threat to the internal market at the moment. The common frameworks, which are close to agreement, could be used in their draft form if they're not finally detailed ready. And common frameworks don't even get a mention in this bill, yet for 2 years that work has been going on. Has the government put in place appropriate dispute procedures? No, it has not. The government's engagement with the devolved governments has not given an inch on their involvement. Will this bill weaken devolution in our country? Yes, it will, because this bill produces override and bypass mechanisms which have the effect of reducing devolved powers. Will this bill guarantee high regulatory standards? No, it won't. By creating a system where, if you follow high standards, that'll place you at a competitive disadvantage. And will the bill promote cooperation and trust between the governments of the UK? Well, that's an easy one. No, it will not. Self-evidently no, because of the way this government has shown in their approach to devolution. The evidence is it's managed to bring together 3 very different democratically elected governments in their view that it hasn't been the right thing to do. I want to just mention a few words about Part 6 of this bill. Now, that's the add-on part, because Part 6 of the bill relates to spending, and it's not clear to me how that links to the proposed regulatory structure for the UK internal market, which is the intention of the bill. So perhaps the Minister, in reply, could say why this section is there at all. In answer to me in an oral question in your Lordship's House earlier this year, the government stated that Wales would receive pound for pound what it had previously received from the EU, and that that money would be controlled by the Welsh Government. The question which the bill documentation does not address is whether the government still intends to follow the pound for pound statement as previously made. and that any money proposed to be spent in devolved areas by the UK government is an addition to the former EU funds replacement. I must say, my Lords, that the reference to EU programmes in the impact assessment says to me that the Welsh Government is set to lose control over these funds. As it stands, my Lords, it's very unlikely, almost impossible, to see this bill having the support of all three of the devolved administrations. However, with amendment, there is a very, very slim chance that it could agree with the Welsh Government. So I ask the Government to live up to the agreement it made in July 2017 that a UK internal state aid framework needs to be drawn up cooperatively and consensually between the UK Government and the devolved administrations as equal partners. The Government must avoid actions which could lead to the breakup of this union. But, my Lords, to defend the union, you have to have respect for it. You have to have regard for it. And that's simply not apparent from the way this government is proceeding at this time.
I now call Baroness Meacham.
My Lords, I will keep my remarks brief and try and avoid duplication, difficult at this time of night. But as a member of the Delegated Powers and Regulatory Reform Committee, I must put on record, along with the great majority of the 100 or so speakers today, my deep disquiet that in proposing the bill, our government has shown such disregard both for the international reputation of this country and for one of the most fundamental principles of our democracy, the supremacy of Parliament. I applaud my noble friend, the noble and learned Lord Judge, on his very powerful speech. I agree with every word of it and will certainly be supporting his regret motion. For the sake of Britain's standing in the world, my Lords, I implore the government to ensure that this bill never reaches the statute book unless clauses 44, 45 and 47 are removed from the bill, along with most, I would say, of the Henry VIII clauses, which have absolutely not been adequately justified by the government's memorandum to Parliament on the bill. For the sake of the health of our democracy, I trust that the government will respond positively to the appeal in a letter to Michael Gove and Jacob Rees-Mogg from the chairs of the Constitution Committee, the Delegated Powers and Regulatory Reform Committee and the Secondary Legislation Committee. The letter sets out the considerable concerns of the members of all those three committees about the truly extraordinary delegation of powers to ministers in recent bills. It's not just this one, but this one, the Internal Markets Bill, is undoubtedly the most extreme and the most troubling example of this trend. Finally, I call on the government to respect the conclusion of the Strathclyde review of the role of the House of Lords in relation to statutory instruments. The review made clear, and I quote, that it would be appropriate for the government to take steps to ensure that bills contain an appropriate level of detail and that too much is not left for implementation by statutory instruments. Does the government really want to completely disregard a report commissioned by a recent Conservative government? Lord Strathclyde, I believe, would want your Lordship's House to challenge the exceptionally pervasive use of Henry VIII clauses in this bill, and indeed the terrible clauses 44, 45 and 47. And I hope very much that we can do this on a cross-party basis.
I now call Lord Lee of Crondall.
My Lords, I was, like many members, horrified when I saw this bill. I was for many years on an EU committee on benchmarking, and in those days, people had to get used to the idea that if we get best practice in Europe, it's for the good of us all. And the slogan that we worked out in the trade unions, Jacques Delors and all that, those days, it was something like, Europe is the league we are in. Now, Britain will go nowhere but backwards if we get out. And although we have accepted that there has been a referendum result, we are now going to make the situation far more adverse to our employment and investment prospects. Multinationals, I went to a meeting a couple of years ago, they say their investment forecast was going down for Britain, even then, and now it's going down very, very much more than 50% for many, many industries. And the idea that we can, as it were, complain about the 26 countries together wanting to stick with their standards rather than say, oh, well, Britain wants to change in a negotiation between equals and we will change all our standards. Well, it's so unrealistic. And to hear colleagues here thinking that there is some, as it were, sensible, rational motivation for this bill, when I can only imagine that it was some late night conversation in number 10 Downing Street, this Conservative Party element which really wants to get back to the heyday of Boris Johnson by doing something a bit more dashing about this and tearing up this aspect of the Good Friday Agreement because some people have never liked it and so on. Whereas, of course, as far as the Irish question is concerned, it is the Good Friday Agreement, which has been a great contributor to peace, and it implies a certain degree of a condominium, if you like, between aspects of the life in Northern Ireland and dotted line to London and a dotted line to Dublin. Now, if that is the issue lurking behind this, it is historically such a ludicrous way for the tail to be wagging the dog. Also, if we do go down this track now, it means that there's a big question mark about whether we could in fact have what they call third nation status with the WTO, because part of the United Kingdom, Northern Ireland, would have to have one foot in the joint arrangements with Dublin in the Good Friday Agreement and another foot in the United Kingdom. So it's hard to think that we would be a normal third nation. And I think that there should, before the lorries all queue up at Dover on December the 31st, start to think about how we are going to get away from this ridiculous apotheosis of the Boris Johnson idea of the world and see what in fact we can do. And I think we need a framework agreement, not just for the British Isles and so on, but a framework agreement such as Switzerland at least has with the European Union. It's not my ideal, but we cannot simply commit hara-kiri the way we're going at the moment.
Lord Floyd.
My Lords, the justification for this bill is to support and advance trade and also, as pointed out, to provide insurance against present negotiations breaking down. The existing internal market is supported by EU law until the end of the year, where this bill provides for UK law to take over. This is a detailed bill which provides for what I call single market membership in respect of our trade with the rest of the EU, and if we reach agreement with the EU to this end. The question is raised as to what happens if trade negotiations break down and the UK opts for WTO, where it looks unfortunately likely from the Prime Minister's comments yesterday that this may well be the case. It is clear, I'm afraid, that the EU has been acting in bad faith in the trade negotiations, which, as the PM has pointed out, involve a requirement to lead and not a requirement to lead to a breakdown. Presumably, we could amend and use the bill as we saw fit. We would, however, have a self-interest to make the bill as helpful as possible to European importers and exporters to help optimise our trade. And as we are leading historic trade free trade supporters, I'm sure we would be happy to be driven by the free trade principles of mutual recognition and non-discrimination. As for the bill, will become an act as of 31st of December, assuming it passes both chambers of this House, and whether or not we do a trade formula deal with the EU, this trade legislation will be on the statute books and operative to ensure smooth functioning of trade. Turning to the controversy, it was the UK government which found out that the EU was seeking to misuse aspects of the Northern Ireland Protocol in a way which was not intended and in order to gain advantage in the future relationship negotiations. I'm somewhat disappointed that no one seems to have made this point, and the whole problem with Clause 5 arises from that. And it was for this reason that the UK government created the safety net of clauses 44 and 45 to give British ministers the power to unilaterally interpret, modify or disapply parts of the Northern Ireland Protocol. The UK has agreed to require parliamentary approval of any government initiatives involved here. I think this is clause 56. I was always told as a student that there was really no such thing as international law, as there was no agreed single court of law to monitor it. But in this situation, I'm inclined to the view that it may be better to get rid of clauses 5 and 6 and to address the issues that have been raised in another way. I remain a staunch supporter of free trade and appreciate the major contribution to upholding free trade afforded by the Internal Market Bill. But it does have the weakness of underpinning oligopoly. Most of the trading requirements as witnessed by this legislation are too detailed, too difficult, too expensive and demanding for smaller businesses to find it worth complying.
My Lords, Baroness Gowdy has withdrawn from the debate, so I now call Lord Palmer of Charles Hill.
My Lords, it appears that Brexit will not only have queues of trucks on roads leading to the Channel ports, it will apparently lead to an expected plethora of disputes in the internal market between parts of the UK. This bill, by its very existence, acknowledges the divisive self-harm which has been inflicted on our nations by this clueless government. We already have the Common Frameworks Programme so well detailed by my noble friend, Lord Jermyn, and this commitment to collaboration in a regulatory manner. So I do not see how this bill in any way helps or adds to the resolution of disputes in the functioning of the single market. The latest proposed Quango, the Office for the Internal Market, is purely to have a role in providing independent advice on dispute resolution. But we already have the Competition and Markets Authority, which has become a very large body in its own right. It will now also include the Office of the Internal Market, an added and expensive creation. It appears in the current crisis in health, business and employment, the only growth industry is an expanding civil service. Sir Humphrey Appleby of Westminster would have been proud of it. An article in the Times today suggests there is one civil servant for every 152 citizens, not counting employees of arm's length bodies. This bill moves us nearer to the doubtful utopia of a civil servant for each and every citizen. We can see at this very moment in the COVID pandemic how there are divergent policies between Scotland, Wales, Northern Ireland and England. Can the Minister state clearly whether in the case of a dispute not being solved after the valued advice of the latest Quango, whether it will be the UK Minister who will make the decision? If so, that is a sure way to build up resentment in the devolved administrations. Surely a more collaborative arrangement is required between the devolved parts of the United Kingdom. My Lords, this brings us back to the Common Frameworks programme, detailed, as I said, by my noble friend Lord Jermyn. There is no doubt that the advanced development of common frameworks has been complicated by the bill before us today. The bill aims for a draconian, even dictatorial power to ensure that sales in one part of the UK will be acceptable in all other parts. This may be the desired result for some people under any arrangement, but it may not be the desired result in one of the devolved nations. What I require from the Minister to explain is how the bill and the common frameworks are to function at the same time. My Lords, this bill is unnecessary and could well be very harmful. My Lords, we should do all in our power to defeat this bill in its current form.
Lord Woolley of Woodford has withdrawn from the debate, so I now call Lord Naseby.
My Lords, after 46 years in Parliament and 5 as Deputy Speaker, I am no lawyer, but frankly, my faith was somewhat shattered in the law when a decision went against the government on the autumn adjournments, which seemed to me to be perfectly in order in parliamentary terms, and which when we normally adjourn to party conferences. Having said this, I've got 3 aspects that do concern me. Firstly, obviously I'm concerned about the regret notion, and I recognise that my Lord Judge is sitting here in the chamber. And if it is, as he says, we are undermining international agreement, and particularly Part 5, and it appears that we are repudiating part of an international treaty which we've negotiated and we in this House have signed up to, then I am concerned. But I then listened to a colleague, Lord Howard of Rising. I did have a copy of Lord Pannick's statement, and as I understand it, and I'm now quoting, if therefore the UK and the EU were unable to reach an agreement on Northern Ireland, despite good faith negotiation and despite the arbitration procedures, and if the UK were therefore to be faced against its will with a permanent backstop arrangement, the UK would be entitled to terminate the withdrawal agreement under Article 62 of the Vienna Convention on the Law of Treaties. So therein, maybe, is where the answer may lie. Secondly, I am concerned about the Union with the devolved assemblies of Wales, Scotland and Northern Ireland, and I take a particular concern about Scotland. So there must be nothing in this bill that makes it easier for Scotland to be difficult. Sadly, there is, and I am indebted to the Delegated Powers and Regulatory Reform Committee, who highlight the problems of how the consultation and the dispute processes would actually work. Thirdly, and I'm not sure anybody's actually mentioned this, thirdly, there's the Office of the Internal Market as part of the Competition and Markets Authority. Even here, the portents are not good, because the CMA is regularly criticised for its poor performance, recently over bank reforms and sport monopolies. So this, my Lords, is a bill fraught with difficulty, not least the reputation of the UK internationally, so vital for our future trading internationally. So I shall listen with particular care to my noble friend on the front bench, with whom I have great faith. And I hope he will be able to address the legal point, and as Lord Pannick has said, that Lord Panic is correct, and if he is, then I will be, with my support, I shall be voting in the lobby for the government.
I call Lord Judd.
My Lords, we've heard two interesting maiden speeches today. I warmly welcome my Cumbrian neighbour, Baroness Hayman of Bullock. What she said about the environment was not only right, but very important. We look forward to hearing much more of her in the years ahead. I record my appreciation of the forthright clarity of the reports of the Delegated Powers and Regulated Reform Committee, the Constitution Committee, that was the chairs jointly of the Constitution and the European Union committees, and indeed the brief from the greatly respected Bingham Centre. Just what are the principal inescapable mega issues confronting us all in the UK? Climate change, migration, pandemics, conflict, limited natural resources, the biodiversity crisis, pollution, destruction of the natural environment, terrorism, international crime. All these require multinational cooperation. Not one can be dealt with effectively by the UK on its own. This requires trust and discipline, hence the indispensability of the rule of law to underpin that essential cooperation. The UK has in the past been respected as a pioneer in the rule of law. What will the ideological, blinkered and visionless proposals in this bill do to the respect and esteem which has been won for the UK by its principled leadership? What signals will they send to Russia, China, Belarus, Burma and Latin America? No, my lords, this bill is indeed a disaster. More immediately in the UK, the stability and trust which has been central to the cause of peace building in Ireland is potentially jeopardized. The Good Friday Agreement and the Protocol are not just words to be cynically played with, they are crucial. What is proposed in this bill could threaten that peace and stability which has been so painstakingly and imaginatively built. It is time, my lords, to say enough. Security demands a more principled and enlightened commitment. How I welcome the reasoned amendment by the noble and learned Lord Judge. My lords, I also totally endorse the arguments of the noble Lord Butler on any forthcoming ping-pong experience. And my lords, devolution, the same ideological zeal to recenter control in Number 10 crudely challenges all the progress and success so far in constructively building towards the new constitutional settlement achievements for Scotland, Wales and Northern Ireland. My lords, we must beware of the future peaceful, we must beware for the future peaceful stability of the UK itself. The lowest common denominator becomes the reality. On a practical level, what of the lead given by England in the provision to help curb death from cigarettes and tobacco? What of the legislation in Scotland on alcohol pricing? What are the spring water and bottled water standards established in Wales? What prospects now for them that they can be part of a firm base from which to develop civilized policy for the future? My lords, we can now see starkly what take control really meant. Control for an ideologically ruthless Number 10. It is high time for us to make a firm stand.
I call Lord Bhatia.
My lords, there is a definite need to give unfettered access for Northern Ireland goods to the UK internal market. The Withdrawal Agreement Protocol creates a unique status for Northern Ireland and remains part of the UK's customs territory and will continue to apply the EU's customs code, VAT rules and single market rules for goods after the transition period ends on 31st December 2020. My lords, after the transition period, these provisions can rightly continue to apply with the consent of the Northern Ireland Assembly. Nothing in this protocol shall prevent the UK from ensuring unfettered market access for goods moving from Northern Ireland to other parts of the UK's internal market. My Lords, the UK government is committed to having legislation to guarantee unfettered access for Northern Ireland businesses to the whole of the UK market in place by 1st January 2021. This commitment was made in January 2020 to restore devolved government in Northern Ireland 2020. My Lords, we cannot break this commitment. UK's reputation will be severely damaged. We are respected internationally, not to break commitments made by us in law. Thank you.
Lord James of Blackheath has withdrawn, so I now call Lord Billy Moria.
My Lords, the UK internal market operates across England, Scotland, Wales and Northern Ireland and is this economic glue that binds our four nations. It is key to help increase prosperity, raise living standards and opportunities for people and businesses across all parts of the UK. The internal market is critical to maintain attractiveness to foreign investment across the UK and to maximise opportunities from new trade deals. Firms across the UK have operated with the devolution settlement for more than 20 years. What the UK Internal Market Bill must do is provide certainty that products made in one part of the UK will not face additional barriers to market in another part of the UK, and with this ensure consumers in one part of the UK are not disadvantaged by limiting access to goods and services. The UK is a highly integrated market, and for the internal market to continue to operate effectively, firms across the UK have been clear that there are three guiding principles that must guide its implementation. 1, no new barriers to trade. 2, collaboration across the UK. 3, fair, independent and trusted adjudication. My Lords, the CBI, of which I'm president, welcome the government's plans to give powers to the CMA, the Competition Markets Authority, to establish the Office of the Internal Market, which will also have the responsibility to report to devolved parliaments and administrations. And where Northern Ireland's concerned, a free trade deal with the EU would minimise the need for strict controls on a range of goods entering Northern Ireland from the rest of the UK, bolstering the Northern Ireland Protocol, maintaining the integrity of the UK internal market and respecting the all-island Irish economy. The UK Internal Market Bill must work in lockstep with the implementation and operation of the Northern Ireland Protocol. England, Scotland and Wales, that's Great Britain, is Northern Ireland's biggest market for external sales, with the GB market larger than all export sales combined. Over 7,000 businesses in Northern Ireland rely on the GB market, which is worth over £11 billion annually. And for this to work effectively, the UK Internal Market Bill must work in lockstep with the Northern Ireland Protocol and respect the all-island economy between Northern Ireland and the Republic of Ireland. Firms in Northern Ireland have always been clear that they want to see the protocol work. And in respect of trade flows from Northern Ireland to Great Britain, the protocol provides that nothing in the protocol shall prevent unfettered access to the GB market for trade in goods. My Lords, on the 16th of October, Lord Kinnoul, the chair of the EU Committee, and Baroness Taylor-Bolton, the chair of the Constitution Committee, wrote in the Times that it's clear that the Internal Market Bill authorises, I'm quoting them, violations of the UK's obligation in international law, setting out explicitly to break international law in this way is unprecedented, and this undermines the rule of law. The bill also risks destabilising devolution arrangements when it's never been more important for central and involved governments to work together effectively, close quotes. And of course, today we had the bishops, the UK's five most senior Anglican churchmen, join forces to denounce the government's new legislation, claiming the Internal Market Bill, and I quote, could set a disastrous precedent. My Lords, across the UK, firms are clear that the UK internal market is an essential aspect of how they operate their business. And yesterday, the CBI and 71 trade associations and professional bodies representing 190,000 businesses and 7 million employees called for politicians on both sides to carve a path towards a deal. Sectors from automotive, aviation, to chemicals, to creative industries, farming, food and pharmaceuticals are united. Securing a quick agreement matters greatly for jobs and livelihoods. Clarity on an ambitious deal would turbocharge business preparations, increase confidence in the UK as a place to invest, and help to ease the sustainable implementation of the Northern Ireland Protocol. It follows an intervention earlier this week by leading European businesses from France, Germany, and Italy calling for a solution. Now is the time for historical political leadership. After 4 years of debate, there must be resolution. 2021 can then be a year to rebuild rather than regret.
My Lords, I beg to move the debate be adjourned until tomorrow.
The question is that this debate be now adjourned until tomorrow. As many as are of that opinion will say content. To the contrary, not content. The contents have it.
My Lords, I beg to move that we do now adjourn.
That the House do now adjourn.
The proceeding has ended. 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 The proceeding has ended.